So, welcome everybody to the third hearing for the inquiry into the integrity of the New South Wales Biodiversity Offsets Scheme. The inquiry is examining a range of issues, including the effectiveness of the scheme to halt or reverse the loss of biodiversity, the administration and regulation of the scheme, and the use of offsets for major projects. Before I commence, I'd like to acknowledge the Gadigal people of the Eora Nation, who are the traditional custodians of the land on which the Parliament sits. I also acknowledge the traditional owners of the lands from which all meeting participants join us today. I pay my respect to the elders past, present and emerging, and extend that respect to all Aboriginal people watching. Before we commence, I'd like to make some brief comments about the procedures for today's hearing. Today's hearing is being held virtually and in person and is being broadcast via the Parliament's website. A transcript of today's hearing will be placed on the committee's website when it becomes available. In accordance with the broadcasting guidelines, media representatives are reminded that they must take responsibility for what they publish about the committee's proceedings. While parliamentary privilege applies to witnesses giving evidence today, it does not apply to what witnesses say outside of their evidence at the hearing. I therefore urge witnesses to be careful about comments you may make to the media or to others after you complete your evidence. Committee hearings are not intended to provide a forum for people to make adverse reflections about others under the protection of parliamentary privilege. In that regard, it is important that witnesses focus on the issues raised by the inquiry terms of reference and avoid naming individuals unnecessarily. All witnesses have a right to procedural fairness according to the Procedural Fairness Resolution adopted by the House in 2018. There may be some questions that a witness can only answer if they had more time or with certain documents to hand. In these circumstances, witnesses are advised that they can take a question on notice and provide an answer within 21 days of receipt of the transcript. Finally, a few notes on hearing etiquette to minimise disruptions and assist our Hansard reporters. Can I ask committee members to clearly identify who questions are directed to, and could I ask everyone to please state their name when they begin speaking? Could everyone please mute their microphones when they're not speaking? And members and witnesses should avoid speaking over each other so we can all be heard clearly. So I now welcome our first witness. If we could please start with, if all of you could please state your name and position title and swear either an oath or an affirmation. And I will start with you, Mr. Scott Phillips, and then go down in order of the hearing schedule. So Mr. Phillips. Can you hear me, Mr. Phillips? I think you might be on mute if you haven't unmuted yet.
You got me now?
Yeah, we've got you now.
Okay, apologies with the microphone. Good morning, Scott Phillips, Chief Executive, Local Government, New South Wales. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you, Mr. Phillips. Ms. Senadese, is it?
Yes, Susie Senadese. I am Strategy Manager Environment at Local Government New South Wales. And I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you very much. Mr. Stephen Peart.
Hi, Stephen Peart. I'm the Group Manager for Development Services at Port Stephens Council. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you. Mrs. Kimberly Baker.
Kimberly Baker, Environmental Planner for Port Stephens Council. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much. Mrs. Marianne Crawford.
Thank you, Madam Chair. Marianne Crawford, Manager of Development Environmental Services at Singleton Council. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. And finally, Mr. Ziggy Andersons.
Ziggy Andersons, Coordinator of Environmental Services at Singleton Council. And I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much. And now I assume that each council will be making an opening statement by one person. Mr. Phillips, you're nodding. We'll start with Local Government New South Wales. Is that yourself? giving an opening statement, Mr. Phillips? Or is it Ms. Senadisi? I think you might be on mute, are you? Can you hear me, Mr. Phillips? No, we might move to the next. Yeah, I'm just going to move to the Port Stephens Council for now. Who is providing that opening statement?
Kimberly Baker, Port Stephens Council.
Thank you.
Thank you for the opportunity to address the committee today and discuss our submission made on the inquiry into the biodiversity offset scheme. My name is Kimberly Baker, Environmental Planner for Port Stephens Council. I'm also a BAM accredited assessor, and with me today is Stephen Pert, our Development Services Group Manager. Port Stephens is an internationally recognised tourist destination focused around the region's unique biodiversity values and our famous local koala population. Recent community surveys also identified the natural environment as an important asset to our community, with a specific focus on the local koala population as well. Port Stephens Council was the first council in New South Wales to prepare and adopt a comprehensive koala plan of management under the then SEP 44 in 2002, which is still active today. Our local government in the area contains a variety of sensitive ecological values and biodiversity assets, which are often managed and assessed through the biodiversity offset scheme. In assessing developments subject to the BOS, Council has observed that the scheme is generally effective. The Avoid, Minimise and Offset hierarchy of the Biodiversity Conservation Act 2016 provides a powerful framework for ensuring that important biodiversity values of the site are first protected locally before then being offset. The other strength of the BC Act is having defined thresholds that trigger development into the BOS, and these two aspects make the scheme more effective than the previous provisions under the TSC Act. Although Council is supportive of the BOS, we have also observed that there are several inadequacies with the offset scheme. We've focused our submission on three major items which we're predominantly concerned about. Firstly, the BOS does not require species credit species to be offset locally. This is particularly problematic for Port Stephens Council in managing its local koala population, as important koala habitat for species credit species can be offset anywhere in the state. This general approach to the BOS to manage threatened species at a statewide scale does not align with the objectives of the New South Wales Koala SEPT to support a permanent free-living population of koalas over their present range. This issue could be resolved by requiring species credit species offsets for koalas to be secured locally or within the LGA. This approach could provide better alignment with the New South Wales Koala SEPT and our comprehensive koala plan management, and reduce requirements for double offsetting. Secondly, issues have been identified with regards to the streamlined assessment module of the biodiversity assessment method, or the BAM. This part of the BAM prescribes that when a streamlined biodiversity development assessment report can be prepared, the requirements of that report. Currently, streamlined BDAs are not available to be prepared for biodiversity value mapped areas that consist of core koala habitat. Within our LGA, core koala habitat is often mapped as occurring in small pockets across urban and peri-urban areas, particularly within areas zoned large lot residential or R5. We have observed several instances where the interaction between small-scale development and the ability to use streamlined assessment module has led to disproportionate financial and time burdens for families seeking to build a home. It is our recommendation that the inquiry investigate the opportunity to allow for the use of streamlined BDAs for areas of core koala habitat, particularly within residentially zoned land, by adding in koalas as a species credit species. We also recommend that the inquiry review the streamlined assessment module to ensure that it provides a robust assessment of all predicted species. Lastly, Council has observed the extensive clearing of vegetation on rural zoned lands prior to lodgement of rezoning or development applications, presumably to avoid triggering BOS clearing thresholds or to reduce the residual offsetting obligations of the project. These clearing actions are often undertaken on land with no agricultural operations under the proviso of allowable activities under the Local Land Services Act 2013. There is an opportunity for the New South Wales Government to provide support and guidance to councils by amending the Local Land Services Act 2013 or providing a more clear pathway to limit vegetation loss on development lots and to strengthen the compliance provisions available within the LLS Act and the Biodiversity Conservation Act. Thank you again for considering our submission and for the opportunity to address the committee today.
Thank you very much, Mrs. Baker. That was a very good opening submission. We'll go to opening statement, We'll go to Mr. Phillips now, who I think has rejoined us for your opening statement. Mr. Phillips.
Good morning and apologies for cutting out there. Danish Wi-Fi is not as secure as I was hoping.
Mr. Phillips, you're very faint. Is there anything you can do about your volume? Yeah, maybe moving. You've got your headphone on, but maybe just moving closer to the microphone on your computer, which
Does that look at all?
Yeah, that's better. It's what's picking up your voice is the computer. Yeah.
Okay.
Much better. Thank you.
Yeah, apologies again for cutting out. Danish Wi-Fi is not as secure as I hoped. Thank you for inviting Local Government New South Wales to address the committee in relation to our submission. As you would be aware, local government has an essential role in contributing to biodiversity conservation, including through planning and approval processes, community education and engagement activities, and as public land managers. At the outset, let me put on the record that local government supports the conservation of biodiversity and supports the biodiversity offset scheme in principle. In saying that, however, the scheme requires changes to improve its functioning and outcomes. Councils have expressed a concern that biodiversity offsets are not leading to net improvements in biodiversity. In particular, there are concerns in relation to biodiversity loss in rural areas of New South Wales, where the interaction of the scheme and other vegetation management frameworks are inconsistent or unclear. Structural problems with the system include differences in rural versus urban application and outcomes, lack of defined thresholds, for example, for serious and irreversible impacts, and no ability to link offsets to the same region that is experiencing impacts. From an administrative perspective, councils have identified difficulties with the scheme, such as an incomplete mapping or guidelines, and poor understanding of the scheme by proponents and the wider community. So our submission makes quite a number of recommendations to address these issues and to improve how the scheme operates. Our more fundamental recommendations call for greater focus on applying the avoid and minimise principles before offset, greater emphasis on requiring like-for-like offsets, offsets to be procured locally wherever possible, improvements to the scheme and broader land management framework to prevent incremental clearing, more concerted efforts on scheme education and on compliance and enforcement in relation to accredited assessors, and greater support to encourage the establishment of stewardship sites, or the credit supply as it's often referred to. Thank you again for this opportunity to discuss Local Government New South Wales recommendations and the possible pathways towards improving the functionality and outcomes of the biodiversity offset scheme.
Thank you very much for that, Mr. Phillips. And we'll finally go to Singleton Council. And who's giving that opening statement?
Thank you, Madam Chair. That will be myself today, Marion Crawford. Thank you for the opportunity to make a statement today. The Singleton local government area includes 181,779 hectares of national parks and state forests and comprises 92,302 hectares of coal mining leases and exploration licences, making it one of the largest state significant mining areas in New South Wales. The known area of map biodiversity offsets in the Singleton LGA is approximately 16,000 hectares, or 3.28%. 6% of the land in the LGA comprises vegetation that is classified as being endangered ecological communities. In 2020, Singleton Council adopted its local strategic planning statement. This statement set the strategic policy positions regarding biodiversity in the LGA. Council's policy outcomes are to advocate for significant local biodiversity corridors and to ensure that where development of land is likely to disturb or harm biodiversity, adequate justification will be required, including the consideration of alternative options. Council's assessment of the effectiveness of the scheme is made in consideration of these policy positions. Whilst Council is supportive of the scheme, there are ways in which the scheme does not align with the outcomes in our adopted LSPS. Today, I would like to highlight two of those. Firstly, the most important misalignment is the application of the serious and irreversible impact refusal provisions, which are crucial to the long-term viability of many at-risk species and communities. These provisions only apply to local development and not to major projects, infrastructure or agriculture. Consideration of serious and irreversible impacts should form part of the assessment process for all development types. In that regard, cumulative impact of biodiversity offsetting is often left to Council to impose on its community, as the assessment process, in particular for major projects, constrains those impacts to the individual project level. Mapping of offsets within an LGA and providing public access and scrutiny to offset outcomes would improve the concerns around the cumulative effects of multiple projects within a locality. Secondly, strategically locating offsets in areas of biodiversity importance within known biodiversity corridors provides positive biodiversity outcomes. Where offsets are not strategically located, or as is the case in Singleton, are concentrated within a region, the consequences on biodiversity and strategic land use planning outcomes can be quite significant. Finally, Council also raised concerns regarding like-for-like rules, credit pricing, consistency in the application, particularly between local and the Department of Planning, and transparency of the scheme across all development types in the submission that we made to the inquiry. These concerns are consistent with those that have been raised here this morning by Local Government New South Wales and Port Stephens Council. Again, I would like to thank you for your time in making this submission today.
Thank you very much, Mrs. Crawford. Now we'll go to questions starting with the opposition. Ms. Penny-Sharp.
Thanks very much, and thanks everyone for your submissions. They're extremely helpful. Mr. Phillips, I might go to you first. Thank you for the work that you did bringing all those councils together. There's some very clear themes emerging, but also those real regional differences in terms of the way the system is operating. My first question was, and I don't know whether you know the answer to this, do we have any data on the number of sites, well, I suppose it's DA applications where, in terms of the hierarchy, there's avoidance, then there's mitigation, then there's offsetting. Is that broken down either council by council, or do you have a sort of a overview of that?
Thank you for the question. Unfortunately, no, I don't. I'd be happy to take the question on notice and provide any data that may be available to assist the committee.
Yes, thank you. I mean, it goes to this issue of, you know, the system being about no net loss, and most of the local councils have raised the issue that they're not at all convinced that there is no net loss. In fact, it seems like there is accelerating loss with a lot of gaps, with some good outcomes at the end. So no, that would be very helpful, and I would appreciate that. I just also wanted to say thank you for the list of suggestions. I mean, these are pretty much, you've summarised almost all of the submissions that we've had to this inquiry in terms of the issues that are there. And so, you know, I'm not going to ask you a lot about them because I think they're actually pretty self-evident, and I just wanted to appreciate that. I did want to ask, though, and this might be for the other councils as well. I mean, obviously, Port Stephens, the peri-urban development cost of land issue is massive, and Singleton clearly has the mining issue. Perhaps this is one, I'll start with you first, Mr. Phillips. It's that interaction between the LLS land clearing laws and biodiversity offsetting in those kind of regional areas. Can you just take us through the issues that councils are raising about that?
Thank you. Yes, I can. Councils are particularly concerned that the scheme's resulting in a loss of biodiversity in their own local area. We're finding that's often the case in coastal areas where there's quite considerable development pressure, and there are less offset credits currently available for purchase in those areas where there's limited potential for stewardship sites to be established. So it really depends on the LGA, but quite considerable pressures in a number of those council areas.
Yeah, I might go to Port Stephens. Do you just want to comment about that? Obviously, you've got a lot of development pressure, not a lot of land available. Look, obviously, koalas are a big issue in Port Stephens. Can you just sort of take us through, I suppose, as you're assessing what's coming through, where are you really struggling to try and find local sites, and what are is it because land's too expensive?
I can talk a bit to the pressures in our LGA. You know, koala habitat is co-located on the urban fringe quite a lot, and it's difficult to balance the offsetting on the site with and in the locality with balancing development. The real issue we're having is the interactions with like the LLS Act, as you asked of Steve previously. Yeah,
tell me, can you give us a couple of practical examples of where you're seeing that and what that looks like?
Yep, so we've got two types of protections we're seeing there with the LLS Act. Unsafe, for example, is residentially zoned land. There's several lots. They've been in consultation with council about planning proposal to rezone that land, rural land, rezoning that to residential land. They've now used the land clearing codes to go and clear 12 metres on each side of their property and then degrade that habitat under the proviso of agricultural activities. But that land isn't actually used for agricultural activities, it's used for residential already.
And so, just to be clear, I mean, so there's no one monitoring that, is there? Essentially, they can say, look, we're zoned rural, we're clearing on 12 metres on each side of the fence, we're allowed to do that under the code, even though there's actually there's no agricultural actual taking, they're really just preparing for residential upzoning. Is that?
Correct, that's how it would appear, yeah.
But again, but council has no mechanism to do anything about that, do you?
So compliance on rural zone land sits with local land services, and council only has compliance control over residentially zoned land.
That's right.
And non-rural zone lands.
And have you raised that with LLS? I mean, obviously you meet regularly about a whole range of land management issues. Surely they're aware of that. Are you aware of A, have you raised it with them, and B, what's been the response?
We've discussed it with them in an open meeting once, and we had the opportunity to meet our local officers. However, I think that perhaps there was a little misunderstanding between what their action is between what might be perceived as development in the future, because their argument was, well, it's not development now. That clearing purpose was not to facilitate development, and that they considered that because it's rural zone land and there was like a couple of sheep or goats or something on that property, that it was considered to be an existing agricultural activity. But in our opinion, that land wasn't actually being used for a commercial or agricultural activity. It was for residential purposes. I guess there was a bit of a disagreement in that regard. We've seen, for another example, there's rural zone land outside of that urban interface, and there was a case where the proponent had come to council in a pre-lodgement meeting to build a structure that needed a DA consent. They then went away and got a land clearing permit from LLS to clear that portion of the land that was BD mapped, or would have been over the clearing threshold, to then clear that land under the land clearing code, the permission from LLS, And then they came back to council and then lodged a DA for that infrastructure in the same footprint that LLS had then allowed them to clear. So they essentially avoided triggering a BEDA and offsetting through the boss by going through LLS. And when we contacted LLS to ask what was the context of their approval, they said that he said he was just clearing for grazing. He mentioned he may be expanding his other activity, but the LLS said that could happen in 5 years, 2 years, 12 months, 3 months. They weren't able to take that into consideration in their assessment at that time. So they just had to assess it on face value, which was cattle grazing.
Great, thank you. I think one of my colleagues has got a question.
Yeah, thank you. I'll just, and just for Hansard's purposes, because there's a lot of acronyms in this business, BDAR again is, can you?
Yep, Biodiversity Development Assessment.
What, the assessment report, the R? Yes. Yeah. All right. Thank you. I'll just go to Ms Cusack from the government.
Thank you very much. And look, I also have some questions for Port Stephens Council, being a bit familiar with some of the issues, and thank you for your submission. And thank you particularly for focusing on wildlife, because the habitat that we're trying to protect is, of course, for wildlife. And I think that's something that we do need to focus on in the inquiry. You've kind of made the link that that protecting species such as koala involves local action, and that to look at statewide or sort of offsets that extend well away from the location of the development is going against that sort of, but it also doesn't align with the concept of koala management plans, which is about having local strategies. So my first question relates to in 2017, I know the Threatened Species Council made a preliminary determination that Port Stephens koalas were endangered. Then I'm sorry to bring this up, but I think this goes to the heart of the issue that you're bringing before the committee. Then a decision was made that we're not going to have local species being defined as endangered. It's going to be all on a statewide basis. I just wonder if you could comment on that having an impact in relation to Council's capacity to protect habitat.
Yes, thank you. I can make a comment on that. So I think, are you talking in regards to an endangered population listing?
Correct. So it was headed for that listing, but then the methodology changed and they decided not to list local populations anymore. And I suppose the evidence that I'd love to hear is that it would have been beneficial to Port Stephens koalas if they had have been able to get that listing. Not putting words in your mouth.
Yeah, thank you. I agree that it is a shame that Port Stephens koala population wasn't listed as an endangered population under the TSC Act then. I understand from the determinations that and the findings that I've been exposed to that it would have been a successful listing had the change in legislation not have gone through at that specific time. But unfortunately, because the BC Act commenced and the determination wasn't made before that, it didn't.
So would you say that the previous methodology that did permit local listings was better aligned with the concept of local management of threatened species?
Yeah, yep. I think that's definitely a valid finding. Yep.
Coming back to the Koala SEP 2021, that, as I understand it, is a document that's still a work in progress while people discuss what the final guidelines will be. But Koala SEP 2021 has been finalised, but it only applies to metropolitan areas. The Koala SEP 2020 still applies to Port Stephens Council, is my understanding. So that means that only 10 species of feed trees for koalas can be. Do you have other species of trees that would have been protected had the list of 123 species been adopted?
So the koala SEPs, they have a provision in there that allows our CK POM, which was approved under SEP 44, to remain active. And under our CK POM, we only have 3 koala feed tree species. The SEP basically is it becomes our CK POM in our LGA. So our LGA only has 3 koala feed tree species, but I agree that the new SEPs have the 120 is much more powerful and more relevant to our LGA. And yeah,
so if the 2021 SEP that was adopted for Sydney and certain areas around Sydney, like Blue Mountains area, if that was adopted in Port Stephens, if that had been applied to Port Stephens Council, would that have resolved many of the issues that you've raised with us today?
Perhaps not, because we've still got our CK pond that works under SEP 44. So the SEP 2020 and 21 essentially doesn't change the way we work in Port Stephens.
And the principal issue relates to rural zoned land. That is, the owners would be looking at urban development, which was actually the land that everybody seemed to agree that we would be protecting. Okay, thank you. Thank you, Madam Chair.
Thank you. I might just move to questions to, there's a couple of questions to Singleton Council firstly. Mrs Crawford, in your opening statement, you said that the situation with offsets in your area is that they're kind of all occurring in the one place or in the region. Could you just explain what you mean by that and what that area is?
Thank you, Madam Chair. Yes, the situation in Singleton is that a majority of our offsets are not locally acquired offsets. They're generally acquired through the major projects state significant development planning process, which kind of puts council at a little bit of arm's length around the selection and location of offsets through that process. Quite often they can be opportunistically, I guess, secured rather than strategically secured. One of the things that we have identified within our local planning provisions is the need for us to be a little clearer around what biodiversity corridors, in particular significant biodiversity corridors, might be in our local government area, and that's a body of work that we're working through at the moment. The concern that we have around that is the relationship between that local planning outcome for biodiversity, I guess, benefit versus the way in which the Department of Planning may apply conditions of approval or an applicant themselves may seek offsets well in advance of their development or outside that local planning provision process.
Yeah, thank you. So Singleton is massively impacted by open cut coal mining, of course, and this is probably much of the major projects that you're talking about. So what involvement then do you have with planning when various mine applications and extensions kind of go through with these offsets? I think you were just indicating then that you don't have, there's not much of a relationship there, is there?
Oh, sorry, please don't misunderstand. We do have a relationship, and a very good relationship, with the Department of Planning in the way in which we work collaboratively together in the, I guess, approval process for major projects. But we're not a regulatory authority in that process. So we really just provide an advisory function, as does any council into state significant development. So the concern for us, I suppose, is the extent to which that advice may be taken on board. And we've certainly been doing a lot of work with the Department of Planning over recent times to, I guess, promote the need for us to be able to have a greater voice around particularly biodiversity offsetting and other land use planning outcomes that are a result of major projects in the LGA. Sorry, I didn't mean to mislead in relation to that.
No, that's good. Thank you. We heard yesterday about quite a significant situation in relation to offsetting mines with offsetting the clearing that will take place within a particular mine with the rehabilitation of that mine or another mine. Is that an area that the council has concerns about, that the fact that the mine can clear habitat and it might not be, we know that the life of a mine, can be 40 years, and that some of the offset is around some potential future rehabilitation of that mine?
In our submission, we did raise a concern in relation to the timing for when offsets can be provided, particularly under the major projects approval process. So quite often those offset offsets are not provided up front. They can be provided at periods of time further down the post-approval process, which could be months or years after the development has been approved. And that would also relate to the way in which rehabilitation is used from an offsetting perspective as well, because obviously that's not going to occur until some point into the future. And the uncertainty, I suppose, that would be attached to that is something that the offset scheme doesn't really speak to.
So the council, in your submission, you also mention, you give one example of a threatened critical habitat, endangered ecological community, I understand it probably is, the Central Hunter Grey Box Ironbark Woodland Community. When that's cleared now within the LGA, I assume that's almost impossible to offset within the LGA firstly, and is it possible to even offset it elsewhere?
I might refer that question to my counterpart, Ziggy, if that's okay.
Excellent. Yes, Mr Andersons.
Madam Chair, Ziggy Andersons. So as I alluded to in our submission, that community is also a federal community, and that federal community was able to be, the offsets were enforced by the East Act, and they required strong like-for-like, and we're seeing good, strong like-for-like outcomes. But that community, due to the Hunter Basin's fairly unique layout, it flows from us out into the Great Sheep Wheat Belt, which flows right throughout New South Wales. So now that we have that bilateral, that community can now be offset with what is essentially the same community, which extends throughout inland New South Wales. So yes, those offsets can now be sourced a lot further afield. And that's been acknowledged by the BCT. I've had that conversation with them that bilateral agreement now opens the opportunity for them to offset a critically endangered community with a community that is also critically endangered, but is not like for like. It is a very different community. It just falls under the banner of that broader community of the box gum woodland.
When did that change take place that you're saying? So it's a broader community of what woodland was it? Grey box?
So,
right.
Yeah, Grey box woodland. So what it was, when the bilateral agreement was signed between the state and federal government to allow federal matters of environmental significance to be considered under the Biodiversity Conservation Act, it essentially brought a whole heap of federal communities that are very geographically specific. That woodland is very specifically related to the Central Hunter. It was only listed based on its geographic location. So it's some characteristics of the community that extends throughout inland New South Wales, but the listing was based on its extent, the edge of its extent within the Hunter Valley. And so now that it's under the bilateral, can be considered under the Biodiversity Conservation Act, it's now brought into that broader community and takes away that geographic context of that community. So what we're seeing is the mines are searching into the Upper Hunter Valley for their offsets. It's cheaper land prices, so we see a lot of offsets occurring in the Upper Hunter and the Muswellbrook Shire and Golden Rivers. And so further far-flung communities that sort of meet that variation rule in regards to the interim geographic regions, integraphic geographic biography. I always got the acronym wrong. Bioregions, basically, it's provision within the variation rules to allow within the in the IBRA or adjacent, and that picks up that further flung vegetation out in the Golden Rivers and the Upper Hunter. So that's where we're seeing that.
Thank you. That's fascinating. I could keep asking questions about that, but I just have time for one more before I throw it back to Ms Sharp. To the local government, New South Wales, in your submission, you talk about, this is on page 9, non-additional offsetting, and that councils acknowledge that establishing stewardship agreements in large council reserves and other areas with limited development potential provides limited net biodiversity increase. And you write that the choice for a council can be to either establish a stewardship agreement on reserve land and accept the obligatory 20% discount in credits and the resulting net loss in biodiversity, or see offset credits leave the LGA or region altogether. Could you just expand for the committee, just what is the obligatory 20% discount in credits? This is a very complex scheme, as I think every witness has said, and all members agree. But what is the obligatory 20% discount in credits if you're using an existing reserve? And just explain how that works. See whether.
Thank you for the question. I may have to defer that question to my friends in the councils. I know Ziggy has put his hand up. I just apologise. It's been some time since I've practically applied the scheme.
Yes. So, that's fine.
If the committee's indulgence, I'll do
of course, yes. Mr. Andersons, did you want to take that one too?
Fundamentally what it is about, there's discount rules within the scheme for when you generate credits, and those rules depend on the existing management obligations of the land. I'm probably going to get the terminology wrong, but I think it's based on the classification of the land, whether it's community land or operational land, and then within that there's an obligation on councils to manage that land accordingly, and that incurs a discount on the credits, and I think that's the 20% discount that as raised by LG New South Wales. It's based on existing obligations.
And does that provide more of an incentive? This is my final question. More of an incentive because it is the credits. Is that more of an incentive to use existing reserves or less of an incentive?
Less of an incentive, and often councils are required to change the classification of the land so that they can avoid that 20% penalty as well. So there's quite a few councils on the coast that have changed classifications so that they can avoid that penalty in credits. But I think the question goes to the fact that if there's a penalty applying to councils providing offsets versus those offsets leaving the region, and there's a bit of a disproportionate application.
Sorry, I have to ask this question of clarification. What do the councils change it when you're saying changing the classification of the land? Can you give an example what that means? So is that from a public reserve to?
From operational to community, or around the other way. It's one of the those. Some of the other councils might be able to better allude, or my manager might be able to better allude. But under the classification of the land under council ownership determines what management the council should be doing on the land, and therefore that's what potentially generates a reduction in credit.
Thank you, Ms. Sharp.
Thank you. I have just got two quick questions. The first one really is, I mean, given the importance of local government to land management across the state, and I think in your submission for Local Government New South Wales, you just said there used to be some government support for officers in councils to work through this very complex scheme. Has that been withdrawn, or is there some support from state government? Sure, who can answer?
Thank you for the question. Look, there is some support.
So just who? Oh, yeah, Mr. Phillips. Mr. Phillips, yeah.
Pardon me, sorry, I'm Scott Phillips. Yes, there is certainly some support from the state, and councils work collaboratively with the agency in that respect. However, it should be said that a number of councils don't necessarily have the staff or the skill set to properly implement the scheme, and the limited experience and limited exposure to the scheme does create those complications for councils.
And given that so much now, so can you also just describe to me, given most of it's now been handed over to the Biodiversity Conservation Trust, is that sort of, where do councils go to for help in relation to these issues?
Thank you for the question. Could I defer that question also to the councils with us today who would practically be dealing with that on a regular basis?
Who helps you?
We're happy to answer on that. Kimberly Baker.
Yes, go.
Yes. We're lucky enough to have 2 BAM accredited assessors on staff. However, it is quite difficult for councils to secure staff that have the appropriate experience or technical skills to help assess these reports. And where they're not available, you have to go to the Biodiversity Conservation Division, and you can hand your BDAR to them and they can provide an independent review back to council. Or the other option, which most councils, I guess, are using, is using consultants that are accredited to provide an independent review for them.
I imagine if you send it to the department, it could be quite a long wait before you get that ticked off, which would, impacts in terms of development times and costs.
From time to time, but yeah, it can be lengthy depending on their workload and who's available in their team. And their support system is quite difficult sometimes. It's just a BAM support online form or email. There's no ability to just call someone and ask a question. And a lot of consultants have raised that as an issue with me previously, that they're hard to get contact to get advice out of.
And do you find issues with consistency in relation to that, to sort of, seeking advice? Is the advice consistent enough?
Yeah, I think the advice is consistent enough. It just takes too long to come through.
Okay, thank you. That is unfortunately the end of our time with you. We knew it would be very stretched to have all the councils in this these next few sessions, but we wanted to make sure we heard from as many as possible. So thank you so much for appearing today, and rest assured, if you didn't get we didn't get all the questions out, your submissions have been very helpful as well. And the Secretariat, I don't believe any questions were taken on. Oh yes,
I've got one.
Yes, there are. The Secretariat will be in touch with you if you have agreed to take any questions on notice or supplementary questions, which will be available, which will need to come back to us within 21 days. So thank you so much for appearing, and we will now call our next witnesses. Thank you. You're so much more efficient at it.
Good morning, it's Andrew Road here from the Secretariat. Mrs. Love, can you hear me?
I can.
Thank you.
Can you hear me all right?
Yes, we can hear you. Ms. Klein, can you hear me?
Yeah.
Thank you. And Mr. Clark, can you hear me?
Yep, can you hear me?
Yes, thank you.
Great, excellent. Now that that's done, we will, it's Kate Fairman here, we're all in the Jubilee room and you're all coming through loud and clear, so we will now proceed to swear you all in, starting with you, Ms. Klein. What we'll do is, if you could all state your name and position title and then swear either an oath or an affirmation, the words of which I believe you have been sent. Ms. Bianca Klein.
Yes, so I'm Bianca Klein, the Environmental Services Team Leader at Wollondilly Shire Council. So I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thanks, Ms. Klein. Mr. Clark. Mr. Clark, have you... Yep.
Gordon Clark, Director, City Futures at Shoalhaven City Council. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you very much. Finally, Ms. Love.
Karen Love, Strategic Environmental Project Coordinator for Port Macquarie Hastings Council. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you so much. And do you all have opening statements? And if so, we will go to each of you in the same order. So Ms. Klein, do you have a short opening statement to make?
Yeah, I do.
Thank you.
Yeah, thank you. Thank you for the time today. So the comments provided are based on the experiences of council and the local community it represents in regard to the experiences with the biodiversity offset scheme since its introduction to Wollondilly in 2018 following the transitional arrangement period. So Wollondilly Council are generally supportive of the intent of the scheme and its biodiversity conservation goals of facilitating a no net loss of biodiversity. However, there are a number of concerns raised in our recent submission in relation to the application of the scheme and its ability to deliver intended conservation outcomes. So a few of these concerns, I'll just summarise these quickly. So we believe that there's not adequate protection of biodiversity at a local scale So offsets are often not acquired locally within the LGA, and Wollondilly is vulnerable to being subject to a net loss of biodiversity as a result of the offsetting rules. And the ability for developers to pay directly into the Biodiversity Conservation Fund is sometimes perceived as an easy way out and contradicts the principle of the biodiversity assessment method to avoid, minimise and to only consider offsets if the first two outcomes are not able to be achieved for development. And we also believe that the cost of preparing a biodiversity development assessment report for impacts to land within the biodiversity values map encourages illegal clearing. So the cost of a fine, if legal action is enforced, is likely to be cheaper than preparing a BEDA and retiring credits for those impacts. So that's just a summary, but happy to answer questions at a later stage.
Thank you so much, Ms Klein. Mr Clark, do you have a short opening statement as well?
Yes, I do. Thank you. So thank you for the opportunity to appear before the inquiry and provide input on behalf of Council. Council made a submission to this inquiry responding to the specific term of reference point, any other related matters. We wish to highlight a specific issue that is of particular concern to the Council in regard to the Biodiversity Offset Scheme and the Biodiversity Conservation Act more broadly. Our concern stems from the impact that retrospective application of the offset scheme is having and will continue to have on long-planned local development opportunities. The specific scenario highlighted in our submission relates to the impact on potential employment-generating development in Shoalhaven in areas that have been agreed on, planned and zoned for a long period of time, well prior to the offset scheme being introduced. Because the scheme was introduced after the employment land had been planned and zoned, there is no strategic framework or regime in place to support development in the areas affected. As a result, it means offsetting is considered in a piecemeal approach as part of every individual development application. This is resulting in an outcome that makes the intended development unviable and important job-generating opportunity could be lost. It is also likely that suboptimal biodiversity outcomes will occur because there is no priority framework in place within which to consider the best targets for application of any offsets. A specific example in this regard is the South Narra Industrial Zone. Much of the area was zoned for employment-generating development in 1985, and this was reconfirmed in 2014. The area is one of two banks of significant employment land in the Illawarra-Shoalhaven region and is recognised in the government's regional plan. Industrial zones like this were previously excluded from the operation of the New South Wales Native Vegetation Act, one of the acts that the Biodiversity Conservation Act replaced, and from which the offset scheme now flows. Approximately half of the over 300 hectare area was developed prior to the offsetting requirements. The requirements that have resulted from the retrospective application of the Act have cost and time implications for individual development applications. Significantly, the offset requirements, specifically the purchasing of required credits, can be more than the employment land is worth. This is impacting on the viability of development. For example, in one case, it is likely that upward of approximately 1.5 million in ecosystem and threatened species credits would be needed before a development could proceed. This is having a real impact, rendering development unviable and meaning that previously desired and agreed planning outcomes are not currently being pursued or may not result. Council is extremely concerned about this situation and has resolved to request the New South Wales Government to exempt employment and commercial land from the offset scheme. Council has made representations to the New South Wales Government in this regard and recently took part in a deputation to the New South Wales Parliamentary Secretary for Environment along with affected owners seeking removal of such land from the offset scheme. Thus, it is requested that the committee strongly consider Council's request that areas zoned for urban development, particularly employment and commercial zone land, be exempted from the biodiversity offset scheme as part of its deliberations. Thank you.
Thank you very much, Mr Clark. Ms Love, do you have a short opening statement as well?
Yes, thank you. And before I begin, I would like to acknowledge the Biripi people as the traditional owners and custodians of the land on which I live and work and am currently addressing you from. I would also like to thank the committee for inviting me to give evidence today on a system that is currently failing to address biodiversity loss in New South Wales. I sincerely hope that this inquiry bears more fruit than the last inquiry on koalas and their habitat that I gave evidence to last year. Let me be very frank. The Biodiversity Offset Scheme, or BOS, is currently failing. Not only is it failing, it is an elaborate, resource-hungry and complex accounting system that facilitates development at the cost of the environment. In other words, it has failed to halt the loss of biodiversity, and worse, it actually enables it. The reason why? Well, the very principles on which it rests, the avoid, minimise and offset hierarchy, which is resoundingly supported, is not being used in practice. Where offsets should be the last resort, they are in fact the first port of call. This means the integrity of the BOS has been undermined before we even get into anything else. It appears to have been set up this way, as the principles were never defined in the legislation. Furthermore, serious and irreversible impacts have no quantifiable impact thresholds where development cannot be approved. Numerous examples of this exist in our LGA, including littoral rainforest and critically endangered local flora. Due to a lack of these thresholds, the impacts on such entities are assessed subjectively, and further, any decision on the impacts can be turned over by the Minister. Our most precious entities, in essence, have little or no protection. What we're seeing in a local government area is development, paying for the loss of biodiversity through credit retirements to the VCT. Those credits will never be realised in our LGA as we have no stewardship sites. They're gone forever. Of even more concern is whether certain species and ecosystem credits ever have or ever will exist. The increasing pressure of development along the coastal strip of New South Wales due to COVID has escalated the price of land, where biodiversity stewardship will now never be an option. The land is worth too much to develop. As a fair amount of it is rural land, it can be cleared under the LLS Act, private native forestry, or the new Rural Boundary Clearing Code, and then be rezoned for development. Of critical concern is the scant information provided thus far regarding trades, where the majority of trades are those that haven't occurred. Some 952 species credits and 310 ecosystem credits. Will these ever be realised? If so, then where and when? If not, then what happens to the money? The BOS appears to be the monetisation of species and ecosystems into credits that may never come to fruition. I ask the committee to seriously consider these matters and also, as a result of this inquiry, answer these three questions. 1. Where is the report that provides information on which species and which ecosystems are required to trade credits? What trades have actually been made and where? 2. Where is the data that shows the credits required at this moment can ever be realised? And 3, and probably most importantly, who is assessing the long-term cumulative impacts of the biodiversity loss that has been facilitated through the BOS? Thank you.
Thank you very much for that very good opening statement as well, Ms Love. We will now go to questions from members. We'll start with questions from the opposition. Ms Penny Sharp.
Thank you, and thank you all for your submissions. They're extremely helpful and give practical voice to the complexity and failures of the scheme, and they've been very helpful to the committee. Mr. Clark, I wanted to ask you just specifically about the issues that you raised. I'm actually quite familiar with the Nowra area and the desperate need for employment lands and the long-term planning of that South Nowra precinct. The sort of solution that you've come up with is that those lands just should be exempted. I mean, is there also, is part of the issue the fact that you can't sort of look at that all in one go and come up with some sort of biodiversity offsetting plan that could be dealt with as a job lot as opposed to having to deal with each individual lot? Would that be useful, and are you prevented from doing that at the moment?
Look, thank you for the question, and it's a very valid one. I guess, look, first and foremost, I'd say that we went through a strategic process with the state government to actually identify the industrial zone in that location. So essentially what we're saying is, we've in good faith, and the community and the broader council have gone through that process, but we now have a real risk that some of our key industrial land for the future will be difficult and if not impossible to realise because of the impost of the scheme. The problem, as I said in my opening comments, are that it's being considered DA by DA, site by site. There is no localised strategic biodiversity certification process underway, and certainly that potentially would provide an avenue, an avenue to assist if there was a will amongst particularly government. Obviously, council will always have a will to assist, but essentially potentially government playing a key role.
And forgive me, this is a dumb question from my end. Is the ability to do that just prevented in terms of the design of the scheme and the way that the legislation is drawn, or is it just that there's a lack of will to actually come to the table and try and work through that?
Oh, look, I don't think there's any lack of will on council's part.
Yes, I'm not suggesting lack of will from you.
Yes. I think, but that type of assessment, essentially, we would argue, needs to be driven at a higher level, and there's absolutely no point in going through it unless you can get, I guess, an outcome at the end of it. So essentially, we would hope for buy-in from government in that type of strategic process, either to help fund it or alternatively fund and run it with council and landowner input.
But that all sounds quite sensible to me, but I suppose you're not able to... It's all right, I'll ask the department later this afternoon, but is the structure of the legislation not allow that? I mean, what I'm trying to work out is there's a design flaw in the legislation that means that you can't come to a sensible arrangement in your situation, or is it just that there's a lack of will to bring people to the table and work through that process together?
Look, my simple understanding of the legislation is that mechanism does exist, but it's really about herding the cats, so to speak, and getting everybody committed to that process and actually, underway with it. I mean, because from council's point of view, if we go through that process, we don't want to get to the end of it and actually still be arguing about, the outcome. It would be good to agree on an area outcome or a regional outcome, rather than, as I said, at the moment we're kind of dealing with the issue DA by DA, site by site, and we've got landowners there, some of them who've held land in an industrial zone for a long period of time, basically frustrated.
Yeah, no, I think that's right. I might come back to you. I'll defer to others.
Okay, I just wanted to check, Justin, Mr. Field, do you have some questions?
Yes, I do, Chair, and actually Ms Sharp stole my thunder a little bit, and good to see you, Gordon, on the call. Thanks for everyone's participation today. I had some questions as well about the Shoalhaven submission. In the first instance, was the Shoalhaven submission stands out a little bit in terms of the various council submissions in the approach that it takes and the concerns that it raises. And I'm just wondering, Mr Clark, if the submission was something that actually went formally through council or if it was put together at the staff level.
Thank you for the question, Justin, and good to see you again. As per usual with how our council operates, we operate off council resolutions, as you'd probably all appreciate. So essentially this submission was triggered by essentially two resolutions from the council from earlier this year, essentially that related to or raised concern around the impact that the biodiversity offset scheme was having on employment zone land. So yes, the staff prepared the submission, but it's based upon two council resolutions that, as you would all appreciate, we as staff have an obligation to enact.
Has there ever been a council resolution to actually seek an application for a strategic biodiversity certification? Because my reading of the legislation is you can do that. I appreciate you might need to organise with various landholders, but the approach is available for council to simply, as a planning authority, make the application to the state government to start the process on a strategic biodiversity certification.
Look, Justin, again, thank you for the question. Again, it's a valid one, and that could be an approach that ultimately comes into play. And yes, I acknowledge that it's something that council can do. But like I said earlier, at what cost? And also, it's really, yes, it's something we can do, but from a council perspective, we want buy-in from the government agencies along the way, so that if we go through it, we come out the other end of it with an outcome, and it's not just a process that, as we've experienced in the past, just goes around in circles. So it could be an outcome that the council ultimately takes at some point in the future, depending on how its deputations and representations on the request for the exemption is currently received by the inquiry and ultimately by government.
Thank you for that, and I appreciate this is still relatively new, and we've really only seen sort of one major strategic biodiversity certification process even attempted in Western Sydney. But have at the very least yourself or through resolution of the council sought advice from DPIE at the regional level about how should we go through this process? What does this look like? What's the likely cost or the time frames? What work has council done to actually work out whether or not this is a process that you should go through?
So look, again, to reiterate, we currently have resolutions of council which really focus on requesting, the general exemption of employment and commercial land from the offset scheme. So that is our current focus. To my knowledge, the council has not passed any resolutions or similar decisions around moving into potentially looking at a regional offset scheme, but it could well be a step that the council takes depending on the outcome of any the current representations we are making. In terms of have we done any work, we haven't done contemporary work, but I can assure you that as part of identifying those industrial lands, particularly in 2014 through our LEP, there was a whole series of work went behind those lands, which obviously, yes, it's now dated, but could assist. But I guess what the point I'm trying to make is that the land was zoned based upon information, a set of information at the time. We have a scheme later on that effectively comes along and essentially compromises, a long-term zone that was agreed to in our minds with the state government.
Even if this scheme hadn't have come into force, though, if it was vegetated land that had been zoned for industrial or commercial use and a DA was put in that was going to require the clearing of substantial areas of habitat, whether it be for threatened species or endangered ecological communities or otherwise, there would likely have been conditions of consent that would have required offsets or some other form of protection of other environmental land, right? So these costs haven't just been put in place because of this scheme. It's just that now there's a sort of a much clearer defined process for how those costs and those biodiversity impacts would be addressed through a DA process.
Look, again, in response, I don't necessarily know that that's fully the case, because I think, as we noted in our submission, one of the previous acts that was in play before the Biodiversity Conservation Act was the Native Vegetation Act, and urban land, which included industrial land, was exempted from that act. So essentially industrial land was part of that. So we would have had developments occur in that area within a period of time, not that far away, where, essentially the type of implication that we're now seeing was not there. I think the big implication that particularly a lot of the current owners are struggling with is, as I said, one offset cost was in excess of $1.5 million. So essentially, given the size of the industrial block, it basically renders the development of that particular block almost effectively unviable. And people are just basically, stuck and not proceeding with anything because they just don't know how to proceed from a financial viability point of view.
Okay.
Thank you, Mr. Clark. My time expired.
Thanks, Mr. Field. We'll go to questions from Ms. Catherine Cusack.
Thank you very much. A quick question to Ms. Klein. In your submission, talking about biodiversity values mapping, which appears to be problematic, which is very disappointing. We hear this in many of our inquiries. But one of the comments you make, and I quote, is the cost of preparing a BDAR for impacts to land within the biodiversity values map encourages illegal clearing. The cost of a fine, if legal action is enforced, is likely to be cheaper than preparing a BDAR and retiring credits. First of all, can you just clarify what a BDAR is for me? What that acronym means? And secondly, can you just talk me through the cost of the fine and the cost of preparing the map and time issues?
Yes, no worries. So sorry for the acronyms. The BDAR is the Biodiversity Development Assessment Report that a developer needs to prepare when entering into the biodiversity offset scheme, and this is generally quite costly. They usually start at a minimum of $15,000 to $20,000 to prepare, and that doesn't include the credits that need to be offset after that. So in a few instances in Wollondilly Council, we have been working with the department to amend a few areas of inaccurate biodiversity values mapping, so we appreciate that support, and that is ongoing. But there are still a few instances where a certain property is covered by the biodiversity values map, where the property owner needs to clear, say, up to 10 trees, and then they approach council and get told that they need to prepare this biodiversity development assessment report and retire credits, and they're not happy about this due to the cost. And I think word is getting out around these. It's generally the smaller private landowners. The cost of preparing these reports can be quite prohibitive. So the other option is to clear the trees anyway and either hope that no one notices, or that if there is compliance action, often the fine is cheaper than what would be spent for the BDAR or
what sort of a fine would you be looking at for illegally clearing 10 protected trees?
So probably about $10,000, $15,000 if it did go to court.
Okay.
The unfortunate circumstance we sit in is the compliance section is under-resourced. Like many councils are faced with that same situation. So sometimes no legal action is taken in those instances, which is a shame, but something council are continually trying to improve on. But yeah, so that's just one of our concerns about the scheme sort of encouraging illegal clearing.
Thank you very much for that. Can I just ask Port Macquarie Council, and thank you for your passionate submission, Ms Love. I want to ask you about, I note that Port Macquarie unfortunately hasn't submitted its koala plan of management. I'm not sure where that's up to, but it's, and I know that that's beyond staff control, but I just want to comment that's disappointing.
It is. Agreed.
The land that I want to ask you about is in Ruins Way, and I understand about a third of it or 2/3 of it is zoned rural land at the moment. Now, this issue that you've raised of coastal land and these historic zonings of rural are bringing it under a different set of rules in terms of... Correct, yeah. I mean, I live in a coastal council as well, and we have exactly the same problem, that it's not really rural land, is it? I mean, in terms of the properties that we're talking about, which are peri-urban, they haven't been operating as rural properties for many decades, and some never have, but they've still got this rural zoning. So I wondered what the solution is to that. I understand Port Macquarie has actually mapped its population footprint, if I can put it like that, or it's if you can explain that to me. But there's been a kind of a proposal for the city limits of Port Macquarie, if I can put it that way, for housing, and how that sort of mapping could potentially be used to deal with this problem of these legacy rural land zonings that are meaning that some rules for rural properties are being inappropriately applied to what are really urban areas.
It's a rather difficult question. There's a lot of things that we can do. For me, I think the planning proposal process where we identify those types of land and get them zoned appropriately, it's a long-term solution, and it will take a fair amount of resources. We already have a list of those types of properties that are inappropriately zoned. However, what we come against is the owners of those lands realising, oh, actually, I can put a subdivision in here and I'm zoned rural, so I can use the other legislation to clear it and then rezone it. Yeah.
This, to me, is absolutely the iconic issue up and down the coast of New South Wales in relation to clearing. Nobody supports this sort of clearing. It's not farmland, it's not forestry, it is just about the value of the property because of the zoning that's on it.
Yep. And we've got no recourse as a council to stop them because the LLS Act is out of our remit.
And can I jump in there, because that just on that same issue, because it's the chair here, because you see these very large blocks of land around the kind of outskirts of Port Macquarie, and as Ms Cusack said, right up and down the coast, and a lot of them are reasonably significant in terms of the vegetation they have, what they contain, aren't they, Ms Love? Did you want to maybe talk just, are there any examples you'd care to kind of highlight for the committee about what is being lost?
I can give you some stats, actually.
Great.
Private native forestry in Port Macquarie Hastings Council, 58% of it is potential koala habitat. 58% of it we have no control over because it's already approved, to be clear.
Yeah.
So where do we go from there? How do we...
Can I prompt you maybe on the Ruins Way, because my understanding is that is a very strategic block of land in relation to the koala, the corridor for movement of koalas. And so basically losing that part of the corridor will destroy, it's not just about that piece of land, it completely sterilises and destroys urban koala populations in Port Macquarie by cutting them off.
That is a main population. There's about, well, the last that I read, it may be out of date now due to the fires, but, a population of 500 koalas, which is probably the main population in Port Macquarie. It's right next to National Park, and that corridor is critically important to that population, and I can't speak to the rest of it, but
do you have any thoughts about how corridors can be protected? Because you can look...
That is the main thing that we need to do now. We're not going to see the ability to actually make a koala plan of management because we've got 2 SEPs running that are still undefined. There's no guidelines for them. My main aim will be to get corridors identified and protected, and the only way I can see that council can do that is through the LEP. So again, a long process.
Thank you.
I can't see any other way. Can you?
I'm feeling very depressed, actually.
So sorry, Ms. Love, had you finished? We've got government reps this afternoon. So what would your recommendation be to them in relation to those corridors that need protecting? You just mentioned the very frustrating situation of the koala SEPs and wherever that is up to. But what would be your recommendation to how we can get what I suppose is a broader application of laws and policy to protect corridors?
Well, I noticed that the SEPs are being remade. Perhaps something in the new SEP that Stokes has put forward that will happen in March. Maybe we could have a SEP for corridors. I don't know if that will work. I'm not a legislative planner.
That's all right.
Otherwise, it's the LEP, and that's a 2-year process.
Yes. Can I just have another question for you as well, Ms. Love, while we've got you. Your submission states under the issue of this is where you talk about the species credit, which you mentioned, species credits, which you mentioned in your opening statement, that you talk about a recent webinar to discuss the new developer charges, and that was the first time that any information regarding transactions for ecosystem credits and species credits had been relayed to the council. If you could just explain a little bit further around where you say of concern was the trading transactions that have not occurred, where 952 species credits transactions and 310 ecosystems credits have had no trade. So those, explain firstly the 952 species credits and 310 ecosystem credits. Have they been what the council has essentially what's been accumulated in terms of clearing in their area? What are both of those credits? Groups of credits.
Yeah, the webinar was across New South Wales. It wasn't just for our local government area. And it was discussing the developer charges and how they're going to change them. And that's the first time they've actually issued any type of information on what had been traded and what hadn't. I can't tell you off the top of my head. It was a slide that I took a screenshot from because it was horrifying that they'd only had perhaps 5 species credits actually retired properly, whereas there was 900 odd that hadn't been retired. And the same with ecosystem credits. Again, I can't remember what had been, but it was in the single digits as opposed to those that hadn't been, which was the higher number. And that's across New South Wales, and that was in June.
Yes.
So I don't know, there's probably more now.
Thank you for clarifying that. That's very useful for this afternoon as well. I wondered whether you all probably could care to comment on this, but what are, I think, let's see whose submission this one is. I think it's Wallandilly Shire Council. Consider, in terms of recommendations for conservation, but to consider tax-free thresholds for the stewardship site funds so that landholders are more incentivised to encourage participation and conserve land. I just wondered if all of you could care to comment a little bit more about what recommendations you would like to see to encourage landholders to conserve land more. I'll go to you, Ms. Klein.
Yes, thank you. So, yeah, that was one that we have received feedback on from a few private landholders who were investigating the opportunity of setting up a stewardship site on their property, and after going through a few feasibility assessments and sort of doing the number crunching and then realising that any gains are still taxed, that did hit their budget a little bit. So I think, yeah, in order to promote conservation, it would be nice for something like a tax-free threshold on profits on a stewardship site was considered. The other thing that could help financially is maybe the Biodiversity Conservation Trust can provide services free of charge to private landholders to do a feasibility assessment on their properties. I know consultants charge a fee for this type of service in our area. So just financial assistance from the department or BCT or some support for councils to do that with private landowners would help.
They're very good suggestions. Ms. Love, do you have anything to add to that?
I think the system is overly complex for normal landholders to apply. Getting that report is very costly and time consuming. If they could somehow streamline that process, that would perhaps make it more viable. But as I said in my opening statement, the land's now worth too much money. Stewardship is, I think it's out of the picture for this area on the coastal strip anyway, because it can be developed. So yeah, it's problematic, and that's got nothing to do with the system. It's just the way it is, and I think it's become more and more because of COVID. So our land down here has tripled in some areas in price in the last 6 to 12 months.
Yes, thank you. And what about, and Mr. Clark, do you have anything to add to that question in terms of incentives?
Oh, look, I think just to reiterate some of the points that have already been made, I think the system as it currently now stands is way too complex. I think I reflect back on, a lot of the rhetoric around when the Biodiversity Conservation Act was coming in. It was about bringing a number of acts into one and simplifying things. I think if anything, as we quite often see, things have just become even more difficult to understand and navigate. If I put myself in the shoes of, one of the landowners in the South Narra Industrial Estate, but by and large, they are essentially, individual landholders. They're not businesses. Because this is an area that was strategically identified some years ago and rezoned from rural residential because it adjoined our main industrial estate. So these people are essentially not businesses. They're not companies. They're not, they're not basically. They don't have a lot of money sitting behind them to carry out a whole heap of investigations. So yeah, they find the system really complicated. So I think if anything we could do would be to try and simplify things for everybody would be a really good start, because I don't understand it and I'm a professional working in the field.
Thank you. I've just got one final question maybe for you all as well. We've heard from, most of the councils and local government New South Wales this morning saying that while they support the biodiversity offset scheme, there's some, there's improvements to be made generally, but probably other than you, Mr. Clark, but with the evidence that we've heard this morning, it just sounds like it has been a gross failure, to be honest, to meet any of what was originally the objects of the scheme. So can it be fixed? And I want to start with you, Ms. Love, and that's a very big question, but can it actually be fixed?
I think we need to start with an audit and actually look at what we need in terms of credits that have already been accumulated and paid for, and then go from there. Whether those credits will ever be realised is a key part of this.
Absolutely.
And if they can't be, then it needs to be thrown out and start again. If they can be, which I hope they can, otherwise we've lost that biodiversity forever, then an overhaul and maybe simplification. We've got 2 biodiversity assessment methods running at the same time. We've also got new plant community types coming in next year. So we'll have 2 biodiversity assessment methods and 2 plant community types to deal with. That's even making it more complex.
Can I just quickly ask, it's a finite process, isn't it? We can't go on offsetting forever, can we?
No, Offsets don't work.
That's the
We know
report.
that. We know that.
People.
Yeah. Thank you. Ms. Klein or Mr. Clark, did you want to comment on that? We're almost out of time. Ms. Klein?
Yep, I'm happy to add.
Great.
I agree with Ms. Love in terms of an audit being a great first step. A couple of other suggestions that would tighten up the credit trading rules would be to sort of tighten up the variations allowed for the like-for-like credits. That's an issue we see in Wollondilly a lot. Impacts to very rare, critically endangered ecological communities like Cumberland Plain woodland and shale sandstone transition forest. They're getting impacted in Wollondilly and being offset elsewhere. So that's a loss to Wollondilly for those communities. And then these communities, there isn't a sort of infinite supply of these communities in the Greater Sydney. So they're just getting chipped away piece by piece and being offset, or the money paid into the fund. And there is a great concern whether the Biodiversity Conservation Trust will actually be able to offset those specific communities, as an example, in the Greater Sydney in the future.
Yes.
So I think an audit would really be good for identifying those.
Thank you so much. And on that, I'm sorry to say we are out of time once again. We could have kept going, but thank you so much for your excellent submissions and views and thoughts. They're very appreciated. So thank you so much. We will now break. The committee secretariat will be in touch if you have taken any questions on notice or if there are any supplementary questions by members. So thank you, and we will now break for morning tea. We'll be back. Great. Okay, well, we are now back on, and welcome to our next witnesses. I will just begin, let's begin by getting you all sworn in. We'll start with Goulburn Mulbarry Council. If we could start with you, Ms. Kate Wool, by stating your name and position title and swearing either an oath or an affirmation. I understand you all have those words in front of you. Thank you.
My name is Kate Wool. I'm the Business Manager of Strategic Planning at Goulburn Mulbarry Council, and I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much. And Mr. Faulkner?
Yep. So my name is Brian Faulkner. I'm employed by Goulburn Mulbarry Council as the Environment and Biodiversity Assessment Officer. So I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth and nothing but the truth.
Thanks very much. We'll go to Coffs Harbour City Council. Ms. Sally Whitelaw.
Yes, my name is Sally Whitelaw. I'm the team leader of Biodiversity, Coastal and Flooding at Coffs Harbour City Council. And I solemnly, sincerely and truly declare and affirm the evidence now about to be given by me should be the truth, the whole truth and nothing but the truth.
Thanks very much. Clarence Valley Council, Mr. Scott Lenton.
Yeah, hi, my name is Scott David Lenton. I'm the Manager of Environment and Regulatory Services at Clarence Valley Council. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. And finally, Ms. Heather Mitchell.
I'm Heather Mitchell. I'm the Biodiversity Officer at Clarence Valley Council. I swear that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth, so help me God.
Excellent. Okay, so we'll now go to opening statements, and I assume each council has a short opening statement to make. Who is giving that for Goulburn Mulbarry? Great.
So good to go?
Yes, thank you.
Okay. So basically, Goulburn Mulbarry Council's experience is that the biodiversity offset scheme is not preventing net loss of biodiversity. We have found it's impeding loss to a degree, but it is not halting it or reversing it by any account. And there's a lot of reasons for that, which we might obviously be able to cover later. We have identified that there's really three major issues that are contributing to this. One is that the legislation is incredibly complicated, and basically people involved in clearing don't understand it. And when I say people, I mean landowners, I mean real estate agents, property developers, builders, earth-moving contractors, all the stakeholders who might be involved in clearing land vegetation. Routinely, they don't understand it. They find it really difficult, and I spend a lot of my time having a lot of conversations explaining the legislation. So as a consequence, a lot of clearing happens out of ignorance. It's not that people are necessarily being bad or deliberately violating the law, it's just they're doing it because they don't understand. The second biggest issue we have here is we have a lot of rural properties, a lot of remnant bushland, and some of that is rural, so RU1, RU2, and some of it is environmental management. And there's different rules and different regulations that apply to those two zones. Again, there's a lot of confusion, but people on rural properties are using the Local Land Services Act and the provisions, agricultural activities, and the newly released Rural Fire Service Rural Boundary Clearing Code to clear huge amounts of vegetation prior to some of the DAs. So effectively, they're clearing huge amounts of land, then they put in a DA, and they can avoid the loss completely because either they're down through the area clearing threshold because it's already cleared, or because they cleared habitats, or if they're remnant species that they cleared out. So there's nothing there that they need to consider. So the biodiversity offset scheme is, not being implemented in any shape or form in those instances. And then the third biggest issue we have encountered is inability to enforce compliance. So we locally have had a huge influx of people coming in and buying properties and wanting to clear. And equally, there's been a huge spate of activity in the DA sphere in building, people with an existing property wanting to clear and build dwellings. A lot of clearing has happened. We our compliance team are overworked by reported allegations of illegal or unauthorised clearing. We work closely with other agencies, so we work closely with local land services, with Department of Planning, Industry, Environment, the Biodiversity Conservation Compliance Officers. We work with Crown Lands, we work with Fisheries, with Water New South Wales and so on, and right across the board, the stories are saying woefully understaffed, woefully under-resourced. They simply can't keep up with the enforcement. So as a result, what's happened is there's a triage system where they'll only take action if they're absolutely guaranteed an outcome. The way it was explained to me recently by a DPI compliance officer was, there has to be a threat species that's getting present. It has to have clear evidence of the damage, and thirdly, it has to be clear evidence that the person who did it deliberately. And that's the only way you'll guarantee a successful outcome of a prosecution or enforcement. And as a result, there's a lot of clear going happening. But yes, it's investigated. The people get a bit of a slap on the wrist, they don't do that again, you're so naughty, but there's no actual real serious enforcement. So those three issues combined are causing huge issues for us, and overall, the impact, as I said, is our experience is that there is a net loss of biodiversity, and the loss is not working. So that's our opening statement, I guess.
Thank you. Thank you so much, Mr. Faulkner. We will now proceed to Ms. Whitelaw. Do you have an opening statement as well? Please proceed.
I do, thank you. So I've worked in local government for 15 years in roles relating to environmental planning and assessment, and that means that I've worked with both the former Threatened Species Conservation Act and the Biodiversity Conservation Act. It's been my experience impact underneath the former Threatened Species Act was very rarely assessed as being severe enough to be significant, and therefore needing a species impact statement. Even then, when an SIS was required, the outcomes were not consistent or arguably based on sound science. On a positive note, I found that the offsetting scheme under the Biodiversity Conservation Act has resulted in development that can be encouraged to avoid impacts, as the additional cost of entering the offset scheme, both by preparing the ecology reports and retiring the credits, can be formidable, and applicants typically want the easiest pathway to determination. The principle of avoiding impacts upfront rather than offsetting has also been recently found to be upheld in a number of land and environment court judgments. I do have concerns with the lack of a robust credit market, particularly outside metropolitan areas, and this results in developments in regional areas being approved with the knowledge that it's highly unlikely the required credits are going to be retired in the same bioregion. Additionally, the continued increases in the value of coastal real estate mean that popular coastal areas are likely to become a biodiversity sink, with credits retired in less expensive areas. Entry into the offsetting scheme can also be avoided by the staging of development or in rural areas by clearing permitted underneath the Local Land Services Act prior to lodgement. I also note the inconsistency of assessment requirements for vegetation removal underneath the LS Act, such as private native forestry agreements that are approved without the appropriate ecology reports and are exempt from offsets. Council also has the concerns that with the lack of willingness by the New South Wales Government to accept data from Council update the New South Wales Biodiversity Values Map, despite the regulation saying that councils can submit data for consideration. I understand this is a resourcing constraint. In regards to the role of the Biodiversity Conservation Trust, it would assist councils if an annual report on an LGA basis could be generated that details the credits generated and retired. Councils could then review local controls to better respond to the impacts. The BCT is also responsible for the assessment and administration of biodiversity stewardship sites. Landholders report that establishing stewardship sites is complex, costly, and multifaceted. Additionally, given the lack of trading in the credit market, it's difficult for landholders to approximate financial incentives. The BCT should be better resourced to assist landholders through this process. Thank you.
Thank you very much, Ms. Whitelaw. And finally, Clarence Valley Council, who's giving that opening statement.
That's me.
Great, thank you.
Thanks for the opportunity to appear today. Clarence Valley Council initially made a submission for this inquiry as we have concerns that the current scheme is contributing to biodiversity loss in our area. So we have three main concerns: a net loss of biodiversity across the LGA through the application of the BOS. So the BOS is based on the avoid, minimise, offset hierarchy, with biodiversity gain at a stewardship site, theoretically compensating for biodiversity loss at a development site to achieve a no net loss of biodiversity. However, the application of the scheme has seen a loss of threatened species and habitat across the Clarence, and there's several reasons for this. Firstly, there's a lack of emphasis on the avoid and minimise, and all too often developers choose the offset option first because they can. Secondly, the BOS is overly complicated for all users, and often the offset option of paying into the fund is the easiest and most time-efficient way of satisfying an offset obligation. And thirdly, of the 4 offset rules listed by the BOS, the first 3 often don't apply in the Clarence, hence developers are left with payment as the only offset option. Our second concern is a lack of stewardship sites in the Clarence. So as discussed, payment into the fund is generally the path taken to offset development. However, the first offset rule is to retire like-for-like credits generated at a stewardship site. This is next to impossible in the Clarence, with only 2 stewardship sites established. Hence, a very small percentage of credits for our flora and fauna species can be retired locally. Following from this, landholders seeking to establish a biodiversity stewardship site on their land are met with a costly and complicated process. So in addition, the eligibility rules often exclude landholders in the Clarence from establishing these sites, as the area of remnant vegetation falls below the size recognised for conservation programs under the BCT. And to date, only 1 development has locally offset credits within the Clarence, so the rest have paid or are paying into the fund. And our third concern is a lack of opportunity for council to negotiate better biodiversity outcomes apart from payment into the fund. So the second offset rule includes funding a biodiversity conservation action under the ancillary rules with a corresponding reduced credit obligation. However, the list of species in the rules is very select and doesn't include any Clarence Valley threatened flora or fauna. So council has no opportunity under the current scheme to negotiate biodiversity conservation actions with the developer. So with little to no local credits available, payment into the fund results in a loss of biodiversity in the Clarence, and there's no indication that the payments are then returned to the BCT, or returned by the BCT into the Clarence in the form of conservation programs, compounding local biodiversity loss from the scheme. So we have 4 recommendations. Firstly, strengthen the avoid and minimise options to discourage offset as a first choice. Second, alter the eligibility requirements of the stewardship agreements to enable smaller areas of vegetation to be included in conservation agreements by the BCT. Thirdly, allow councils to determine biodiversity conservation actions that reduce the payment into the fund and thereby allow for locally driven, meaningful conservation action. And the BCT should be transparent regarding where the funds from the credit offsets are spent. Thank you.
Thank you very much for all of those excellent opening statements, which are essentially confirming what a lot of other local council, local government witnesses have also said. And thank you for your very excellent submissions. I'll go to the opposition first for questions. Ms Penny-Sharp.
Thank you. Thank you very much for your submissions, and I particularly liked the worked examples from the Goulburn Mulwaree example, which I think show very clearly the difficulties. And look, there's been just the theme has been the same throughout all of the councils, but with the tweak of where you are in terms of where your pressures are. We've got the government coming in this afternoon, and I'd just be interested for each of the councils. I mean, you've kind of touched on this. I mean, how do we fix the mess that we've found ourselves in? How have we ended up with such a complicated scheme? And what do you think, what are the practical things that need to happen? In the previous session, people talked about an audit, obviously, of available credits. People have talked about the need for like to be closer to where they are. But, you sort of touched on this. But if you were asking the questions this afternoon, what do you think we should be asking the government? I don't know who wants to go first.
Maybe let's start with Goulburn, and then we'll go from there.
Okay. Well, I'm a planner, not an actual biodiversity person, and I think my main concern is that a lot of our most significant biodiversity is actually in the rural zones, and so effectively having the 2-tier system of, one set of rules for the rural area and another set of rules for the environmental zones and the urban area is a clear weak point in terms of trying to work out responsibilities and having some clarity or consistency of rules across environments, which it's causing clear poor outcomes, because effectively the way it is at the moment, you have rural areas where the LLS provisions are very light and a lot of clearing can occur, then almost the next door you can have an environmental zone where, you know, you have to go through the whole BOS scheme, and it's a lot more technically difficult to do anything. This is also an issue in terms of the fact that, you know, with our urban areas, there's an expectation that there's going to be growth and high level of pressure on biodiversity in urban environments, which it's very hard to protect and conserve, and this is where the biodiversity scheme is stronger. Yet in our rural areas where we actually have this you know, expanses of really good environments, we can't protect them, and that would be typically where I would have expected we would protect them. So I think effectively going back to a regime where there's one piece of legislation that covers the environmental zones and the rural zones would be a good start.
Thank you. That's actually very helpful. Anyone else? Yes.
I'd like to add a little bit to that. I particularly like the Clarence submission about the problems with stewardship sites. So they've got 2 biodiversity stewardship sites in their local area, but apparently don't have none. So one of the big issues here is that, you know, people maybe want to meet their offset requirements, but they can't fund locally. They can't buy credits locally. And part of the issue, I've had a lot of feedback from landowners like the case that we've got a lot of big rural properties with good native vegetation. And one of the things I always do when I'm talking to them is to encourage them to investigate the idea of setting a stewardship site. And inevitably what happens is they go and do a little bit of research and they come back and say, absolutely not, it's too hard, too complicated, it's going to cost me lots of money up front.
How much does it cost? Can you give me a sense of, you know, for a property, are we talking $50,000, $100,000, more than that?
You're going to have to get a biodiversity assessment report done as part of setting up the stewardship site. And so we're usually looking at between $20,000 and $25,000 for a consultant to do that properly up front.
And that's for a small site.
That's for a very small site, yeah. And obviously, the bigger the site, basically the way it works when you do a BDR, the biodiversity development assessment report, you have to do a certain number of what I call band plots.
Yes. And
typically it works out 1 plot per hectare kind of thing. So if you've got a really big site, yes, it is scale, but the amount of effort required by the consultant, and the consultants are charging a lot of dollars per hour to do it, makes the cost absolutely prohibitive.
Yeah, for a single landholder who thinks, oh, look, I've got this nice bit of bush on my site, they're sort of open to, I mean, is the sense that you get from landholders that they're very open to it, but the system, the upfront costs and the barriers to participation, with those, particularly the uncertainty at the end, that you could go through all of this and still not actually be accredited, is that...
And then also, just how long it takes and how complicated it is and how long it might take to get some money back. So it sounds a great idea. So, you know, I was protecting bushland, I want to preserve it, I can fund it, have an agreement set up, and I'll get money coming in to maintain it and keep it as I want it. Sounds brilliant. But then they look into it and they say, no, it's too hard.
Yeah. Might just go to Clarence Council as well to see Clarence Valley, if you wanted to comment on this issue too.
Yeah, sure. So, I mean, for us, definitely it's that like for like. So, for example, with I guess an example of this is we've had 2 BDRs recently that are impacting the coastal emu, the endangered coastal emu. Mm-hmm. So there's no locally available credits, so they have to offset into the fund, which is over $3 million. And there's no cause for us to be able to negotiate with that developer. You know, don't pay all that money in. Instead, let's work with you to develop some really locally driven actions to help recover, that species on ground. And I mean, that money would go so far, but there's just no option. And the other thing is we can't get an answer out of the BCT. Well, does that money come back here? And well, I don't think, we've only got, I hope so. So that's not...
But there's no guarantee, you don't have a stewardship site. I mean, the coastal emus are extremely specific in terms of where they live. It's not like there's other places that you can be looking at.
No, they have a very restricted area, and that goes for a lot of our species and our vegetation community. So all that's left generally on the floodplain are smaller areas of vegetation, and these fall below what the BCT considers worth protecting. So whether that's even for a conservation agreement, say outside of the BOS as well, oh, that's too small. But I mean, you can trigger the BOS by clearing, you know, like a hectare, but you can't secure a hectare of these endangered ecological communities in a stewardship site agreement. So we're always going to have this loss. So that's one thing. I think if I could pick one thing, and that would be it, is to be able to, okay, well, if we can't secure this, then let council work with the developer to get some actions on ground.
I mean, sometimes 1 hectare might be very strategic in relation to a corridor, for example.
Oh, yes, definitely. Mm.
I will give Ms Whitelaw an opportunity to respond to this same issue, actually, if you want to. Yeah.
Yeah, that'd be great. Look, I guess the way I see it, yes, the scheme is complex. And back to my opening statement, I guess, about the Former Threatened Species Act, I actually don't have a problem with the being able to, the complexity of actually doing the ecology reports, doing the BDA, the Biodiversity Development Assessment Report, because, you know, it is a complex issue. And I think that actually by that assessment and finding out and calculating it and putting the value on it, I think it actually shows us the value of biodiversity. I kind of break it into 2 issues. I don't have an issue with the assessment, and definitely when it came in, consultants and industry and even councils were very much finding it hard to figure it out. I feel as though everyone is finding their feet a little bit more, both with consultants and developers and councils, with how to assess these things. But that's the assessment side of stuff that I don't have an issue with. It's complex. What I do have an issue with is probably what we're all talking about, is how the credits markets actually happens. And I'll echo the points of the other councillors here today about the stewardship sites. I've actually been looking on behalf of Coffs Harbour City Council at actually establishing a couple of stewardship sites on council land. And every time I look at it, it is so complex and so time consuming and so expensive. And if I can't kind of figure out and get the energy to find my way through it, how is a landholder meant to do it? I feel as though there needs to be more resources put into the BCT of actually helping the landholders to do this. But I guess, yeah, I don't have a problem with the complexity of the assessment side, because having worked in the Threatened Species Conservation Act, I wouldn't want to go back to something that was broken. I guess what I'm saying is I feel like the assessment side has improved.
Thank you. And Mr. Linton, did you have your hand up? Yes, you do.
Yeah.
Please proceed.
I just add, I mean, the statement that Heather read out, we had some recommendations there. So in answer to your original question, what would we...
Yep, yeah, I got those, yep.
Fix it, I guess.
That's them. And they were very good, thank you.
Yeah, and I just, you know, the process just needs to be made easy on the stewardship side of the equation. If the intention of the BOS is to not result in a loss of habitat, then that fundamentally doesn't appear to be successful. So something seriously has got to change in the way the BOS operates to achieve that objective. Yeah, I guess that's probably the bottom line, really.
Thank you. We've got, yes, we will go back to you, Ms Mitchell, and then Ms Catherine Cusack has some questions.
Okay, just want to add to that as well. One of the other side of stewardship sites is not every landholder who has the land that could be set aside wants it set aside for a stewardship site to offset development either, and that can be another factor in this as well. Just because it's available or could be turned into one, they don't always want it through development offset.
Yes, and that comes back to incentives in some ways, doesn't it? And the fact that how much they, well, for some landholders anyway, the value of that land in terms of doing other things. Ms Cusack.
Yes, thank you. I did want to, can I just ask Clarence Council a question that I've been very curious about? When the Pacific Motorway was put through kind of east of the old route, were those environmental impacts offset? I know it carved straight through koala habitat. And what happened to those offsets?
Well, it was a different system. So they sought landholders, so they put out it was almost like a tender where you put forth your land, and I guess it was sort of similar, but it was outside that BCT program, and I think the monetary returns is very attractive, I think, for landholders, and they would put out, advertisements for particular types of veg and for species habitat, that kind of thing. That's how they did that.
Did that come back to the valley?
Yes. So that was locally, generally, I think. Yes, they were looking for local offsets there.
Okay, I'm just curious about that system because I'm just wondering if did they have different legislation that enabled them to have more flexibility in terms of doing that? Yes.
Who are you yesing to?
Oh, sorry, who are you asking your question? Mr. Lenton, is it?
Yes, I'm sorry, my eyes aren't that good. So
that's okay. So Clarence Valley Council, yeah, you'd jump in. Yeah, this is the issue with these screens.
Look, certainly that the offset system that operated in association with the highway predated this legislation. I'm not 100% sure of the exact pathway, whether it was biobanking or some other measure, but most of the offset, well, a lot of the offset does appear to be local. There are a number of offset sites in the valley.
Thank you. Ms Whitelaw, I think you also want to say something?
Yeah, I guess I'm just bringing it into the current framework. So the Coffs bypass is sort of going to be commencing shortly, and we're having worked a little bit with Transport for New South Wales. They are retiring credits through the current scheme for the bypass, which will kick off shortly. I can say that one is that most of the credits are in the bioregion. Now, not all of them are in the Coffs local government area, but they're in the local bioregion. So I think Transport for New South Wales has made a big effort to do that, but for most, and they've been able to succeed with most of the credits. I guess that's actually a really good example, though, is in terms of Transport for New South Wales, with lots of resources, has actually facilitated landholders to establish stewardship sites. So it's not impossible if you've got the money and you've got the resources and the know-how, and there are landholders willing to do it, as evidenced by the Coffs bypass, but they needed a lot of help to get them through that process, which Transport was able to facilitate.
Could you expand upon what the help you're referring to in terms of the resources that Transport has and what they have been able to do differently as a result?
Well, I think what happened, and I guess I haven't seen it firsthand, but from what I understand from talking to some of the Transport staff, is that they actually facilitated the setting up of the stewardship sites on behalf of the landholders. So yes, the landholders needed to be involved and interested, but they coordinated the ecologists. And I don't know if they helped the landholders out financially as well, but it's my understanding they did. I don't know to what extent, but they facilitated that process. So it wasn't in the individual landholder engaging ecologists and dealing with the BCT. It was all very much facilitated by Transport.
Okay, thank you. Just back to Clarence Valley Council again, if I may, in relation to the coastal emu, which I know there's a lot of community action starting to spring up, which is wonderful, to protect it. But do you have any engagement at all with the Trust in relation to how those funds are expended or what the strategic priorities would be of Council in relation to the use of the offset?
Absolutely none. There's no communication at all with the BCT when it comes to the funds. I mean, they're difficult enough to get on the phone, and I know. I mean, they are lovely when you can speak to one, but But no, we've had no indication whatsoever that money will get spent on the emu.
Is there any consultation at all, at any level, with councils or any opportunity to make an input to the Biodiversity Trust in relation to what their priorities are? Is there any transparency around how they determine those priorities?
Not that I'm aware of.
And can you just perhaps, in relation to the coastal emu, just give a little bit more evidence about how endangered it is and how the tipping point that we appear to be at in terms of the future survival of that. I mean, the region is looking at a local extinction, isn't it? And which is disastrous for the species as a whole.
Definitely. So I think the last count there were 46 emu, and they're very restricted in their geographical distribution, and their range has really contracted. Even in the last 5 or 6 years, they really are just in the Clarence around Brooms Head. Yeah, it's a very, very restricted distribution. Lots of, I guess, by various impacts. Because they're a ground nesting bird, they're vulnerable to feral pigs and foxes and dog attack, not only when they're nesting, but with the chicks as well, because they have, you know, there's a bit of a prolonged period when the chicks are very vulnerable as well, and then car strike too. And bushfire.
I think they just lay their eggs on the ground and walk away, don't they? Which reflects the landscape before it was.
That's right. But I mean, you know, in terms of a species that has traditionally a very wide range, you know, they're very important in seed dispersal up and down the coast, and to have them, just restricted like that it's quite a travesty.
Thank you.
Thank you. We'll go back to the opposition, Ms Penny-Sharp.
And again, it's a question really for each of you, because I think the issues that you've raised around private land, particularly rural land, and the importance of the biodiversity that's on it comes directly into conflict with the evidence that we had from New South Wales farmers yesterday, which is that ongoing conflict about, well, this is their land and they have a right to farm it, and it's you know, the incentives and a whole range of reasons, that the system doesn't work for them, and that, I would argue that there's some resentment about even sort of, trying to deal with that. And in some ways, I think that the way that the legislation is set up through LLS and that division reflects the kind of political tensions within that. I'm just interested, though, that, as councils, you would be dealing with this all the time through DAs and all of that, and that cross part of it. I mean, aside from making it easier for landholders just to get involved in the system, I mean, do you think that there is just this general resistance to doing this, or do you just think that the system is so hard to navigate? I'm just trying to get a bit of your sense of it. You practically work with this particular issue all the time. I'm just trying to get some perspective from you on the willingness of farmers and landholders to do this, because my sense is that there's actually a great willingness and interest. Is it just that it's too hard, or is it just that there are some who just say, well, this is not our problem, this is our land and we want to do with it what we want? I'm just trying to get a bit of a sense about how you're dealing with that conflict, because that, to me, is really the legislation that we see, I think, is the political compromise of that conflict.
Go to Goulburn Mulmurray. I think you have your hand up, Ms Wall. We'll go to you first.
Yeah, look, I think it's interesting. We've got a culture here of where farmers have had a long history and involvement with land care groups and have been actually very active in trying to conserve more sensitive parts of their properties, and are very mindful of the benefits of actually retaining a certain amount of biodiversity on their properties. Where we're actually having trouble is not so much genuine farmers who have pretty much already cleared all the land here historically years ago, which is suitable for agriculture. It's lifestyle developments and chopping properties up for smaller lot sizes for rural residential properties for lifestyle lots, and then having to comply with the asset protection zone requirements and all the rest of it, or they just want to have a property that looks like an English countryside like the other historically cleared properties have. So in actual fact, it's not really the genuine farmers here who we have an issue with. They're actually quite well educated and very proactive in the land care groups. Yep. It's all the people coming from the cities who want to live in a little piece of English heaven by the looks of it.
And want to clear that block so they can build their house. Yes, Mr. Senator, go on. Mr. Fong. Yes.
So basically, as Kay said, historically, the good country land here has been cleared.
Yes.
The remnant vegetation is mostly on like hilltops and ridges, so there's steeply sloping land, really poor soils, highly erodible, highly fragile. a lot of it's classed as land capability 6 or higher, so it's not suited for cropping or clearing. It should just be left alone. And the long-established farmers, the farming families, the people who have been here for generations, they understand that, they value it, and they have no intention of clearing it whatsoever. It is mostly people coming into the area, cashed up people from cities like Sydney and Canberra, buying those blocks and then wanting to clear it, so that they have this perception that clear land is more valuable. They have this perception that native vegetation is dangerous, it's bushfire prone, it's full of snakes, and it's full of all nasty bitey things. And so there's this huge pressure of people coming in and wanting to clear it. Some of them sadly too have decided they can clear it all and put in olive groves or apple orchards or truffle farms. And they just don't understand the country's not suited to it. So as Kate says, the real farmers, the genuine farmers, wouldn't clear it. And the real farmers do like to see the wildlife. They do actually like to see koalas in the trees.
Oh yes, can I just say that my comments were not trying to say that. I'm just interested in that. The representative organisation, I just think that there's a conflict here around how this issue is talked about. And that what you've just said is exactly the sort of the experience. So I just want to be clear. I'm not having a go at farmers. I was just interested that the representative groups often have a more aggressive approach to the way they talk about these things, and that doesn't necessarily be reflected. So you've given me actually very good information. I might ask the other two councillors as well, because similarly, slightly different issues depending on where you're at.
Ms Whitelaw has her hand up. We'll go to you first.
Thank you. Look, I think that, and I can only speak for Coffs Harbour, but I think there is, you describe it as a philosophical point of view. I think that's true. And for Coffs, it's not necessarily about new people coming to the area in difference to Goulburn, but there is that philosophical view in terms of this is my land, I might have owned that land, or it might have been in the family for generations, and I want to do what I want to do with my land. I should be able to do what I want to do with my land. And you definitely see that with vegetation and biodiversity management. And you also definitely see that when you start to talk about the next issue with environmental zones as well. So that comes up a lot, and that's a very difficult issue. So I think some of it's just a core philosophical point of view. My land, I'll do what I like. But I guess what I'm saying is that I would like to think that if it was profitable or viable to establish stewardship sites, and I think that most of the time it comes down to to a point of view where if it's easy to do and there are enough incentives there to do it, I think you would find, in terms of some of those philosophical issues, would die away, and people would go, yeah, okay, well maybe that my back paddock there, which has always been vegetated or has regrown, and if it was viable, that they would consider stewardship sites or other incentives, and some of those philosophical issues might die down.
I think that's right, because you've also got the challenge of private native forestry. I mean, there's competing opportunities for different use of the land. Clarence, do you want to jump in on that one? Thank you for that. That's been really helpful.
Thank you. I guess our community, going back to what the community thinks about the environment, our community have shown in recent community satisfaction surveys that there's certainly wanting the environment prioritised and given much greater weight in decision making of this organisation. And if we look at where if there's hesitance around the scheme, I would say it's coming more from the development industry, like our Goulburn have indicated. We came from a system before where, as Sally has mentioned from Coffs Harbour, that the TSC, the Threatened Species Conservation Act, didn't really put a great obligation on developers in real terms, and now the BOS is actually making them address the real cost of their development from a biodiversity point of view, which is a reasonable thing to do. And there's certainly some strong dissatisfaction, I would suggest, from a good part of the development industry around the new process, because it is a relatively new process and it does require them to invest more capital into upfront studies and the like to determine what the real impact of their development is. So I would say it's not so much an issue with our rural community, because I guess the rural clearing doesn't typically trigger the BOS I would suggest. It's really the development-related clearing that's...
No, thank you. That's helpful. All three of your answers sort of cover the diversity, I think, of the pressures, and so that was really helpful for me. Thank you very much. I don't have any more questions, though. Okay. All right. Thank you. I've got one that just in relation to, we heard from the previous witnesses from Port Macquarie Hastings, previous witness from Port Macquarie Hastings Council, just about the impact of private native forestry in the area, and the Coffs Harbour, Ms Whitelaw, your submission states that the impact of private native forestry and the fact that private native forestry is exempt from any offsets under the biodiversity offset scheme. Would you just care to comment about that and whether you think it should be, and would it help with ensuring that the impacts of PNF were offset if possible?
Yeah, look, it's a really tricky issue, and back to the point we were talking about before. You definitely get a lot of objections to that. It's a huge concern, private native forestry. So when I look at the areas that are affected or approved private native forestry approvals across the LGA, it's huge. And obviously, they're the vegetative areas, otherwise why would someone want to be logging it? And that pressure is skyrocketing because of the construction industry is going, housing is going into ramping up, and so the demand for timber, and then after the bushfires as well, there's an increased demand for timber. So PNF is massive, and I'm really concerned about the impacts. Now, and it's not even, about the offsets for it, it's even about the assessment. The assessment is negligible, I can really say that. And they don't do targeted flora and fauna reports. And I know we're still waiting on a revised code of practice, which doesn't seem to be coming anytime soon. But going back to what's been said before, it really is two different systems. One, you've got the development under Part 4 of the EPA Act, having jumped through a lot of hoops, and then you might right next door have a private native forestry or a rural boundary clearing code. That was the other thing that came in recently that has had big impacts in Coffs Harbour. 25 metres either side of the boundary fence being cleared with no assessment. It just seems like there's two different systems, and I'm really concerned about the impact. Now, whether or not you could do offsets through a PNF agreement, I mean, they do avoid, riparian areas and rainforests, but it just seems like there is a real risk of biodiversity loss.
Thank you. Thank you very much. We've got one final question by Ms. Cusack.
Yes, I'd just like to ask Goulburn Valley Council, again referring to your submission, you've spoken about the need for greater education and listed the different people who need education, and given an example of somebody who was actually doing their due diligence on a purchase of property before exchanging contracts, and contrary to the information they'd been given by the real estate agent that the land was basically ready to develop and council supported that. In actual fact, it turns out it's got high biodiversity values. In terms of raising awareness and ensuring that potential purchases of property, I mean, this idea that ignorance is a defence, I guess, just trying to address all of those issues. What is the solution? Should we be as part of the conveyance process, putting biodiversity values on the land as part of the being attached to the title of the land? Should we be asking councils to undertake education, or how would totally agreeing with your recommendation, I'm just wondering how you would implement it.
Okay, well certainly from our council's point of view, we've recently had a media campaign where we got the mayor to say, if you want to clean that vegetation, for goodness sake, ask someone first, and try and explain in brief terms, what rules apply to what land. And we had a bit of a campaign on Facebook too. And a large one of my roles is just getting out and spreading that message. So we are definitely doing as much as we can here. but my feeling is that it needs to come from higher up, so Biodiversity Conservation Trust, and possibly, as you said, part of the whole PA process of all the paperwork. It needs to go out to all stakeholders. And who, we could do a certain amount at our level, but what my feeling is it has to come from higher up, and probably Kate might want to elaborate on that.
I'm afraid we actually have, I'm so sorry, but we have run out of, I am so sorry to do this, but the time is up for this session. So thank you. And we could, as usual, we could keep asking our fabulous local government reps questions on this all day. So thank you so much for appearing before the committee today, for your work in this space, for your excellent submissions, and the Secretariat will be in touch with any questions you may have taken on notice or supplementary questions. So thank you again for appearing, and we'll call our next witnesses. Thank you. And here is okay, let's proceed firstly. So we'll just welcome you to this next session, and what we do at the beginning is make sure everybody is sworn in. So we'll start with Peter and Ruby Dykes, who are in the room with us now. Welcome, both of you. We'll start with you, Ruby, let's go with you first. So if you are able to state your name and position, title, or whatever you want to say, as well as your opening, sorry, not your opening statement, as well as swearing either an oath or an affirmation. So that's the words in front of you. So just your name and then your your affirmation or oath. Thank you.
Okay. My name is Ruby Dykes. I solemnly and sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you. Mr. Peter Dykes, you're next.
My name's Peter Dykes, and I solemnly and sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you very much. Now we'll proceed to the witnesses who are giving their evidence virtually. So we'll start with the Henry Bark witnesses. So Greg, if we can start with you, please. I think you'll have to unmute yourself. Thank you.
Sorry about that. My name is Greg Steinbaker. I'm a director with Henry Bark, and I'm also a practicing ecologist. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. Thank you.
Thank you very much. Judy?
My name is Margaret Steinbaker. I'm chairman of Henry Bark and an accountant. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. Let me go.
Thank you, Ms. Steinbaker. We now have Mr. Andy Davies.
My name's Andy Davies. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but it.
Thank you very much. And Louise, Mrs. Louise Davies.
Louise Davies. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you very much. Now, witnesses have an opportunity now to make a short opening statement before we proceed to questions from members of the committee. So, Ruby and Peter, we'll start with you, if that's okay. Do you have an opening statement there, Ruby? Thank you.
Firstly, I would like to acknowledge the Gadigal clan of the Eora Nation whose lands we are meeting on today. Also, I'd like to acknowledge my ancestors and my elders past, present and future. Secondly, I want to express an opinion that biodiversity conservation is not just about the preservation of plants, animals and stones and bones. Aboriginal cultural landscape also plays a major role in this vast environment. We have our Aboriginal spirituality enveloped in our dreaming tracks and our songlines, our birthing places, our waterways. Landforms and in our plants and animals are our moieties, spiritual beings, and they are everywhere. The earth is our mother that gives us life. The sun and the waterways are the providers that sustain us and the whole environment. Please, when considering our submission, consider our cultural landscape, which encumbers our Aboriginal spirituality. Thank you.
Thank you very much. Peter, did you also have...
Yeah.
Yes.
Thank you for allowing us to speak at this inquiry. We are an Aboriginal family with 15 members having a very strong cultural link to Trickett's Arch and an extended family network of not less than 40 persons having a strong cultural association with the property. We have owned Trickett's Arch for 40 years and it has cost both of us dearly to keep it. For me, it cost my first marriage and our house in Orange. In May this year, I stood with my daughter at her mother's grave in Condobolin to say goodbye. For Ruby and I, it has cost Ruby her house in Burke, all our life savings, all our super money, plus a great deal of stress and heartache and emotional strains to keep the property we both love in family ownership. We now live and manage on Centrelink pensions while looking after our grandchildren, Michael and Matthew. We undertook a biobanking conservation agreement because we wanted to firstly have the funds to properly manage the property, to pay for the fencing, the weed and pest control, the provision of fire breaks and maintenance of access tracks, the rehabilitation of degraded and cleared areas and lots of other things needed to manage a rural property for biodiversity conservation. And secondly, because we wanted to provide for our children and our grandchildren the means to keep the property in family ownership. At the heart of our problem is a lack of money to manage a property for conservation. We were completely dumbstruck to find that the Kyoto Treaty excluded native vegetation from being used for carbon abatement credits and in effect consigned it to economic garbage. Since the beginning of the biobanking process in 2008, with funds provided Land Alive, to say that we have struggled to sell our biodiversity credits is a huge understatement. We have had to go into battle against a bureaucracy and a community that by and large don't believe in biobanking and or that landowners should be paid, let alone make a profit for managing biodiversity. The advent of the BCT in late 2017 and its current foray into the biodiversity credits market has made a very hard situation into an absolute nightmare for us. Here I would like to table a spreadsheet and an email I sent to a department office to show just how difficult it has become. Also, I would like to table a one-page document on what we see as an essential changes needed in the biodiversity offset credit administration.
Thank you very much. That would be very helpful for us. Is that the end of your opening statement?
That's it. And
thank you very much.
There's the...
We'll get to questions for you soon. We'll just go to the opening statements of Mr. and Ms. Steenbecker. Do you have an opening statement to make?
I do. Thank you, Chair.
Thank you.
I seek to dedicate my appearance here today to my friend and colleague, Glenn Turner. Glenn was murdered by a landholder who saw habitat as a hindrance, not an asset. This view is held by many people in regional areas who don't see advantages of having native biodiversity under them. This inquiry largely arose from reports about windfall gain made by people with expertise. There are many errors, mistakes, omissions and untruths in the reports. Returns for caring for the land are a tenth of those developed into small acreage lots, as abound in Razorback. It would have been lost to any conservation outcome and no one would have batted an eyelid. It is specialist knowledge, as is designing roads, undertaking surgery or providing legal advice. Yet engineers, surgeons and lawyers can own practices to present these skills without any expectation of operating at arm's length. Planners in government and real estate agents can own property and know of development plans but not be benefited. Assessing biodiversity and doing something that protects it should not be separated from each other. EPIE recently introduced a protocol to restrict employee interactions with people who have knowledge of BOS from a lived experience viewpoint. Their submission is now in error and misleading. As an expert ecologist and BSA owner, I cannot advise employees things that will improve the scheme. Even as a volunteer, I am considered an employee. While not perfect, BOS provides an opportunity to address ongoing law and claw back losses when land is best managed for outcomes related to nature. It is still maturing in its application and as yet is barely in play. The BOS is a means of valuing impacts to biodiversity. Its purpose is economic, not ecological. For projects where BOS is triggered, it is doing the best job possible towards halting loss. Some think the scheme applies to all clearing, but it does not. It is also hard to judge a scheme when media speak to a previous process or one totally separate. The Clumping Declaration has been signed by the Australian Government. It calls for financial implications of biodiversity interactions to be considered and is likely to be mandatory for financial institutions by 2024. The BOS provides a way to value nature-related financial disclosures and helps achieve conservation efforts. Use of the scheme ensures that biodiversity impacts are assessed by someone skilled at the task. A plumber can look at your arteries and see them as pipes, but would you trust them to undertake bypass surgery? Why should biodiversity be considered anyone can put, simply because we all have ongoing and lifelong experience with it? Biodiversity is very complex. A BSA has the same status in terms of security as a national park. It is perpetual on the land title and binding on the landholder. Unlike a national park, the costs for all future management forever is put aside early in the process and drip-fed back to the landholder to cover costs. There is no risk of Treasury or the ERC reducing or rejecting the funds required to manage it. The costs of all future management are borne by the developer whose impact needed the offset. No funding comes from taxpayer sources unless they are the developer. Private landholder participants consider lost productivity, costs of entry and participating, taxation, risk, and the demand for their credits. A credit is a measure of a unit of effort to improve habitat up to a limit the tools say is achievable in 20 years. After 20 years, if more improvement can be achieved by more effort, then that should be allowed for. After all, why leave a job half done? The role of the BCT is complex and influential well beyond its remit. They stymie the market by acting as a middleman in almost all transactions and charging developers the best average cost rather than the premium price they were meant to, so degradation continues. The cost of credits is not an impediment to developers. The highest priced credit in benchmark condition will still only add at most $370 per square metre to the costs of development. But development rarely impacts best condition habitat. If costs of impact were higher, more avoidance would occur. Actions undertaken on the sites help to build and maintain skills in the community and create employment. Farming biodiversity is a term I use for stewardships, and that is how they should be viewed. Biodiversity as a financial asset. Thank you to the committee for hearing me out on this extended opening statement, and I'm sorry I didn't have time to make many recommendations, but look forward to that opportunity.
Thank you very much for that comprehensive opening statement, Mr. Steenbecker. We'll now go to the Davies, who's making the opening statement for you.
I am.
Okay. Please proceed.
Thank you for allowing us to speak at this inquiry. I represent a group of landowners from southwest Sydney and northwest New South Wales. The pre-2016 biobanking scheme operated as a free market. Under this scheme, I've seen multi-generational farming landowners pay down farm debt, invest in improving farm infrastructure, renovate homes and be able to plan for the future without the threat of subdivision or sale of their land. I've seen small businesses created and increased investment in regional areas. I've seen an increased understanding of the value of native ecosystems and their role in whole farm systems. I've also seen developers' profit margins impacted by less than 1%. With the introduction of the Biodiversity Conservation Trust, the new biodiversity assessment method and the biodiversity offset payment calculator, these opportunities have been severely impacted and transparency and trust eroded. The biodiversity assessment method returns roughly 1/2 to 1/3 the number of credits per hectare in comparison to the old biobanking assessment method. This reduction in saleable product, along with a reduction in credit price per hectare, a price determined by the biodiversity offsets payment calculator, has resulted in a less profitable scheme and, in my experience, a reluctance to engage in conservation agreements. An opportunity to bring about real conservation and regeneration of native ecosystems, along with increased investment in regional areas, has been curtailed through government involvement and market control. Previously, direct communication was possible between buyers and sellers with the assistance of government agencies. However, it now appears that interference has been done by government agencies. In some cases, government agencies are positioning themselves as the only buyer of credit. An increasing lack of transparency, for example, total lack of communication regarding our funds held in trust for annual payments, no information on how credit prices are being calculated, massive delays in annual management payments, and great difficulty in communicating with ECT, and the manipulation of a free market will lead to poor outcomes and a lack of real conservation statewide. There has also been a complete lack of landowner involvement in decision making. While some dodgy deal brought the scheme into disrepute, as landowners committed to the protection of our native biodiversity, we feel this is a minor issue. The real issue is looking at the free market operation of the scheme through government involvement. Thank you.
Thank you very much for those opening statements. We'll now proceed to questions. We'll go to from... I don't even know if he's there yet. So I can... Oh, no, you go. Oh, no, you start. It's fine. All right. I just wanted to go to you both, Mr. and Mrs. Dykes. Thank you so much for, again, for making the effort to come and talk to us. And I'm very glad that you did get wind of our inquiry. I understand you heard about it a bit late in the piece. So could you just explain a little bit about the particular species that you, the Trickett's arch, buttercup, double-tailed, 9-10. So what happened? Can you just talk us through what happened with that? You've got the land, you found out then that you had this particular threatened species on your land. Talk us through what happened then.
I suppose I'll give you a little background.
Yes,
I'm a caver, and I've been that since I was 16. And I visited the Trickett's Arch property in 1973, and I got the opportunity to buy the property in 1982. It's 360 acres. It has a unique limestone cast feature, which is the arch. It's not really an arch, it's a limestone bridge. We were unaware, as a caver, was unaware of the biodiversity value. When we undertook in 2008, we got funding from Land Alive to actually do an ecological assessment, and that began in 2009. And it was in December 2009, they came back to look over the property and found that we had identified buttercup double-tailed Diurus equalis, and at that time there had only been 200 individual plants found at 20 sites, and they found 431 at our place in what amounts to one large site. That's now been increased last year to just under 500 individual plants. We made a big mistake, as well as on the ecological assessment, identified a number of bat species, powerful owl, as a caver, we had some biologists. I already knew there were bats on the place and powerful owl. We should have got credits for the powerful owl and the bat because we could have sold them. But we decided the buttercup was so rare that we went and got an ecological assessment done with Land Alive funding and created 910 credits. And we've never been able to sell those credits, basically, because no one really wanted them. And it's interesting. Greg has made me aware that under Saving Our Species, that the Commonwealth funded some program to look at saving this species, and I've only just become aware of that in the last week, and literally no money ever come to us. What we've did, we tried initially to sell the credits. Land Alive came around about 2000.
Can I just stop you there? Yeah, okay. I'm just interested in when you say you tried to sell the credits, how do you do that? What happened? Do you put it online? Do you... Yeah, take us through that.
That's been, to put it bloody hard.
Yeah.
Excuse me saying that.
No, that's exactly, but that's exactly sort of what we're trying to understand.
We anticipated that when we got funding for Land Alive, we had two very, very capable Aboriginal elders running it, Marcy Ellen Duncan and Robert Clegg. And the program came around in 2008, 2009, and by the end of 2010, it was gone. And we thought that they would help us make contact to sell the credits. And always our market was a philanthropic market, a company willing to put money into biodiversity. And of course, after that, as part of that process, which I only have, we developed a booklet that went into everything that's on the property. And the property not only has biodiversity, as Rube said, it's got Aboriginal sites, it's got pioneer heritage mining sites on the place, and it's got a large karst area with approximately 80-odd karst features. And we thought we'd be able to sell it, but the market, how do you... Once Land Alive was gone, no one seemed to want to help us. Neither Department of Ag, neither Department of Environment, which were the two, and neither anyone, planning, no one. And that made it very, very difficult.
I was wondering, whether you could talk us through a little bit. You've got the spreadsheet here, and without explaining a little bit to us, is that okay? The
spreadsheet actually highlights the problems that Greg and the other lady, the other person are actually talking about. The top part of our spreadsheet lists, in the first bit, lists our credits, right? Now, we've made 2 sales. The first sale, the bottom part shows the sales, and the first sale we made was to North Connect, and we sold 48 credits to North Connect. That was, I should say, there are 2 things. There's biobanking, which are called BBAM, and then there's BAM credits. And if anything is more confusing, anything is likely to say, I don't know who dreamed it up. I'd like to take them out and shoot them. Not meant physically, but that's how I felt. We sold them at $2,000. If you'll notice, it's HN 590-1197, right? And it's on the bottom of the second spreadsheet.
Yep, got that.
And we sold them for $96,000. However, because there were no workshops, nothing in 10 years, we were unaware that the BCT calculator was actually $4,600 for BAM credits, not biobanking. So the next 2 coloured, the ones that are the yellow and the purple, they show what we would have got if we'd sold the whole lot of our remaining credits, which were 50. At 2,000, we would have got $100,000. However, that $100,000 equates in BAM credits to $3,226. If that's the purple. If you sold the 50 biobanking credits, you get 100 grand, and if you sold the same, which are 31 BAM credits, you get the same, roughly the same amount. But that's less than what they're actually the BAM credits are worth, right? We would politely taken as suckers. That's my view.
So just to be clear then, because we actually did hear from a witness yesterday with a completely different species, and we were wondering whether this had occurred with other species. So it's very fortuitous that you are here today explaining this to us. So it's the $3,226 there that you would have realised if you sold everything.
What I'm trying to do, you've got two systems and two system pricing. You've got to try and figure out how the two merge.
Yeah.
So if you look at our remaining 50 credits, 50 BAM credits, that equates to 31 BAM credits.
Yeah.
So 50 credits times 2,000 gives you $100,000, and 31 BAM credits at 3,226 gives you $100,000. So we were, in a sense, they're currently 4,006. We were lost. But here's where it really gets interesting. We then had the BC earlier this year, or late last year, about this time, offer a fixed price offer to buy credits. And we had HN 558, the narrowleaf peppermint. And we sold 46 of them, and that 46 gave us two at $6 grand. We'd finally said these things are underpriced, let's sell them for $6 grand, and they did. You know, Ruben and me nearly dropped over. We sat down and had a little heart attack in the kitchen when they actually accepted it. So we then figured that the whole 109 credits that we had, biobanking credits, were worth $654,000. However, if we'd sold the remaining ones to get the same amount, the BAM credits, we'd have to get $17,211. But the current price for that remaining is actually $4,600. So we would make, if we had sold them at the current calculated price, we would make a loss of $479,218. Right? And that's sort of explained in this email that, please don't, I sent it to Benjamin Tom. I've got no problem with Ben. Ben asked for me to send this to him as part of an investigation. Now, things get actually really interesting because, in effect, the remaining other credits don't appear to be able to be sold. And one of our problems is that we've undercosted our total fund deposit. Instead of 1.74 million, it should have been 2 million. Because again, we didn't realise that. When you allow for all of this, we end up with a Part B payment of $502,000 if we sell all the credits at the current BAM calculator price. That $502,000 sounds a lot, but we've got to build another house on the property. We've got to have a tractor and agricultural equipment, and we've got to fix up the existing residents. And in effect, the $502,000 is going to go out. So we don't just to do all of that. But the really interesting thing...
Thank you.
Hang on, there's one last thing I need to say. The really interesting thing is in July this year, a lady from an assessor contacted me to buy the same credits, HN 558, PCT 963, the narrowleaf peppermint. And I said to her, it's $6,000. And she was there discussing whether to buy our credits or put them in the calculator. They evidently decided to put them in the calculator. So recently, only in the last fortnight, the BCT has got a fixed price offer looking for these credits, PC 963 narrowleaf peppermint. It has 22 of those. I have 22, but it's looking for 37 of those credits at approximately, they've put in at $4,600. They've paid their total payment is $170,200. Now, if they bought our credits or bought what they need at our price, they would have paid $636,400. And the BCT has got a payment of $170,000 when it should have got a payment of $636,000, put their markup. Someone is going to take a $500,000 loss. It's either us or the BCT when they try to fulfil their credit requirement. And that's the problem, to put it in real perspective, of why we want the calculator thrown in the garbage tin.
Thank you very much, Mr. Dykes. That is very well explained. Did you pull this? Is this your work? This spreadsheet?
Yeah, that's
well done. That's that's excellent for us.
And you need to read it with the.
We'll sit down and certainly go through that. I might just conscious of time and that we've got other witnesses online and members to ask questions. Actually, Justin, Mr. Field, do you have questions?
I do, thank you.
Great.
Actually, I have a question. I think if I'm pronouncing this wrong, let me know, but Mr. Steinbeck, is it? Steinbaker, sorry about that.
It's all right, happens all the time.
Your submission, I'm sure. In your submission, you make a comment towards the end that you've been seeking to go through the variation process to add certain species credits to your agreement. You indicate that you've been stymied by the Biodiversity Conservation Trust for a period exceeding 8 months. Could you just expand on that? What is going on there? What's your experience been with the BCT?
So up until September, I was an employee of the Department of Planning, Industry and Environment in a number of roles, but basically for the last 27 years I've worked for it and the 15 government agencies that have predeceased it since I started with the Department of Water Resources in 1994 in Dubbo. Being a departmental employee, complied with all of the required conflict of interest declarations and all that to ensure that my processes were all available and publicly, or were available to the staff that were undertaking management inquiries and so on. So there was no hiding of my involvement in the scheme. In February last year, as the site was recovering, we were fully burnt out on October 8th, 2019 by the Busby's Flat bushfire. Literally all of our 213 hectares was burnt. We put into the BCT when we started noticing in the recovery that we had a number of threatened species, and we're up to over 40 threatened species on our site now, which is pretty impressive when you consider it's. We had a number of species turn up where there's a potential for credit sales to be undertaken, such as redback buttonquail and Rotala tripartita, which is an SAII species, but which we believe should still be in the market. The application, or the initial opening discussions were held with one of the BCT staff in January of 2021 to try and clarify putting in a variation, including for one of the species that is on their fixed price offer list and has been since that time, being Persicaria elatior, which we have on the property, and we have a number of plants on the property. So I started talking about doing a variation on our agreement to add 5 more species and vary the numbers on 2, which had, because of the initial way in which the application was done, we undercounted our slaty red gums because we knew that there were 2,500 plus, but we could only realistically say comfortably that there was at least 1,000, which was one standard deviation or half of one standard deviation value below the mean based on the analysis of the numbers of plots. So I worked out that roughly 1,000 could be used by our assessors. We had all of our work undertaken by third-party assessors, so even though I'm an accredited assessor and have been involved in the design and construction of the schemes for the last 14 years, I step aside and provide technical input and expertise as an ecologist, but it is not my work that is actually what is presented. So our ecologists consultancy decided that it was safest to ask for only 1,000 individuals of slaty red gum to be counted, even though we could say that we had probably around about 2,500, but the standard deviation, so the variation in statistical means, was around about 1,000. So we could say that we were comfortable that there was a 97% chance we were wrong, but that 97% chance was that there were more than 1,000 on the property. I've since counted 2,240, and I've still got 15% of the property to go, so I was well and truly under. But variation we put in to get to add these species, and the person at BCT had said, yeah, sure, I'll get back to you. In April, we got a response saying it's gone up to the BCT administration to have them make a determination on whether you're actually eligible to seek a variation because you're a departmental employee. Even though everything is done under conflict of interest and was all openly declared, and I excused myself from meetings where the species were involved and all those things, they still wanted full probity on it, which is fair enough too. But to actually stymie and exclude me from the process simply because I'm an employee of the 3rd largest department in the state, which also happens to have that BCT under its same umbrella, but operating as a separate entity, is realistically a little bit of a situation where they had tried to apply a case of discrimination that wasn't established and wasn't based in any legislative option. And therefore, when it came through to continuing to this very, it was not until a month after I left the department, so in mid-October this year, they actually said, yes, you can actually do the variation. Now, to do the variation without getting any penalty, because we still have our site not yet active, so we aren't doing any management activities beyond what we have to do to maintain it. We still owe, it's about $2 million until we break even on our site. So that's to pay into the total fund deposit and to pay the assessors and to pay for the cost of purchasing the land in the first place. So we're $2 million of sales yet to happen before we even make a penny out of the site. And for all of that, they said in October, yes, you can do it now. But the trouble is, we have until mid-January of next year. So basically 2.5 months to do the full assessment required for these 7 species, to get them written up in a full biodiversity stewardship assessment report, a full BSSAR, to apply for the variation. So we've acquired the services of a consultant to do that work for us, but that consultant is again behind the 8 ball because there's this tiny little period of time in which that variation can be done, and it's only now being allowed to be done because I'm no longer employed by the department.
Thank you, Mr. Steenbecker. I am sorry, but we are really pushed for time. I'm sorry to interrupt you, but I'm conscious we have more questions and more witnesses to also speak to. And I wanted to assure everybody that your submissions are also taken into consideration and are excellent if we don't get, which we won't, get enough time to ask you everything we want to ask you. I did just want to go to our other witnesses. Mr. Davies, thank you. If I could just ask, just for you to expand, I know it's in your submission, but verbal evidence is very good in this regard, but you really are stressing this kind of manipulation of a free market, if you like, and you mention in here the key points around market imperfections. It's probably safe to say that most people on this committee aren't that great in terms of what all that means and looks like, and you are the experts in this area. Can you just expand upon some of those key points in relation to the market imperfections of the biodiversity offset scheme?
Well, I mean, the offset system is basically there to, at the end point, make it prohibitively expensive to clear an ecosystem top. So, and that was what was happening under the old scheme, particularly with Cumberland Plain woodland credits. The price was going through the roof rapidly because of demand and supply. What's now happened with the Biodiversity Conservation Fund, under the new Cumberland Plain Conservation Plan, the biocertification, which is basically a lump sum per block, I believe it is. The developers just pay that into the Biodiversity Conservation Fund and then move on. They don't actually need to offset anything before they clear. What that's actually doing is it's playing around with the demand and supply metrics. So, demand is only coming from one buyer, being the BCT, as opposed to multiple buyers interacting with multiple sellers. You've got one buyer cherry picking which credits they want to buy.
Yep, thank you.
Can I say something?
Yes, of course you can.
The problem comes is that one buyer has now become a monopoly, and the best way to describe it is developers, whoever they are, wherever they are in the state, no longer go and try and source credits either from people with existing biodiversity credits up or people who have got an expression of interest to create a biodiversity credits. They in effect go to the calculator and they say 4,600 for BAM credits. We need 10. Here's your $46,000, you beauty. We go and do the development. The BCT's then got to find those credits, and it goes back to the marketplace and someone says, oh, we're not going to sell them for $4,600. We want $10,000 a credit. And someone is taking a loss. Either it's the BCT or it's the individual. Now, if, as I put in one of my recommendations, is that developers should test the market, and a calculator should only be used when there is either no credits on the market or there's no expressions of interest by landowners to create credits. And that gives, we get the full market price, because the other problem is that in creating a biodiversity site, such as ours, for instance, there are a lot of credits that may never be sold. And, you know, each site can have multiple numbers of vegetation communities, some of which are obviously not going to be sold because they're on rocky hills, and who wants to clear a rocky hill? Or they're along a river course, and you can't clear along a river course because you've got to come back 30 metres or 50 metres. And so it's really the credits that are on the plain and on the slopes in the landscape that are actually wanting to be cleared. And most properties have a multitude of these type of the credits over different landforms. On top of all of that, the biodiversity BCT is out canvassing for philanthropic donations. It's out running the stewardship agreements. It's literally, I say this, it is literally a textbook monopoly straight out of Adam Smith and John Maynard Keynes' economic textbooks. And we, as individuals, are fighting a monolithic group to try and sell our credits.
Thank you. It's very powerful evidence. Go to Mr. Steinbecker. I understand you've got your hand up as well. Okay.
I did. I just wanted to support what Peter said there. The VCT realistically is only required to come in when there's market failure. That is, there's no credits in the market or no EOIs available for those credits. The way they operate to get best average price stymies the market. It provides an artificial pricing on the market, and originally they were intended to provide a premium price. They should only be buying obligations from people who can't source the credits from the market. Yeah, otherwise, they've got to get them from the market themselves, whether they create the site or whether they buy them from suppliers like ourselves. My recommendation is that the VCT only provide credits that are not in the market. And there are others, as I said, I'm happy to take on notice for other things I'd like to recommend.
Thank you. And I just, Louise, did you have your hand up as well?
Yes, I did. It follows on from what Greg's saying.
Sure, yeah.
Is that we're flying blind because they're sending out a fixed tender price. The VCT tenders a fixed tender price. There's no negotiation at all.
Yes.
They're setting the price.
Yes.
And that's a big stake to me.
Yeah, I understand. Thank you. We have we're technically out of time, but we will have one last question from. You sure?
Oh, no, it's okay. I just wanted to particularly say to the Davies that they actually had a very detailed submission, and I did not get to ask them very much about it, but I have read it, and there was lots of things in there that we'll pick up. So as we run out of time, I won't get you to expand, but to thank you for your efforts because it's been very useful.
Yes, yes.
Can I just have one thing with these VCT agreement, with these biobanking agreements, some people are not selling all their agreements, in our case, for over 10 years. And the total fund deposit was based on prices in 2010. It's now irrelevant. Yep. And there's some people don't sell any of their credits for, it took nearly 8 years for us to sell our first set of credits. There needs to be a low-cost, I agree with what Greg is saying, there needs to be a low-cost administrative procedure to reprice the credits and reprice the total fund deposit. And particularly where credits, where a biobanking site hasn't got a TFE, total fund deposit after 10 years, the whole economics of that site needs to be reassessed and done at a low-cost way.
Thank you. I am so sorry to do this, but we have run out of time for this session. Can I thank you all for your submissions and appearing, and can I say that we will very much take into consideration your submissions and evidence and may be in touch to discuss these issues further given how short this time was today. So I do want to assure you that despite you probably feeling like you didn't get much over then, I think some of the witnesses, I'm sorry about that, but we will absolutely be in touch, and the Secretariat will contact you with any supplementary questions that members may have to ask you, or any questions you may have taken on notice. So thank you again for appearing. The committee will break for lunch now and we'll be back at 1:15. Thank you so much. Thank you. Okay, we will now kick off our next session with our next witnesses. So thank you all for appearing. We'll begin by swearing you all in. So if we could start with you, Mr. Elton, your name, position, title, and either an oath or an affirmation.
Yes, thank you. My name is Paul Elton. I'm the Chief Executive Officer of the New South Wales Biodiversity Conservation Trust. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth. Thank you.
Thank you very much. Mr. Knudsen.
Thank you very much. I solemnly, sincerely, and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you. If you could also say your name and position title.
Sure. Dean Knudsen, Deputy Secretary of the Biodiversity Conservation and Science Directorate.
Thank you very much. Ms. Dumazel.
Michelle Dumazel, Executive Director, Biodiversity and Conservation. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. And finally, Dr. Mamouni.
Dr. Louisa Mamouni, Director of the Biodiversity Offsets Scheme in the Department of Planning, Industry and Environment. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much. Now there is an opportunity to make opening statements. Yes, Mr. Elton, you're nodding. Would you like to begin?
Yes, thank you, Chair. I would like to make a short opening statement. I would first like to acknowledge the traditional custodians of the land where we're meeting today, but also right across New South Wales, and pay my respects to their elders past, present and emerging. The terms of reference say this inquiry is considering the role of the Biodiversity Conservation Trust in administering the scheme and whether the trust is subject to adequate transparency and oversight. Appendix C in the New South Wales Government's submission to this inquiry provides extensive information about the BCT's roles and how the BCT is governed. Just to be clear, it's the Minister and the Department that administer the Biodiversity Offset Scheme. The BCT does not administer the scheme. Instead, we have 4 specific roles under or as part of the scheme under the legislation and regulations. So our 4 roles are that we enter biodiversity stewardship agreements with landholders who may be wishing to generate biodiversity credits in accordance with the requirements of the Act and regulations. We manage the Biodiversity Stewardship Payments Fund, and subject to compliance, we make annual payments to agreement holders. We acquit offset obligations transferred to us from development proponents by way of payments made into the Biodiversity Conservation Fund. And finally, we procure biodiversity credits under various place-based offset schemes, such as the Western Sydney Growth Centres program, when we're commissioned and funded to do so by the department. Appendix C in the submission goes into greater detail as to how we fulfil those 4 roles and the outcomes we've achieved to date. The terms of reference also ask whether the BCT is subject to adequate transparency and oversight. I contend that the BCT is subject to the highest standards of governance, integrity, transparency and accountability. The BCT is required to operate in accordance with a business plan approved by the Minister, and we're required to produce an annual report tabled in Parliament. We're managed by a governing board comprising independent directors, which is in turn accountable to the Minister. The board receives advice from an audit and risk committee, including an independent chair and independent members on financial management, funds and investment management, and audit and risk matters. And we're subject to numerous governance requirements or instruments, including a board-approved risk appetite statement and risk management framework, internal audit, probity frameworks, and external audits by the New South Wales Audit Office. So I hope we've demonstrated the BCT is subject to very rigorous transparency and oversight. I would just quickly like to clarify 2 matters that have arisen in the hearings to date. Some witnesses to this inquiry have suggested that paying into the BCF is somehow not an offset, and that's not accurate. The Act establishes a legislative obligation for the BCT to acquit offset obligations transferred by development proponents. We must apply the amount paid into the Biodiversity Conservation Fund towards securing and retiring the relevant number and class of biodiversity credits transferred to us in accordance with the regulations. So paying into the BCF does not, therefore, in any material way diminish the requirement for an offset obligation to be met. The other issue that's arisen is the time taken by the BCT to acquit offset obligations transferred from development proponents by way of payments made into the BCF. There have been suggestions that the BCT has acquitted less than 20% of the obligations and is taking 5 years or a very long time to do so, and that's not the case. The BCT board has adopted a policy that the BCT should aim to acquit a median of offset obligations within 3 years and all offset obligations within a maximum of 5 years. To 30 September 2021, the BCT has received 242 payments from private and public development proponents into the BCF, totalling 55.9 million, transferring 668 offset obligations to the BCT. This includes payments to support large-scale infrastructure projects, schools and hospital redevelopments, wind and solar farms, tourist facilities, mining projects, and smaller-scale residential developments. By bundling offset obligations, the BCT can acquit them in a manner that optimises environmental outcomes. To 30 September 2021, the BCT has acquitted 47% of these offset obligations, where acquitted means the credits have been retired or credits have been secured for retirement. To date, on average, the BCT is taking about 15 months to acquit offset obligations as measured by number or dollar value. The BCT publishes details of offset obligations that have been fully acquitted. For these fully acquitted offset obligations, as at 30 June 2021, the median offset acquittal timeframe was 10 months. Now, we do expect that those timeframes will increase somewhat over time, because there are still offset obligations that we haven't acquitted that we've held for longer than that, but we remain very confident that we can operate within the BCT board's policy of acquitting a median of offset obligations within 3 years. There have been a few other suggestions made about the BCT during the hearings. Many of them have been accurate, many of them not so accurate, and I'm happy to answer any questions you may have about some of those suggestions that have been made. Thank you.
Thank you very much. Now, is there another opening statement? Yeah, Mr. Knudsen, is that correct? Yep.
That's correct. Thank you, Chair. And I, too, would like to acknowledge the traditional owners of the land on which we're meeting, and elders past, present, and emerging, but also highlight that there's a particularly important role that Indigenous people can play in helping us understand how to effectively manage our land and also ensure that we're leaving a legacy for future generations. I'd like to thank the opportunity for appearing before this committee. The New South Wales government, as Mr. Elton referred to, has provided a comprehensive submission on the role which the department plays, but also the Biodiversity Conservation Trust and as well the minister. As a department, we have strategic oversight of the scheme, set the rules, provide the scientific assessment method, manage the systems, and undertake the accrediting of assessors. Mr. Elton's already laid out the BCT's role in terms of the scheme, and certainly consent authorities also have an important role to play as they determine development applications, set the conditions of consent, which aim to avoid, minimize, and offset impacts, and as well manage the compliance associated with those consent orders. While each of us have different responsibilities, the government agencies do work closely together to deliver the scheme. And a few examples I would highlight are that we have a broad-based interdepartmental reference group, which meets on a regular basis to look at our overall delivery of the scheme. As well, my group provides extensive advice on biodiversity development assessment reports for major projects to the planning area of the department. And then finally, we help support local governments in their consent role by providing information and support services. We set out in our submission how the scheme improves on previous approaches. And I'd like to add that from a personal perspective, I worked for about 10 years with the Commonwealth Government before taking a role with New South Wales about 8 months ago, and certainly can comment on the respective strengths and weaknesses of schemes, not only as far as the Commonwealth goes, but also with respect to other jurisdictions to a point. And in my experience, and one of the reasons why I decided to come to the New South Wales government is that the scheme that exists in New South Wales is the most advanced and comprehensive across Australia. The scheme builds on more than 15 years of work in implementing market-based approaches to biodiversity conservation. And the acceptance of biodiversity offsetting arose from the government's need to better address the environmental impacts of decisions to improve development and to provide greater certainty not only to developers but also to the broader community on how rules will be applied in a consistent manner and by a consistent method. Importantly, the state government has chosen to legislate this framework through the Biodiversity Conservation Act. That brings a level of transparency, consistency, and accountability that is not as evident in other jurisdictions. No other jurisdiction has a single, repeatable, scientific biodiversity assessment method that quantifies biodiversity values at both the impact and the offset sites to achieve a no net loss standard. And that standard's important. I was involved very extensively in Graham Samuel's review of the Commonwealth legislation, and that was one of his key findings, was the lack of clear standards is a significant weakness in the Commonwealth approach. The calculation of impacts and the gains of biodiversity credits also allows credits to be traded and gives proponents clear rules on how to secure offsets compared with other jurisdictions. The outcomes are not negotiated on a case-by-case basis, which is the case in the Commonwealth and a number of other jurisdictions. It also allows the public to closely scrutinize the expected impacts of a project. So the scheme's biodiversity credit market creates the opportunities for landholders also to earn an income from those offsets. And Victoria is one of the few states which has such a market, but it isn't as advanced as the one in New South Wales. The scheme ensures that offsets are secured in perpetuity through a legally binding biodiversity stewardship agreement rather than ad hoc arrangements. This too was something that we struggled with in the Commonwealth, where we had offsets where the arrangements were for a more limited period of time, there was less security over them, and there certainly was less oversight. And Mr. Hilton undoubtedly will be talking about the audit program, for example, that exists on stewardship arrangements. The stewardship agreements ensure that there is a gain in biodiversity, and that's because effectively the scheme is set up to generate 3 to 4 to 1, so 3 to 4 hectares of protection to 1 hectare of impact, and that's been done on the basis of science to indicate that that's what's required to yield a no net loss. You also need to actively manage this land. Effectively, this means removing weeds, fences, and making sure that replanting happens. And the scheme ensures that there's sufficient money to undertake those type of important works if you're actually trying to yield biodiversity outcomes. Now, just to share one example of one of the outcomes that we're seeing on a fairly large project would be the Inland Rail project, which will see 1,020 kilometers of rail constructed or upgraded across New South Wales. It's the largest biodiversity offset generating project in the state to date. Working through the scheme, ARTC has taken significant steps to avoid and minimize its impact while working closely with landholders to secure offsets for residual impacts. The ARTC expects to set up about 60 different offset sites covering 90,000 hectares and provide a steady source of income for participating landowners and conservation investment in regional New South Wales. While a lot can be done to avoid and minimize impacts of biodiversity, some impacts are unavoidable when delivering important infrastructure and the services that communities need. Now, all that being said, there is no doubt that there are areas where the scheme can be improved, and we are fundamentally focused on making sure that that continual improvement occurs. I want to thank the stakeholders for their interest in the scheme and the inquiry. We've certainly found a number of the submissions, and the testimony provided has also been very helpful and insightful, and that'll guide our work going forward. Some of the areas I just highlight, and we can talk about this more during the session, that we are focused on are making sure there is a strong level of assurance with the scheme. It is a relatively new market that we are creating, and with that comes risk. And we're very aware that we need to make sure that we're managing actively conflicts of interest and also the protocols around the governance of the scheme. I think that there's still room to improve the transparency around the scheme's outcomes, but this would be another area that I would say New South Wales is leading on. We have a biodiversity, sorry, I've just drawn a blank.
The public registers?
No.
Oh, the Biodiversity Indicator Program.
Indicator. I had investment in my head. I knew it was an I.
There's a lot of acronyms. A lot of minds going blank too, I think, at this point in time.
The Biodiversity Indicators Program. This is the only jurisdiction that actually has something that maps not only the status of species and their habitat, but also the trends. And it's that trend information that's particularly important when you're thinking about how the scheme fits into the government's overall approach on land management. In addition to the transparency provisions, we're focused on improving the pricing with a more robust and reliable charge system. And Mr. Elton and his organization are leading the consultation on a replacement for the existing mechanism. That's something that a lot of landholders and developers have expressed concern over, is the volatility with respect to the pricing derived from the existing. Final one that I would highlight, and it's probably the single most important one in my mind, is we need to increase the supply of credits. The reason for that is that if we look over the forward estimates, there's about $108 billion worth of major projects scheduled to start in New South Wales. The amount of biodiversity credits that will be required associated with that will be in the billions. That's going to require us to take a stepwise change in the scale which we're identifying credits for those proposals. So I think we have a really significant work program trying to improve the supply of credits, but also provide information to the market about where the demand for credits are going to come from, so that if you're an individual landowner, you know there's a market for what you have on your land. So I look forward to the committee's recommendations. We absolutely will consider them very closely, and we look forward to working with the committee to further improve the scheme. Thank you for your time.
Thank you very much for that. We will now proceed to questions from members. I'll go to the opposition. Ms. Penny Sharp.
Great. Thank you, and thank you for that introduction. Before we get into the submission, can you just give me an update on my understanding is that there are various reviews in relation to the scheme and various investigations in relation to the scheme. Can you just give us an update of where each of those are up to?
Certainly, and I'm going to turn to my colleague in a second. But in terms of the review of the scheme as a whole, the department has commenced what we're calling an integrated improvement and assurance program, which has a number of elements associated with it. The minister at estimates referred to a review of the scheme. That has that is the main focus of that work, is making sure that we comprehensively take a look at the various elements. And in my opening statement, I talked about a few areas. Those are all embedded in that. That's with respect to the operation of the scheme. But quite frankly, the work of this committee will also inform that work. We'll be looking for the recommendations and figuring out where do we have to move things along.
I don't know. I don't want to go over the things that we talked about in estimates too much, but I just am still trying to get an understanding of integrated assurance program sort of assumes continual improvement. I'm trying to get an understanding, I suppose, of what some of the timelines and the public reporting of those different elements are. Are you able to give us that information?
We can give you a sense of when some of those elements are going to come forward. The one thing I would say is that this will be a program of work that will not just wait for a final product. We will be delivering different improvements over time. So one of the pieces, for example, that we've already delivered is an upgrade, or an update, I should say, to our conflict of interest guidelines for staff members, et cetera, who are involved with the scheme. But I'll turn to Ms. Mahmouni in a second. The other thing that we can also cover off is your question about the investigations with respect to the Guardian articles, et cetera.
We provided some of this information in a response to a question recently. So I'll just run through some of that just to bring it to life. So we had a review that was started by Sentium in April 2021. And then we had a law firm, Maddox, that was then appointed to complete that review. And so some of that information is still under review, and there are some matters that are still under consideration by ICAC. In July 2021, we had Maddox do a second review in terms of the management by the department itself, in terms of the establishment and ongoing of operation of certain biobank agreements, and that review has been completed. I understand from our governance and legal. I don't have the details, the final details of that.
Is that going to be released publicly? Has that been released publicly, or is it?
My understanding is that it has a lot of private information.
Yes, I'm sure
in that.
it does.
So at this point, our governance and legal, I'm not sure, but it's unlikely that the report will be released. Given that,
I understand that. Do you think that will there be some public response from the Minister or the Department, just I suppose outlining what the outcomes of that have been?
Yes,
will
and
be?
certainly. I mean, I've only become aware of that this week, so I'm working quite closely with our governance and legal people on that in terms of what we need to do in administration of the scheme. And then the other aspect, which Mr. Knutson was mentioned, was the Centium review that looked at and primarily gave information on what we should be doing in terms of updating our conflicts of interest protocol, and we've recently just put the new protocol up on our website. I understand that review will be made public, but it's just in its final stages of...
And just to be clear, that's protocols in terms of staff members.
Correct.
How is the investigation or reviews dealing with the... We've had quite a lot of evidence around that kind of people who are working on projects. So consultants that are working on major projects in Western Sydney, for example, are they captured by this, or are they just governed by their accreditation as assessors and the conflict of interest provisions within that?
So there is a code of conduct for our accredited assessors. We will certainly be looking to see, with the changes that we've made in terms of our conflict of interest procedures for our staff, we'll also be thinking about what else we might need to do in terms of the code of conduct that we have for accredited assessors. We also, in terms of the accredited assessors as well, I would also say we've recently updated our whole training program for them, and so the requirements to actually become an accredited assessor, the training modules, and then the actual field work that you need to do to make sure that the biodiversity development assessment reports that they're undertaking, that accreditation process has become more robust over the past year. We also have a re-accreditation process that we've just put in place in July this year, and what that means is that to actually be re-accredited, you have to undertake some modules again, and we have to there needs to be some certainty from our perspective that accredited assessors know how to undertake the assessments, and so we'll be looking at that quite closely, and we've also got a complaints handling process. So I just thought it would be useful, given that you just asked about the accredited assessors. Do you want me to go back to the review process?
Well, yes, but just on the accredited. So, look, the issue obviously has been that there have been people who've worked, whether it's directly or indirectly, for a variety of consultants on a number of major projects. And as Mr. Knudsen said, we've got $108 billion worth coming down the pipeline. It's not small bickies. They obviously... it's as accepted. It's a pretty small market at the moment. There's only you've got 400 assessors. It's a pretty small group of people that have access to a lot of information. And we have seen the case where individuals look, I accept that they wouldn't necessarily accept that they work directly on that or had possessional knowledge, but they're clearly watching what's going on. They've been able to do that, and some also have been working in the department. They've then gone. And then they find themselves in a position of where they're either got access to sites themselves, or they're providing brokering. Like where it was put to us yesterday that the only way to deal with that is just through disclosure, and that's the only requirement. I mean, are you looking at beyond just people constantly saying, yes, I own this block of land, and so therefore it's okay?
Well, indeed, for departmental staff, we've effectively said that you either need to, well, first of all, you're not supposed to be participating in the scheme. If you have historically, then we've given staff members a couple of options on what to do to effectively distance them from having any control or influence over that. But your question goes to a broader piece, quite frankly.
A much broader piece. It's not just I mean, you've got some control over that. The issue is in terms of the integrity of the scheme. I mean, no one thinks it's a good idea that individuals are making windfall gains through, the fact that it's a small scheme and that they've got some pretty, whether they're working directly on a project but, adjacent to or as part of the same consultancy, I think is a concern.
One of the things that I would say that stands out for me, Ms. Doomsdale's talked about how we're positively trying to strengthen the role for accredited assessors, but I think what we're missing that we want to look at is also what are the implications, what are the consequences for either poor performance, ongoing poor performance of an accredited assessor, because in meeting with a few proponents over the course of my time with the state government, that's come through. The performance is variable, just like performance of public servants is variable. Certainly not politicians. They're all absolutely above board, et cetera. But
I wouldn't say that. I'm not. Yeah, that's right.
Oh,
none of us are looking for that.
Sorry, it's a Friday afternoon, though. Anyways, but we do want to take a look at what are the consequences, and I mean the negative consequences in terms of losing your accreditation, et cetera. And certainly we take any matters where there is any insinuation that there's been perhaps illegal behavior very seriously, and we refer that to the appropriate authorities.
Yeah, and look, I'm not necessarily alleging that. It's more the issue of individuals making windfall gains. We've had, some, mum and dad landholders really keen to do conservation, really struggled in a really uncertain market. Anyway, we'll get it. But anyway, I might move on because I've got a bunch of other questions, and I know that my colleagues have got some as well. Look, one of the biggest issues I've got with the biodiversity offsetting is we say that there's not supposed to be any, no net loss of biodiversity, but by virtue of the scheme, essentially we're pricing in the removal of biodiversity. And just as an example, I mean, in your submission on page 2, you talk about, to date, 211 land. Now, Mr. Elton, is that just you? Is that just the Biodiversity Trust, or is that the scheme altogether? I was a bit unclear.
In terms of the number of people that have entered agreements.
Yeah, 211.
That's us.
That's you. Okay.
Yep. It's now 219.
Great. More the merrier. But, protecting more than 27,000, 27,500 hectares of land. Do we have the figure for how much land's been cleared?
Yes. I'm just going to actually pull up, because I thought this question might come up, because it's absolutely to the core of the land management biodiversity conservation reforms as a whole. So we've talked about, or I talked about my opening statement, the biodiversity offset scheme hardwires in about 4-to-1 ratio, right? And the idea there is you break even. But then you have to take a look at, as you've just mentioned, land clearing that is outside of the scheme. And I think the last stats show that that's gone up from about 40,000 hectares a year up to about 60-odd thousand hectares a year of especially woody vegetation. But we have to weigh that up against, there's another program within the BCT focused on private land conservation, and Mr. Elton can talk about that. You've also had a pretty significant increase in the public estate beyond that through national parks, and I think the last figures were around 380,000 hectares.
Yeah, those two big properties in Western New South Wales. Yeah, right? Very good.
But the other piece that fits in this also is, because not all land is going to be on public lands, not all land is going to be associated with a development. Then you've got to figure out how do you get beyond that. That's why Saving Our Species as a program exists, to try and work with landholders to try and do that.
I mean, thank you, I appreciate that. That's not really my question, though. My question is directly relevant. So 219 landholders have established biodiversity sites protecting more than 27,400 hectares. And yes, I accept that we've, got to the two new national parks up west, and there's all these other, saving our species and all of those things. But the biodiversity scheme's supposed to have no net loss. We've got 27,000 hectares have been protected under those 2019. How much has been cleared?
Can I take it?
Just that, not the land clearing, not...
So I might just break that down a little bit further, Ms Sharp. In fact, of those 219, only 133 have become active, and that's only 15,500 hectares, which means that they've sold their credits to a development proponent. Now, we're also in transition from an old scheme to a new scheme, so there are also the old conservation offset agreements, and there are 108 of those over 38,000 hectares. Now,
but they were already established.
They were already,
What I'm trying to say is, we've
so
set up the scheme. We're supposed to have no net loss. So far, we've protected 27,000, leaving aside the historical change. What does that represent, though, in terms
of the 15,000 hectares that is active BSAs? As Mr. Knudsen has said, the average offset ratio by hectares is around 3 to 4 to 1. Somewhere between 3 and 4 to 1. The range is 1 to 1 through to 30 to 1. But if we accept the average, well, then it would be a quarter of that figure. So the 15,000, or a third or a quarter of that figure of 15,000 hectares.
I think it might also be useful for Dr. Mamouni to add a little bit more about the process that we undertake.
Please.
Thank you. Committee also acknowledge the traditional owners, the Gadigal people. In terms of no net loss, the scheme sets up a process to avoid, minimise and then offset the impacts of development. And we have a rigorous scientific methodology, the biodiversity assessment method, for accredited assessors to apply and determine the amount of impact that is proposed as part of those developments. And that is the Biodiversity Development Assessment Report that you've heard about earlier. In addition, consent authorities need to have a look at the serious and irreversible impacts that development may cause. And for local development, those consent authorities cannot approve impacts that will cause serious and irreversible impacts.
We'll get to that, but
Happy to come back.
So
then for major projects, they need to also consider serious and irreversible impacts, but the level of offsetting for major projects is decided by consent authorities.
No, I get all of that. My question, so you basically saying that there's, I just don't believe this, I'm sorry, that there's only 4,000 hectares have been cleared and we've got 15,000, and the delivery of that has been sort of 15,000 bits of protected land when there is so much that's still unacquitted. Sorry, let me put this a different way. And I don't know whether this data exists. In all of the, so if we just take it from the point in time, say from, and you might have to take this on notice, if we just take it from the point in time in 2017 when the scheme started, I accept all the transition, I'm not trying to argue the toss on those issues. Are we able to say, of all of the things that have come under the scheme, how many hectares have been avoided in terms of clearing? How many hectares have been subject to minimisation arrangements? And how many hectares have been offset? Do we have that data?
We'll take that on notice, but I will just say one thing. In terms of when there's an environmental impact statement and there's a biodiversity development assessment report, in that report, the expectation is that the proponent will explain what's been avoided, how they've minimised it, and then we understand the offset.
And then the consent authority just makes the decision about that. Who's monitoring that? Because the evidence that we have had for the last 2 days, very much, we had excellent evidence this morning from local government, is that they are just finding that developers or whoever wants to, we'll get to clearing in rural land, which is a completely separate issue, but the development pressures, particularly up and down the coast and the peri-urban areas of Sydney, developers do not want to go through the process of avoiding or mitigating. They're basically going, their first option is to go, how do I offset and how much do I pay? And it seems to me from the evidence that we've got is essentially the consent authorities are agreeing to that. Who's got eyes on how much avoidance and minimisation is actually occurring under the scheme?
So there is certainly an overarching aspect that we're considering as in terms of administrating the scheme, that we need to think more about the overarching monitoring and review of the whole process.
At the moment, you can't tell us that.
It would be useful for us to unpack this more in the next session with our planning colleagues in terms of, because they're responsible for the compliance aspect, but certainly our planning teams, when they're looking at within our, so we have planning teams across the state that look at the environmental impact statements, and to make sure that the proposal that's been put forward is in line with the requirements of the scheme.
And what is their role? So they're looking at the EIS, and they're saying, do they have any sort of consent? I mean, their advice is what? Yes, we think they've done enough to avoid it. B, we think they've done enough to minimise, or C. I mean, who decides whether people have done enough to avoid or mitigate?
So we provide that advice to our planning and assessment, and so our colleagues will be here this afternoon, and then they take it. So, and the advice we provide is public. So, you know, the BDAR is made.
They don't have to, but they don't have to follow it.
And but we work closely with our planning and assessment colleagues in terms of what our advice is and why.
You don't have any veto. You basically just provide it. You're part of the process.
Provide the advice.
So you are looking at it.
Yes.
But you also, but there's no one. No one's giving me the answer.
And I'll take that on notice, but I will say I hear what you're saying, and I think that's one of the things we're thinking a lot more about in terms of the overall kind of framework. As Mr Knudsen before was talking about, we do have the biodiversity indicator program, so we do look overall in terms of the impact on biodiversity.
But that's looking at all of the, that's looking at land clearing, that's looking at national parks. There's not, for this scheme, not a centralised. Mr Elton, you've got your hand up.
I just might be able to help. Look, I think it's important to recognise as well that there is a strong economic incentive to avoid and minimise, because offsetting often is not cheap because of the opportunity cost of the land.
Yes, and we're seeing increasing lobbying to actually have that ignored. So that's not a problem for you. It's a problem for.
I'm certainly aware of developers, and ARTC is a good example where they have actively sought to consider the siting of the project to try and avoid impacts that are going to be bad for the environment and also costly. So that's a very important aspect of the scheme, I think. I'd also like to add that on the supply side of the market, because you know, it's our job to assess applications for biodiversity stewardship agreements, and we do, as part of our due diligence, ensure that the consultant has applied the BAM correctly in preparing the stewardship site assessment report as part of our due diligence before we enter into
great. I mean, one of the things that we've heard, sorry, I'm aware that my colleagues have a lot of time. It's okay. I don't want to hog the place. But I mean, one of the things we've heard from local councils, particularly, again, coastal areas, you know, where land values literally in the last 12 months have tripled. Stewardship sites just aren't available. And again, sort of a concern and local extinctions. We have had two good examples this morning. One was local extinction of koalas in Port Stephens area. Again, an area where, you know, look, if you've got land, the best thing you can do is put houses on it. That's where you'll make the most money. And there's real pressure there. And the second one is the coastal emus up in Clarence Valley. There's no stewardship areas because the land's too expensive and there's no one and they're in a really small area. I mean, how... We just have to accept that that's the way it is, or is there ways that we can design in the scheme? Because it seems to me that those councils have got their hands tied in terms of they're trying, but they really don't have the tools they need, and the system of avoid and mitigate just doesn't seem to be actually working for them.
Just on the supply, if I could just give you some figures though, we've still got 86 biodiversity stewardship agreements that have been signed where they haven't sold any or some of their credits.
Why is that?
Well, because... So there is some supply in the market. So if you go to the credits available register, public register, there are landholders with credits for sale right now, 86 of them. And we have another 54 BSAs with us at the moment that we're processing. So there is an active supply side market. But Mr Knudsen's correct in his remarks earlier that the supply side of the market is an issue, and we are working very hard on a range of measures to further boost supply. There's a lot of work being done to look at demand, the demand pipeline. It is going to need to ramp up, and so we are going to have to do more to support the supply side of the market. But I just wanted to make that point, that there is supply in the market. There's more supply coming into the market.
It's a little bit varied, isn't it? Just sort of, it depends on what you're in the market for. Like certain species don't work, or certain ecological communities. Like there's not an easy match around that.
Sorry, I just want to make one quick point. One of the key things that's really important behind this scheme is because it creates a biodiversity credit, which is got all of that rigor of the scientific assessment under the BAM. That's why you can have assurance that if the system says you need 47 credits, it's because of the science behind what you're impacting and what needs to be protected elsewhere. Because it's market-based, that means that the price, even if the value of land has gone up in coastal properties, if that's where the credit exists in terms of koala habitat, et cetera, so will the cost of that credit. So that is one of the key strengths of the system.
That only works when there's actually a stewardship agreement in place. The issue that is being raised is that people are getting squeezed out in terms of the establishment of new stewardship credit. And I mean, there's a whole other issue about entry to the scheme and how people can actually get themselves ready to be able to provide the supply that we need.
And there's absolutely a piece in this. I met with regional New South Wales and a number of local government areas where if you're a relatively unsophisticated or a smaller either landowner, LGA, business, you're going to have trouble entering the scheme. So we've got to do work to make it simpler. We've got to make it easier for people to figure out what they've got on their lands and what it could be worth in the scheme, because that isn't as transparent and predictable as it could be. So we've got a number of things that we need to do in that space.
Also very expensive at the moment. I mean, we've again had evidence that there's, the cost of actually getting the assessments are often worth more than the development that people want to do on it, which makes it unviable.
Thank you. Mr. Knudsen, I might just go back to something you said in your opening statement, which was that the department has taken some action to ensure, I think, that staff no longer hold interests in biobanking sites. Is that correct?
Well, it's that they no longer have an ability to influence those sites. So we can walk you through the details of that.
Yes, please.
Yeah, the conflict of interest. So, Dr. Mamouni?
I'll answer that one.
Okay, sorry.
With the protocol, and we can provide a copy of that as well. Yeah. Is that it's where there are staff who have more involvement in the scheme. They're like, for example, if they were working in the biodiversity offset scheme branch, they're not able to participate in the scheme, and so we've been quite clear about that. Now, and so they're prohibited from participating in the scheme if they're working, if they have a significant interest in the scheme. So they're working in the scheme.
Sorry, just to be clear, so if they have a significant interest in the scheme and they're working in the scheme, and that means that they no longer have a job in the scheme?
No, they've got 12 months. At the moment, we don't have anybody working in the biodiversity offset scheme branch that has any interest in the scheme. But if they had, they would have had 12 months to divest of their holdings, but we don't have that case, and we've said that if you're working in the biodiversity offset scheme, that you cannot participate in the scheme.
I should just add, divestiture is one option. They can also put it into a trust, etc. We can provide that.
Was there anything? I mean, that's the biodiversity offset scheme, but or maybe it's a question probably for planning later.
The protocol will apply to other departmental staff that may have a conflict of interest as well. It's not just specifically to staff that work in the biodiversity offset scheme, so it will apply to other regional staff or even consultants or contractors that are working for us so that we know up front, and they have to declare their conflict of interest, and we have to put arrangements around that, and any new staff or new arrangements, they're not allowed to hold those interests in biodiversity stewardship sites or in the credits or credit trading aspects of the scheme.
Okay, so that's any new staff, and then historical ownership, like existing staff, that it's kind of like a divest of those interests, or you don't move out of this particular area of employment. Is it that clear?
It is that clear.
Yeah.
So, Chair, Justin here. Could I ask a follow-up?
Sure.
Mr. Mazzell, I think I heard you say there's no staff currently working in the branch now that have an interest in the scheme. Does that mean that there have previously been staff working in that branch that have stewardship sites?
Not in my team.
Not in the biodiversity offset scheme.
Not in the past either?
Not in the past.
In the department, yes. In the department, yes, but not in the branch that's responsible for the biodiversity offset scheme itself. But it's probably... I won't go through the details of individuals.
I'll go back to you, Chair.
Okay, thank you. I just wanted to, to you, Mr. Elton, about the capacity of the trust in some way. So what's the budget for the BCT? What are you working on in terms of just your operational budget, I suppose?
Yep. Look, I can get the precise figure if I take that on notice, but just to give you a sense, we receive $70 million a year from the government for our private land conservation program, which is separate to the topic of this inquiry. And then on top of that, we generate revenues for our roles under the biodiversity offset scheme. So that typically derives from fees charged to landholders, developers and government agencies that commission us to procure offsets. So that's all done on a cost recovery.
Could you give us a breakdown just in terms of those three groupings? I mean, on notice.
Yeah, I'll take that on notice.
Yes,
thank you. Yep.
Yeah, and with that as well is taking on notice probably just in terms of the organisational structure and staff. We have heard, if that's okay, yeah.
Sure. Yeah.
We've heard, quite a bit of evidence just about how difficult it is for landholders and people wanting to understand the scheme, how complex the scheme is, which is a different issue entirely, but just being unable to get somebody to talk to sometimes because there's just not the staff there. Do you think that there's a resourcing issue within the trust?
Look, I don't think there is, and in fact we've got quite a positive track record on customer service. We've actually done landholder and program participant surveys, and we've had very positive feedback, and I could take that on notice and give you the results of that feedback if you wish. So look, I think there may have been confusion in some of the evidence given earlier in the hearings as to who people may have been trying to contact and whether that was in fact the BCT or not the BCT. So, I mean, look, there are in any organisation like ours, there will sometimes be issues, but I think we've got a pretty strong track record and a very low level of complaints as an organisation. So, we've got a very strong commitment to customer service. We have a customer service charter, a guarantee of service. We have a dedicated customer relations officer, answering the phone. An inquiry line. So I think I'm aware of a few instances where there's been some breakdown in customer service, as you'd expect in any organisation. But overall, I think we have a very strong and positive track record.
Okay. We heard from one local government officer today about attending a webinar a few months ago, I think in June, and on that by the BCT or the department with the 900, maybe the department,
I'm not sure.
950, but I'll give you the information anyway, which I'm sure you can help me with, Mr. Elton, which was that there were 952 species credits that across the state, which haven't been able to be retired, if you like. So, and and we've talked about this before, but don't we get to a situation where those species credits just can't be retired? Like, at what point We've talked about this in the Koala inquiry as well.
I think that may have been a confusion. This would have been the webinar, one of the webinars we've run on consulting on the design of the new Biodiversity Offsets Payments Calculator, or the BCF charge system, as we're going to call it. Some evidence was presented by us about the range of species credits that exist, and the fact that a vast majority of those have never been traded. So that's quite a different question to whether they're able to be acquitted. So I think that might have created a confusion there. So there are many offset trading groups, ecosystem credit types and species credit types. The vast majority have never been traded, i.e. there's never been demand for those types of biodiversity credits to be retired. Putting that aside, yes, we have had a number of payments into the Biodiversity Conservation Fund for species credit obligations. We've acquitted some of those, but some of them are more difficult to acquit than others, and we are looking at various ways to induce supply of those species credits. So we run a series of different credit procurement mechanisms. We run competitive open tenders. We run an open fixed price offer, and we also run targeted fixed price offers, and I'm happy to go into details if you wish, but we are not only seeking credits from landholders who already have those credits established under BSAs and for sale, but we are also running those mechanisms to induce additional landholders to set up BSAs and supply the credits we need. We also have a credits wanted register. So we have a standing open fixed price offer, periodic, usually annual credit tenders. We run credit tenders where there's a more competitive marketplace to supply those credits. And then we run targeted fixed price offers where we really need to induce credits that might be quite difficult to source in very geographically constrained locations, for example. So, you know, we're having ecosystem credits generally are easier to find and acquit. Species credits is more complex, but we're gradually working through that and finding ways to acquit those obligations.
One of the issues, and I know that Ms. Shah talked about it as well, but we heard from some of the coastal councils today about the fact that land is just increased astronomically in the past couple of years, and that people are going to be paid a hell of a lot more to clear that land and to obtain credits in the LGAs where that land has been cleared is near impossible, is what they're saying. And so many of those, it's offset elsewhere. It's now cheaper to offset particular habitat, hundreds of kilometres west, for example, because the land is potentially so much cheaper. Just from a policy, what are some recommendations? You've just talked about offering incentives. I think they'd have to be very big incentives, wouldn't they? This is a failure of the system, surely, a failure of the design, that it's just not keeping up with how much developers are able to make clearing the land. That's a big issue, isn't it, Mr. Elton? And I'll go to Mr. And recommendations for reform, because I'm sure you're talking about the fact that internally there are reviews, and I'm sure as good public servants you have fed into this. So if you have any suggestions, feel free to tell us, although I'm sure you will restrain yourself.
So the one thing I would say that's already built into the system is that you have regions, and it's another acronym that I haven't got my head around, but IBRA. So they're biodiversity regions, basically, around the state. And
what is that acronym? We do have to say what that is.
Interim Biogeographic Regions of Australia.
Thank you.
It's a very established biodiversity appropriate regionalisation, so it is quite different to local government areas, but it is publicly available. It's used by many scientists.
Why is it interim?
That is a good question.
Been interim for about 3 decades.
Yes, well, that's why.
Yes, it's a complex space.
But the key thing is there's some science behind saying that region has similar characteristics, right? And so if you're looking at an outcome for a particular species, you're saying, well, within that region, that's basically representative of the habitat.
There are limits to that.
There are absolute limits, and I acknowledge that.
Coastal emus being the one we talked about this morning.
What the system does reinforce is that offsets, if they're to be secured, are supposed to be within those regions. That could be tightened, that could be loosened, etc. That will have price consequences as well, but that is what the system's fundamentally built around.
And I think it might be worth having Dr. Mamouni go through a little bit more about the biodiversity assessment method, because what it does is it takes into consideration what might be happening at an ecosystem level as well as a species level, and so how many credits are required will increase depending on the what's happening at this point in time for a particular species. Certainly, if it's an ecosystem credit required, it's to try and keep it as close to the geographical area as possible. So there's quite a lot built in to the scientific method to then determine how many credits are required for it. But it might just be worth Dr. Mamouni kind of unpacking that a little bit more.
And I'll start off with serious and irreversible impacts. So that allows us to identify those species, and we talked about the emus, the endangered population of emus earlier today. So those populations are covered by this framework for serious and irreversible impacts. It allows for consent authorities where there are very small populations or ones that are particularly threatened by habitat destruction to be treated differently, and for them to not approve the development on the grounds that they are serious and irreversible impacts. So that relates to species with very limited geographic distributions. It relates to species and communities that are unlikely to respond to restoration methods as well. So there are a range of principles that those serious and irreversible impacts are around.
And we did hear from quite a few local council officers, though, right up and down the coast, for example, and elsewhere, that just say that's just not being applied.
We provide guidelines and support for local councils, and we're just about to roll out some new training for them, which will go into this in more detail. We're also establishing a help desk that will be available for local councils as well as developers and landholders looking to enter the scheme as well. So that will start.
Just to go directly to that, I mean, one of the issues. Justin's got some questions as well. Sorry, I'll let Justin go. All right, we'll go to you, Mr. Field.
Thanks, Chair. Actually, it follows on from that last question. My understanding is that the green and golden bellfrog offsets for WestConnex were sourced on the north coast. That seems extraordinary to me, and just is such a classic example of the loss being experienced in one area. It's very difficult to see how you could, have, despite the habitat obviously being suitable to the animal, how it can be a similar area of biodiversity. So can you just explain how that would be allowed to happen?
I'm going to start off with a little bit about like-for-like offsets, because that is a critical component of the biodiversity assessment method. And then I might turn to Mr. Mazel for a comment on the specific issues. So in terms of like-for-like offsets, and this is under the biodiversity offset scheme, and that project that you referred to was under the former scheme. But like-for-like offsets, the stewardship site compared to the development site must be in the same or adjoining IBRA sub-region, or a region within 100 kilometres, so in the general geographic location. And if it's a threatened ecological community, it must be the same threatened ecological community. If it's not a threatened ecological community, then it must be of the same class, i.e. there must be a match in, I guess, the degree of threat that ecological community is experiencing. And also if the development site is a site with hollow-bearing trees, then the offset site must also have hollow-bearing trees. For species credits, and that would relate to green and golden bellfrog, the like-for-like is more straightforward. It must be the same species as impacted, but the offset credits can be from anywhere within the species distribution. I'll just refer to Mr. Mazel in terms of the specific.
I'll have to take the specific on notice, Mr. Field.
But in this instance, obviously, you could totally lose a population of a particular species from one area, and that loss, i.e. in Sydney, is offset by protecting an area of species hundreds and hundreds of kilometres away.
Under the current biodiversity offset scheme, the serious and irreversible impacts would apply, although for major projects, that is something for them, for consent authorities to consider. For councils, they must apply the serious and irreversible impacts requirements.
So what you're suggesting is that offset would not be allowed under the current system unless, say, the planning minister, the consent authority for a major project, agreed that that was suitable. Am I understanding correctly?
So if it's a development that the consent authority is local government and it's serious and irreversible impact, then that cannot be, that is not approved. If the consent authority if it's a Part 5, for example, then they have the consideration needs to be given to serious and irreversible impact, and then decisions in terms of what would be required would be included in that. But that's correct.
Just to be clear, that's could correct. Still happen. No worries. I might just move on. We've had quite a few people mention the need for, it's been described as either red flags or red lines here, where either certain habitat types or species impacts just should not be allowed to be offset. Is that something that is being considered within the department or in any reviews that are being undertaken to aspects of the scheme? Is there a need, do you think, for us to visit this question of some areas simply being made unable to be offset?
Look, the red flag kind of concept was the term that we used in the former biobanking scheme, and in the biodiversity offset scheme, the serious and irreversible impacts are the red flags. Dr. Mamouni earlier referenced the work that we've been doing in terms of providing more guidance, particularly to consent authorities and local councils in particular, around how to work through that, and I think and there's some more guidance that's coming out soon, because we've recognised that that's an issue that consent authorities are still trying to understand. So we recognise that we needed to provide some more guidance in terms of serious and irreversible impacts. But from our perspective, that concept of the red flags is what we're seeing now in terms of serious and irreversible impacts. And I just might, there's a, at the back of our submission too, we just had some kind of pathways that demonstrate what happens, like how different authorities or through different planning pathways, and in each of those kind of documents, it then outlines what happens when you hit serious and irreversible impact. That might help.
But of course, that only matters. Excuse that noise. That only matters if it's if the approving authority is local government here. In the event that it's a major project and it sits with the minister or the IPC or whomever, those impacts can effectively be overridden, can't they?
Yeah, and
So there are no red flags when it comes to major projects?
Well, they have to consider serious and irreversible impact, and certainly... they
only have to consider it.
Yes.
It's not... If it's serious and irreversible, the then decision is, do we accept that that's okay and we therefore stop anything happening, or do we still facilitate? Right. That's what we're trying to... And
yes, and then I suppose... one of the good things is that it's transparent. And I think from our perspective, having such a transparent method like the biodiversity assessment method, where the public can clearly see the impact from an ecosystem credit or a species credit, that it's not just kind of something that's negotiated and a negotiated outcome. You can actually see the credits that are required in the biodiversity development assessment report. That whole process is transparent. A decision can be made by the consent authority in terms of how that's treated, but that process is transparent as well.
I wouldn't mind just coming back to this question of staffing and the ability for staff to participate in the scheme. So I just want to be careful that I understand. We were drawing some quite specific connections before. You were talking about staff that are operating within the biodiversity team. What are the conditions, if there are any, that apply more broadly to staff working within DPIE participating in the scheme? Because of course there'll be staff that'll be working on strategic planning, mapping projects, other things where they have quite specific and specialised knowledge and advice. So could you just explain what the requirements are from this point forward, and maybe what the previous requirements have been for declaring conflicts?
Sure, and what I'll make sure of is, again, that we definitely do get all the members a copy of the protocol. I'll be clear about this, I've been heavily focused on the implications for my staff, and so in effect, Dr. Mamouni talked about those working within the branch, but I run a directorate of around 800 people. All those individuals with the new conflict of interest protocol are not allowed to have any participation in the offset scheme from a personal standpoint. They can be involved professionally in quitting their responsibilities, but they cannot own or participate in a BSA or anything along that lines, or a private land conservation agreement. So that's very clear. That's different from what it was. And quite frankly, we took that insight from the protocols that the Biodiversity Conservation Trust put in place. So we've applied that. That's what's new for the staff within my directorate, and that's beyond the branch that Dr. Mamouni leads. Now, in terms of the rest of DPI, effectively, and I don't want to mislead the committee, so I'm a bit reticent because I won't have the exact language in mind, but effectively it says, listen, if you're at a relatively high risk that you've got effectively access to key information, et cetera, then you should not participate in the scheme, and here's what you need to do. But I think it'd be better for me to come back to you, Mr. Fields, with the specific elements for other staff outside of my area and what the implications are for them, just so I don't mislead.
No, I appreciate that. Without naming any individual staff, I'm not asking for that at all. Do you know how many staff who have previously worked for DPI were participants in the scheme whilst they worked for DPI?
Yes. So I'll come back with the exact number, but it's less than 5.
Okay, no worries. There was, in one of the sessions this morning with local government, there was concerns raised by Shoalhaven Council about land that had been rezoned a number of years ago for effectively industrial commercial development, a sort of jobs precinct, really. That land was rezoned in negotiation with the state planning department, and the feeling down there was that the impulse of the biodiversity offset scheme now made that land difficult to be developed for economic purposes. We're having a discussion about the ability of council to go through a strategic biodiversity certification process. So I just wanted to ask, is it possible for local council like Shoalhaven Council to, on behalf of the various landholders in that precinct, try to engage in a strategic biodiversity certification process?
It is, and one of the things I would say is, so I was in the Central West last week, met with a couple of the local government authorities there, similar sort of dynamic associated with Inland Rail. There's a cash flow problem if you're a local government authority, right? That they're looking at trying to realize an economic opportunity, but most of the liabilities with respect to biodiversity have to be incurred upfront, whereas the revenues from any development come later. That's been done purposely by this system, right? Because again, in the Commonwealth, we had the exact opposite problem, where the offsets came eventually, maybe, hopefully, but the impacts happen now. And so New South Wales made a decision when they put this scheme in place to bring those impacts forward. I think there's still a tension there that we need to sort out, and the example that you're talking about for Shoalhaven would speak to that as well.
And what have you had, I mean, I know there haven't been many strategic biodiversity certification processes, relatively new. Is it difficult for councils to engage in that process, or is it still just in the early stages? They seem to think it was very complex and it sort of was an uncertain process to go through. So I'm just trying to get an indication of whether or not this is workable for councils like that.
So certainly with the strategic biocertification process, that's something where it would be the Minister for Planning would be bringing that forward. And for example, we've just received the Minister. The Treasurer has just received the application for the CPCP, the Cumberland Plain Conservation Plan, which is the kind of strategic biocert that we're kind of looking at the moment. It's a complex process, so the CPCP is the one that we're working with at the moment. The biocertification process is one that's more likely to be one that that councils could engage in, and I know there's been a few of those, but I don't have the detail in terms of the numbers on me right now for that. So there's the two, the strategic biocert is a kind of a much bigger process that's put forward by the Minister for Planning.
We'd be happy to reach out to the local council as well and try and work through options that make best sense for them.
I think they'd appreciate that. Chair, if I could just one more before I
That's fine, Justin. Yep.
I have others I can keep going if you need. The Guardian obviously has run a number of pieces which raise some pretty significant concerns in my mind and others about the windfall profits that have been available to some investors in the scheme, particularly where it's involved government agencies purchasing credits. I'm just wondering, is there any advice that the department provides, or is there any directions or directives that have been given essentially by government to agencies about how they should participate in the scheme? It seems extraordinary, for example, that RMS would pay 4 times the value of land purchased by an investor just a year before for the credits on that land, when they could have purchased the land themselves. So I'm just wondering, how do agencies make decisions about participating in these schemes that's cost effective for the taxpayer and gets the best value for biodiversity outcomes?
Firstly, there is an attachment to our submission where Transport outlined their processes and what they do in relation to working with communities to find the credits that they need for their projects, and I think that's quite a useful document, which I think they've also got on their website as well, because they've made quite a concerted effort with their projects to engage with local communities to try and get their to secure those offsets up front. We've certainly in the past year expanded our remit to support agencies in their process to navigate the scheme and to understand what makes, to understand how to engage, to go through the process, firstly of kind of developing their report, and then also what they need to do in terms of securing the offsets. And I think the fact Mr. Knudsen earlier had mentioned we've got an interdepartmental reference group, and so we have members of all the main departments that have major projects, and that group, as well as looking at overarching governance and policy for the scheme, is also a way for agencies to be able to understand from each other around what makes sense in terms of obtaining their credits and how to work within the scheme as well. So we're finding more and more that agencies are actually now reaching out to each other in terms of, say, for example, where transport might be have led the way. They did quite a lot of work, for example, on the north coast for the highway work, and we've kind of linked them with Water New South Wales in terms of the work that they're trying to do. So just trying to expand the knowledge across agencies. So we're trying to facilitate that process as well. The other thing that we're looking at is Mr. Knudsen outlined, we're thinking about the pipeline of projects, and so we're really starting to do some work around the demand analysis, and Dr. Mamouni could go into this in a lot more detail, so that then we can actually think about the demand required for, because the projects that government agencies might be undertaking can be quite large, and so we're looking to see then how we can marry that up with the supply side and how we can work with landholders, specifically in regional locations, to really to try and get on the ground with local landholders, because we have found where particularly local landholders who've engaged with the scheme have then been able to kind of have that diversification of income as well. So we're really trying to work on that demand supply side.
So if I can just add one very quick thing, Mr. Field, you talked about the costs that transport paid. It's one of the things that we're really concerned about, quite frankly, in terms of making sure that there is a cost-effective way of meeting environmental outcomes, but also in a way that facilitates development in a rigorous system. We think, so the BCT actually has also led the way in terms of trying to do some advanced purchase of offsets. That means that they're looking for the lands that make the biggest difference ecologically, but getting those credits secured and available to developers in advance, we think is pretty important for dealing with the issue that you were talking about perhaps government being in a position or private sector being in a position where they're trying to secure offsets at the last hour. That's less than ideal. Right? You want to get these things done in advance. You got the certainty if you're a developer, but also you're getting better value for money. So that's one of the things that we're taking some inspiration from with the BCT and trying to figure out, is that part of the solution for dealing with the supply and demand issue as well, but also the price.
Thank you.
That's where my question really goes.
Justin, we're at the afternoon tea break though. If that's all right, we might need just to leave it there and come back. We do have another session at 2:45 with government witnesses. I understand Mr. Elton and Ms. Dumazel will be here for that session as well. So if it's okay, we'll just go on a break now at 2:30. Well, whatever time it is. If I come back at 2:45, and I thank the government witnesses who won't be coming back at 2:45. Enjoy your Friday afternoon, and we'll be back.
Chair, if I may, just
Right, welcome back to what is our last session for today's hearing. So we'll just need to swear in the new witnesses that we have before us. So if we could start with, where are we? You, Ms. Greenway, if you could please state your name and position title and swear either an oath or an affirmation. Thank you.
Thanks, Ms. Freeman. My name's Felicity Greenway. I'm the Executive Director for State Policy and Strategic Advice in the Department of Planning, Industry and Environment. I'll take an oath today. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you. Mr. Gainsford.
Thank you, Chair. David Gainsford. I'm the Deputy Secretary, Assessments and System Practice at the Department of Planning, Industry and Environment, and I'll take an affirmation. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much. And joining us via WebEx today, we have Mr. David Witherden. Would you like to state your name and position title, please?
Yeah, hi. David Witherden, Chief Executive Officer, Local Land Services. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much. And finally, Mr. Brendan Cook.
Hi, Brendan Cook, Executive Director, Strategy and Policy for the Department of Regional New South Wales. I solemnly, sincerely and really declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much. Now, is there any additional opening statement to what we heard earlier today? Yes. Okay, Mr. Gainsford, go ahead.
Thank you, Chair. I would like to thank the committee for the invitation to appear before it and to give evidence to this inquiry. My division is responsible for the independent assessment of state significant development and state significant infrastructure projects under the Environmental Planning and Assessment Act 1979. Felicity's area is responsible for the planning policy settings relating to the biodiversity and the land management framework, including administration of the state environmental planning policy, vegetation in non-rural areas or the vegetation set. The department assesses a high volume of major projects every year. In 2020-21, 426 major projects were determined, facilitating a total of 88,901 jobs with a CIV of $38.6 billion. Each one of these projects is subject to a rigorous assessment process, which includes significant consideration of biodiversity impacts where these are likely to occur. The department issues requirements for proponents to examine biodiversity impacts as part of their development application, consults with the community and other government agencies on these impacts, works with proponents to reduce the impacts of their projects through avoidance and mitigation, and where necessary, requires biodiversity offsets through the conditions of consent for approved projects. The Biodiversity Conservation and Science Division of the department is one of the key government agencies that provides advice throughout the planning and assessment process, including providing recommendations to ensure that biodiversity impacts are avoided and mitigated where possible, and appropriately offset where this is required. The department considers BCS's advice in recommending the determination of projects and setting the conditions of the approval. The department has been utilising biodiversity offsets in consents going back over a decade. Prior to the introduction of the biodiversity offset scheme, the department negotiated offset arrangements with individual proponents on a case-by-case basis, but in accordance with the various previous policy frameworks on offsetting, such as the previous biobanking scheme. Regardless of the previous offset policy, conditions of consent relating to offsets were comprehensive in all approvals and typically include stringent performance criteria for the offsetting of each impacted species and community, a requirement for a biodiversity management plan to be approved by the department, a requirement for a conservation bond covering the cost of implementing the offsets, and a requirement for the offset lands to be secured in perpetuity. In 2016, the introduction of the biodiversity offset scheme brought in a single scientifically based, transparent method for assessing biodiversity impacts and a single offsets policy to be applied to all development. Compared to the previous system, the biodiversity offset scheme has facilitated increased repeatability, consistency and transparency of decision making around biodiversity offsetting and provides a framework for continuous review and improvement. Importantly, the scheme is based on the fundamental philosophy of avoid, mitigate and offset as a last resort. This philosophy informs the way that the department assesses biodiversity and works with proponents to reduce the impacts of their developments. Throughout the assessment process, the department encourages proponents to consider redesigning and reconfiguring their developments to either avoid biodiversity impacts entirely or mitigating the impacts significantly. However, this is not always possible with all projects. There will always be certain projects and types of development which are unable to be moved, often due to the location of the resource, such as wind energy projects which need to be located on windy ridgelines, or hydro energy projects which need to be located on flowing rivers. For these projects, there will inevitably be a certain level of residual biodiversity impact, even after all options to avoid and mitigate have been exhausted. Fundamentally, biodiversity offsets allow for these unavoidable residual biodiversity impacts to be compensated for by committing to improve biodiversity outcomes elsewhere in perpetuity. This does not mean that all biodiversity impacts are acceptable with some level of offsetting. Potential biodiversity offsetting is one of the considerations that a consent authority must consider when determining whether the impact of the project is acceptable. The scheme has also undergone a number of improvements since it was first introduced, with the planning and assessments and BCS working closely to continuously improve how the scheme interacts with the planning system. This includes changes which allowed the Australian Government to endorse the biodiversity offset scheme as part of the assessment bilateral agreement between New South Wales and the Commonwealth, significantly reducing red tape and duplication of assessment for major projects which require approval under both jurisdictions. However, there is still more work to do to ensure that the scheme delivers the best biodiversity outcomes possible on major projects. Planning and assessments and BCS are currently working to improve compliance and enforcement of the scheme so that offsets for approved projects are retired within an appropriate timeframe and any outstanding offsets are finalised as soon as possible. We are thankful to the many individuals and groups who have appeared before this inquiry already for their valuable input and can assure the committee that this information will be used to facilitate ongoing improvements to how the biodiversity offset scheme is implemented on major projects. We are happy to answer any questions that the committee may have.
Thank you very much. That's the end of opening statements. Great. We'll move to questions now from the opposition, Ms. Penny Sharp.
Thank you very much. Thanks for coming in today. And thank you for your submission. I have to say the flowcharts have actually been extremely helpful in terms of working out who decides what when. Look, my first question, it really is a bit of a follow-up from the last session. So I just wanted, the scheme, in your submission on page 14, you talk about the scheme providing opportunity for Aboriginal stakeholders and local Aboriginal land councils. Are you able to give us, I suppose, able to tell us how many agreements are in place with local Aboriginal land councils?
Biodiversity stewardship agreements? Look, I'd have to take that on notice. I don't know how many may exist to date, but I can add that there are a number of LALCs that we've been engaged with for a while now who are very interested in participating in the scheme on both sides of the market, both in terms of activating their land for development, but also using some of their land to supply credits they might need themselves or credits they could sell in the market. So that includes a couple of land councils in and around Sydney and some on the coast as well. So there's definitely active interest.
Yes.
But the other witnesses may wish to add to that.
And the second question to that is who supports the LALCs? Again, in the previous session we talked about the substantial upfront costs to actually get certified to be able to put your credits on the market. But I'm just sort of aware, obviously, the local Aboriginal land councils have significant land holdings throughout the state, so there's a massive opportunity there. Does the government provide support for them going through that process?
We've been working with individual LALCs and certainly providing support, and we're wanting to provide more support because there are a lot of opportunities there. So we've been doing it on a case-by-case basis, and we've actually been also working with our regional New South Wales counterparts on in terms of how we can do that. We've also included Crown lands in that process as well. So really trying to understand what the value biodiversity value is on the land, because it can be expensive for councils, louts, to be able to identify that. So I think we want to do more. I think also the approach that we're looking at in terms of trying to marry up the demand and supply side, we really see this as a really good opportunity to do more work to support Aboriginal land councils realise the economic and social development that they want on their lands, and also take advantage of the biodiversity given their knowledge.
And just to follow that, I suspect this is probably not a question for you, but I'll try and you'll tell me if it's not. I mean, the work that Crown Land, if you talked about Crown Lands being involved in that, I mean, there is obviously the massive backlog in terms of native title determinations. Perhaps an awareness also that there could be, that this sort of work could be included in that, I would have thought might generate a bit more interest. Thank you for that. I think it's probably to you, Mr. Gainsford, and we talked a little bit about this in the last session. My concern through all of the evidence that we've heard in relation to this is that there appears to be reports that are made that talk about biodiversity impact. There is advice sought from some parts of the department in relation to that, but essentially it's advice. There's no kind of veto on any of this. It's ultimately up to the decision maker on a particular development, no matter which pathway they come through, about whether they accept that the avoid and mitigate in particular is acceptable or not. Is that the case?
So, Ms Sharp, it is obviously a very comprehensive process that we follow, and perhaps through another question, I can go through the process that we follow.
Well, I've looked through the thing. Well, I wouldn't pretend to understand the process. I can read the flow chart and probably get a basic understanding of it. But look, the fundamental question for me is, and look, this is the biggest concern that we have that I have through this entire process, is that I think biodiversity offsetting is extremely important, and I think that there is a role for it. My concern is that whether the system that we've got in place is genuinely delivering no net loss. And I worry, and I'm going to get to probably Mr Cook and Mr Witherden in a minute, around the various different pathways that are at cross purposes in terms of actually protecting fundamentally biodiversity, which is what the scheme is about, leaving aside the need for development and all of those things. So my question, and so I'm just trying to understand, and Mr Field touched on this in his questioning last time, is that, at various points, so if it's a major project, it's the government that determines ultimately, and it's usually the minister. So we can go through the great process, but at the end of the day, if the minister decides that they don't have to do the offsets, they don't have to do the offsets. That's correct, isn't it?
So, I mean, maybe in answering that question, Ms Sharp, I mean, what I can say is that because it's a rigorous process and we do take the advice that comes through from both the experts and from our colleagues at BCS, we take that seriously, and I think there is a bit of perhaps a misnomer that the biodiversity offset scheme has led to an automatic approach to go towards offsetting rather than the avoid and mitigate. And I don't think there's any evidence of that.
Well, can I just say there's not any evidence that there's not? I mean, so the evidence that we've got is that we've got increasing numbers of developers looking to pay into the scheme, and that's been shown on questions of notice and evidence that we've had here. So far, no one's been able to show me or tell me, I understand you've taken on notice, it's not a criticism of you today, but, where is the bird's eye view that says we want no net biodiversity loss, and through this scheme, this is an amount that's been cleared. This is the amount that we've said no to, that's actually still in place as a result of, there's been a DA on it and we've said no, because I've got to tell you, all of the evidence suggests, good planners at councils, various different landowners are saying, well, we're not seeing any real red flags, whether you want to use that terminology. What the mitigation methods, how much mitigation's really been there. I mean, it's obvious if it's inland rail, if they've taken a different path, terrific. I just think that there's a lack of, in terms of having confidence that it's not just simply becoming pay into the scheme, I think there's a lack of data coming from the government, from the department, that gives us that assurance. Like, you keep telling us that. All of the evidence, people are just saying the first thing that developers are looking for, and this is understandable, what's the easiest, quickest way I can get an approval and deal with my offset obligations? And if it's just paying in, that's what, of course, that's what they're going to do. I'm not blaming them for that, but of course they're going to do.
I might just address that, if I may, Ms Sharp, the paying into the scheme. So, I mean, this is an option once a development proponent has received a development consent and it specifies the offset obligation that they may be required to acquit. They can either do that through the market or they can do it by paying into the Biodiversity Conservation Fund. Either way, that offset obligation has to be fulfilled. If it's transferred to us, we're bound. So I think...
Look, I accept that. Yep. I know that you sort of rail against just suggesting that there's this magic fund and that somehow there's not being offsets. Yeah. Our concern, though, of course, is the length of time that's happening, that some are still not retired after a very, very long period of time. You know, it's accepting that it's a new scheme and you're trying to make it faster, but there's still those gaps where it really essentially is for the developer. They've paid in, they've cleared, they've built, off they go. BCT's got to fix the mess or find the credits that need to be, no matter how long that takes and whether they're available. I mean, that's our concern. Well, my concern is just, how do we have confidence that there is no net loss? Because I don't think that we can show that.
So no net loss is per project. So in the biodiversity development assessment reports, the proponent has to demonstrate what they're going to avoid and minimise and then offset. Now, certainly one of the things that we're doing is trying to work more at the start with major projects, and so where we understand a proponent in a major project, we try and work up front and to kind of help them navigate the scheme in terms of thinking, well, really, you could avoid a lot more if you looked at these different areas. And so we're trying to provide more of that service aspect before we get to the kind of regulatory aspect. And I think that's going to help. What we don't do is actually, and I know I've taken this on notice and I'll need to go away and have a think about it. We don't, all that work we do where we advise at that point, we're not documenting then what we're actually avoiding now. And but it does make a difference because a proponent's also looking to reduce their costs, so the more that they can avoid and then actually have their footprint on a part that doesn't have high value biodiversity, and that's the expertise that we provide to our planning colleagues as well. But there is something about how we actually document that part of it.
And I might go, I'm not sure whether it's to Mr Cook or Mr Witherden. The interaction with the LLS Act and particularly on those edges of rural land and peri-urban land, it was raised a lot by local councils this morning. And I'm hoping you're the right people who can answer this. And there were some fairly serious allegations about essentially land being cleared, whether it's under the boundary codes or whether it's under the land management codes, that's not for agricultural purposes, but is actually essentially it's done, and then 12 months later there's a DA that goes in for development, which means that people have avoided having to deal with the BOS scheme. Could you let us know what LLS, A, is LLS aware of this? B, what action are you monitoring it? What action are you taking to deal with it?
Yeah, sure. Happy to talk to that. In terms of Part 5A of the Local Land Services Act applies to rural regulated land, and there's a series of risk-based approval pathways through that. I mean, you start from at the lowest risk level, what are in terms of allowable activities that are allowed without any approvals. Then there's notification pathways, certification pathways, which provide or require a whole lot of analysis and then approval by us. And then ultimately, when none of those are available, then there's access through the native vegetation panel. But in terms
just to be clear, we've been told that there's only ever been one approval through that process, through the native vegetation panel. Is that correct?
Yeah, that's correct. So I think...
So it's not really it's not an active and important part of the system, given how few approvals have happened through there.
Certainly been a significant number of inquiries. There's been the order of about 120 inquiries, and there are a number of reasons why that has only led to one approval. But to sort of go back to your question around, I guess, in those peri-urban areas, what people are seeing there, my, I guess, understanding would be that the sort of activities you're talking about there would either be allowable activities permitted under the code, but they're quite small in terms of what you can do there, in terms of clearing for fence lines and so on, or maybe notification pathways there. Not aware of any specific issues, and if there are issues in terms of a compliance sense, the compliance component of the framework sits with EES, and they would be the appropriate ones to do that. And I know there are certainly avenues in terms of the analysis they do, the early change monitoring with satellite data and so on. But the requirements of Part 5A, I think, are quite clear. And yeah, we certainly, we're there to provide advice, guide landholders through that. But we don't have a compliance role.
Okay, I think I've misunderstood then. So this morning we had evidence from councils who were talking about clearing that was occurring on rural land, obviously close to, basically being cleared for development, but it's the justification for the clearing is saying because it's for agricultural purposes, probably under all of those allowable and even notifiable issues. So that it's being cleared, it becomes to light that it's not being cleared for agricultural purposes. It's basically being cleared so that in 12 months' time, 18 months' time, there's then development going on to it, and they've been able to avoid that. So you're saying that LLS has really no role in that? If people are clearing under, is it complaints based? You need to wait for someone to say, hey, my neighbour has cleared, they say that they're clearing for a shed or for whatever it is, but that's not what they're doing. What triggers, what are the triggers for LLS involvement in that?
Yeah, triggers would certainly be landholders reaching out to us for advice around that to help them navigate through the requirements of the code. So we could certainly give them advice as to whether it's an allowable activity, whether it's a notification pathway, or whether it requires an approval. But they could certainly, of their own volition, undertake allowable activities. We wouldn't know about that. If they overreached in terms of that, well, then it's a compliance issue that would need to be dealt with by EES, and the appropriate thing would certainly be.
Okay, and who reports that? So if a neighbour goes to report this issue, so that's come to their attention and they're concerned about it, or local government, for example, is concerned about it, they report to EES. Is that right?
So,
and it's a land clearing compliance issue. I'm confused because local government this morning said they'd raised these issues with their local LLS people, and there seemed to be some discussion at that level, but you're saying that that's the wrong pathway. I may have misunderstood, I accept it's Friday afternoon and it's been a long day.
Well, my expectation, Michelle, would be that they would raise that issue through the environment line would be the appropriate way to do that. Now, they may well have contacted LLS officers, and that's highly likely at a local scale for advice around that as to whether we've given approvals or so on. But I'm not aware of any specific instances in relation to that.
Okay. Well, then, Mr. Dumazel, I'll ask. Sorry.
Mr.
Dumazel, so my question then is, and you might have to take it on notice, is just sort of how many, whether this is an issue that people are making, actually making complaints to and seeking compliance of. As I said, several of the councils raised it today. It was not just a one-off, this happens. They're basically, there were sort of two allegations essentially being made. One is that people, they're clearing and they're saying it's for agricultural purposes, but it's clearly not for agricultural purposes. And the next thing you know, it's actually for development to essentially avoid triggering all of the BOS. The other issue that people said was that in terms of illegal land clearing, in some cases, some large landholders are just basically happy to do the illegal land clearing and pay the fine because it's cheaper than going through the process of actually dealing with biodiversity offsetting. And I know it's a little bit of a strange question, but if you can come back to us on notice about, whether in terms of the complaints, whether that's something you're aware of. It just seems to be quite I accept it's a fairly boutique loophole, but again, several of the councils have raised people genuinely doing this because they don't want to have to go through the biodiversity offsetting scheme.
Certainly I will take that on notice and where there is a complaint that's made, we do investigate that and make sure. And Mr. Witherden outlined the early change monitoring, which has made a big difference for us in terms of where, because we can more rapidly see where there might be clearing.
Is that still complaints based though? Do you still need a complaints trigger to do that, or
no.
do you? Or, no. So you can just. So when you're looking at,
we look at the satellite.
Okay.
We look at the satellite information, and our processes are getting a lot better. So it's like, it could be within a week, and we're able to actually then contact the landholder to say, hey, what's happening here. So that process has been improving, and we work quite closely with local land services on that. The other aspect too, I think, is around. We are looking. This is one of the reasons we're putting in place the help desk for people to contact us direct around the scheme. I think there is still a lot that we need to do in terms of supporting landholders to understand the pathways into the scheme, and I think the work that we're trying to do to improve. Particularly information west of the divide as well to landholders around their options. I think that's going to be really important. So, but I'll go back, and I know my team's is looking at all the information that's being provided through this. So we'll go back and have a listen.
Thank you. We've now got questions from Mr. Justin Field, who is remote. Yep.
Thank you, Chair. And I wanted to follow on from Ms. Sharp's line of questioning, if I could, Mr. Witherden, and good to see you here in a different context. And I note just the single approval under the rural area determinations through the native vegetation panel. And I'm just using that, I guess, as an example to understand how this in practice works. Because for that one example, and it's on the register, and we can see the notice of determination, that particular impacted community that was expected to have to be offset, got a very, very long name, I won't read it here, but 3 ecosystem credits were required to be retired. And when you read the determination, it says the panel has decided, in accordance with the Act, to reduce the number of species credits that would otherwise be required to be retired from 3 to 0. And it did provide a couple of dot points for its justification there. What's the point of having that provision of the Act to require rural land clearing to fulfil biodiversity offset obligations if the panel can just simply write them off?
Yeah. Okay. Good to see you again, too, Mr. Field. Look, I think we've sort of got a sample size of 1 to deal with here in terms of approvals, and I'd have to say it's, even in terms of that, it wouldn't be representative. It's only 0.32 of a hectare, so we're sort of talking 3,000 square metres. It was sort of in southwestern New South Wales to do with a centre pivot irrigation. I would, certainly.
But it was Liverpool Plains, wasn't it?
I'll need to...
It's the Liverpool Plains we're talking about here. And I don't know...
Okay, you're right. I've just got my information across there, but it was certainly only, 3,200 square metres, which is, in terms of any centre pivot, any farming operation is minuscule. It's sort of like a couple of quarter-acre blocks. So I think it is, certainly there's the ability for the panel to do that under the Act, but I would think, to be very much the exception rather than rule. And part of the legislative requirement is for the determination to sort of give due consideration to ecologically sustainable development. So, I won't sort of judge what the panel have done here. I'll leave that for them to answer, but, I think it is a reasonable provision.
That's the only determination that we've got. Do we know how many other applications have formally been made or are under consideration at the moment?
Look, in terms of, I think we've had 120 inquiries. There's been 4 pre-lodgement meetings. They have resulted in 3 site inspections by LLS staff. There's been 4 biodiversity, or the BDAR, biodiversity assessment reports prepared, and a further 3 BAM, the biodiversity assessment method, sort of those desktop reports done. But that is as far as it's gone at this stage. My advice is, that potentially, there may be somewhere in sort of the order of about 8 to 10 looming. But yeah, it certainly hasn't been a big take up, and I think for a wide range of reasons.
We might come to the reasons in a minute, but can you just confirm the BDARs that are done and the BAM assessment reports that are done, are they paid for and completed by consultants engaged by the landholders, or does LLS get involved in that process?
No, they're by consultants on behalf of the landholders. Yeah.
Paid for by the landholders.
Paid for by the landholders. Yeah.
Now, some might consider that one of the reasons there's not been a lot of uptake here is that substantial amounts of clearing are possible under the code. Obviously, we've seen now multiple reports, the woody vegetation, land cover, tree cover reports have shown that substantial clearing has occurred. Much of it, I think as much as 60% in the last couple of years, has been described as unexplained. Are there any concerns within government that clearing that should otherwise have been done under section Part 5, under Part 5A, are just simply being done under the claim of the code and we're just missing it?
Well, certainly not that I'm aware of, and maybe a question that's better addressed to my colleagues there in EES, but certainly, what we're seeing in terms of the compliance data, the early change monitoring data, and that sort of flowing through to prosecutions isn't evidence of that. I think, the unexplained clearing, is a bit of a misnomer. As you'd be well aware, the NRC recommended as part of sort of that overall trigger review, one of the key actions of that was really to work through that and, in collaboration with EES, we're really starting to break that down. And my expectation in the future is we'll have a much clearer understanding of that, because, when we've got the ability with satellite data in sort of almost real time in terms of this early change monitoring, we know exactly what's happening and where it's happening, and where it is being done illegally, that should absolutely lead to compliance actions.
You know, Mr. Withers, I'd be in favour of all of those NRC recommendations being implemented in full, but that's a different story.
Yeah.
Chair, I'm happy to pass on. I have some more regarding mine offsets, but I'm happy to come back to it if you prefer to break it up.
Yeah, okay. Let's do another round. Or I'll just got a few questions as well. Mr. Elton, you mentioned in your opening statement that the government has indicated a $108 billion of kind of major projects in the kind of pipeline. You're talking about the need to get more supply and offer incentives. Could you? I think we really need to kind of nut that out a bit more, because there's a big issue, and we're kind of also grappling with what to do there. So what thoughts have the BCT and the department had in that regard? Can you share any with us?
I might refer that to my colleague, because it was actually Mr. Knudsen who made that.
Oh, okay. Sorry. Yes, Ms. Dumason.
So what we're looking at is trying to understand the pipeline of projects, and so that then to try and better marry the demand and supply side. So we know what major projects are in the pipeline over the coming years. So we've started to do some investigation into that, and that's where that figure came from, our initial analysis. And then from that, then looking to see if we know if we're thinking about the avoid, minimise and offset regime, and then we know where those projects are going to happen, then we can start thinking about where we should be targeting additional communication with landholders in those areas to generate supply. So then, for example, and this is where Mr. Elton might want to make a comment, is that for a landholder to enter into a stewardship agreement, they'll have to do their own assessments of it, and then as part of entering the agreement, they need a total fund deposit that'll then support the management actions over the years. And so if we can then make sure that the demand is there for that process, then it means...
Can I just check on that? So we heard this process. Can I just check whether anything under consideration, is there anything under consideration to reduce the cost for landholders that are having to do their assessments? That's what I think Ms. Sharp was referring to as well, in terms of illegal clearing. That can be, significant thousands of dollars to undertake these assessments. That is a big barrier to some people who have blocks of land.
I can offer something there. I'll just add to something Ms. Dimmesell said as well. I think we are looking at releasing more information. The government is looking at releasing more information into the market about the pipeline of demand for biodiversity credits, and that will help landholders and the BCT respond to that, so that we can get proactive in terms of inducing supply. In terms of the assistance issue, the BCT already has a financial assistance policy available for people that might be interested in establishing BSAs to sell credits to us. It is true that there are those upfront assessment costs, and then the landholder doesn't realise an income until later. So we have an assistance policy in place where we can finance the upfront assessment costs and then recover that from the landholder when they've been able to sell their credits. And we've also witnessed many examples where developers are providing that kind of assistance to landholders as well, because they have a vested interest in finding the offsets that they need, and so and ARTC is a good example where they're supporting landholders to participate in the scheme. So that's a couple of things that we're doing in that regard.
The financial incentive one that you're referring to, that the BCT provides, what does that look like in practice? How easy is that for people to find out about and apply for? What are the...
look, we haven't had much interest in it to date, I'll concede, and we have promoted that on our website. We're trying to promote it to people. What it involves is basically that we would finance the upfront assessment costs with an interest-free loan, effectively. It's not a loan, but it's financial assistance. And then we do our own due diligence to make sure that that's a viable proposition in terms of the landholder being likely to be able to sell credits. And if that's viable, then we would offer them that assistance, and then we have a contractual arrangement where they repay it to us once they've been able to sell their credits. So I would encourage anyone out there that's interested in getting into this world of supplying biodiversity credits to consider that as an option.
And can I just add to that?
Yeah.
At the back of our submission, there's a part of the transport submission, and in that, it's got a section that says what happens if I respond to an expression of interest. They've done some really good work about that upfront costs, and Ms Dalton was referring to ARTC, and we're trying to encourage major proponents to really think about how they can engage with local landholders early on and to support that process, because that takes the risk out for the landholders, and there's an incentive there for the proponent, because it's a way of then securing the offsets that they need.
And I can add to that's working. I mean, we have already signed several BSAs with landholders who are supplying credits to ARTC, for example, and there are several more applications in progress. Yeah.
Can I ask, there's no way within the scheme to measure the kind of cumulative impacts of multiple developments on threatened species, is there?
No, we get, because it's all up. It's all up front. So it's built in the assessment method. So
is it? So, for example, if you had 24,000 hectares of critically endangered ecological community left, and then there's a development that clears 800, another development that clears 1,200, another, like, do those credits then become somehow more expensive, or does the calculator calculate how much is left in terms of the cumulative impact?
I'll have to take that on notice because it's the calculator builds into the fact if it is the threatened aspect of the species, so critically endangered or endangered. So that's built in to the formula. It's reviewed regularly, so we update that based on whether there's been a determination as well. And then so we do need to do some work, and we are kind of looking at what our overall monitoring and evaluation framework to see whether it is robust based on what's required between the actual reports and the individual projects versus then the biodiversity indicator program, which then kind of assesses loss overall in terms of the IBRA regions. So, yeah.
Ms. Farnham, I might add to that you know, as we've discussed before, on average, biodiversity stewardship agreements are offsetting development at a ratio typically of 4 to 1, and so where those critically endangered or endangered ecosystems are being protected under biodiversity stewardship agreements, those agreements are in perpetuity, they're permanent, that land can never be cleared or used for development in the future. So I just wanted to add that point.
Yeah, so I just wanted to use the clearing, for example, with mines that are happening in the Hunter Valley, because I think that's where, you know, a lot of the, well, it's also happening in Western Sydney in terms of cumulative impact and the loss of Cumberland Plain woodland. But there is, for example, there is a forest community called Central Hunter Valley Eucalypt Forest and Woodland. And Mr Gainsford, is your department responsible for assessing those mine applications and the offsets there?
Yes, we are. Yes, yes.
So the offsets for those mines, most of them, some of what we have heard, some of the evidence for this inquiry has been that, is it a fact that some of those offsets are being used, some of the offsets are actually rehabilitation offsets. So the offsets for the clearing of that mine, and potentially sometimes the same mine, will be factored in by the rehabilitation that might occur 40 years later. Is that what's happening?
In certain instances, yes, rehabilitation can be a component of the offset component of the project, but perhaps I might ask Ms Greenway to actually explain, I guess, the methodology around mine rehabilitation, if that's okay.
Yes, thanks, Mr Gainsford. Yes, it is correct that mine rehabilitation can form a component of the offset requirement, but it is generally a small component, and I can't think of a circumstance where it's the whole component of a offset. It's only available to major mining projects, and this has only been since 2014 with the introduction of the then Framework for Biodiversity Assessment. So it does allow proponents to receive upfront credits for rehabilitation subject to meeting strict completion criteria in accordance with a rehabilitation management plan. And we take advice from our colleagues in BCS on those management plans and indeed the offsets that are proposed. I would say that it isn't. I think it isn't taken up by all, because the credits yielded by mine rehabilitation, ecological mine rehabilitation, is less than what you would yield from a stewardship site, and that's to recognise, I guess, the baseline state of the land. And
yeah, sorry, continue.
There's also, a degree of effort involved as well in setting aside and storing, saving topsoil, collecting seeds, establishing nurseries and so forth. So, it's.
So why are certain companies choosing to rehabilitate their mines as part of their offset obligations then? Is it because there's no offsets anywhere else that they can't?
I think it's an opportunity, but not all take it up to it's an opportunity, I guess you could say, to have improve a biodiversity outcome at the end of the mine life.
So maybe if I could illustrate just one example that's been provided to myself in preparation for this. So the Wilpinjong coal mine, which is up near Mudgee, is an example of where rehabilitation is part of the offset strategy, and there was a specific targeting of providing habitat for the region honeyeater, and so there was identified specific vegetation communities that could be incorporated into that rehabilitation. And similarly, the rehabilitation also has some very good landscape values that will assist with the connectivity between two other very high biodiversity areas nearby, being the Munghorn Gap Nature Reserve and the Goulburn River National Park. So I think picking up on what Ms Greenway was saying there, it's used sparingly, and where it is used, there's specific biodiversity outcomes that are driving, I guess, the reasons behind incorporating that into the offsets.
So is it the case that some mines can choose to offset the clearing through the future rehabilitation of that same mine? Is that now a
proportion? That's correct. Yes.
And is there a rehabilitation policy within the department that's still being worked on? Is that, and I'm not sure if that's you, Mr Gainsford, or
we're in the process of finalising the ancillary rules for this. We've recently gone out to consultation, and we're hoping to finalise that in the new year.
So clearing, for example, critically endangered, say habitat for the critically endangered regent honeyeater, under this policy that's currently being consulted on, could that be so 40 years down the track, because some mines have a 40-year lifespan? Is that not the case? So the rehabilitation of that land that's cleared now for the critically endangered region honeyeater could be little seedlings planted in 40 years' time. Could that be approved under this system?
So there's a couple of things in that. Number one, it's can only be a portion of it. What we would like to see is that
But there's a cumulative impact thing again, though, isn't there? Because if it's a portion of the habitat for critically endangered region honeyeater,
we need to think about that within the overall.
But do you think about how do you think about it? That was a question I asked earlier, I think, and that's what I'm getting to. So how do you? We need to think about it. Is okay to say. But
so that's why we've got
what's
the rules.
The process?
So that's why we're developing the rule base, and so we've been working with our scientists to see what makes sense.
For cumulative impact, is that what you mean?
Or if the rehabilitation is used as a component of the offsetting. I just wanted to say that at the end of the life of a mine, while there is currently a requirement for, to making sure that it's a safe and stable environment, we would like to see that then is rehabilitated in a way that is scientifically robust from an environmental perspective. So the ancillary rules are being finalised at the moment, and that it takes into account the requirements that would be needed. It's a portion of it, and certainly when then we would be assessing it if it was to come through an environmental impact statement and it's part of a biodiversity assessment report, then we would be considering the totality of the approach.
Perhaps I could add, Chair, that cumulative impacts are a component of any environmental impact statement, and so part of that assessment of cumulative impacts is to look at other developments that might have impacts that accumulate. So our expectation would be, if there was that circumstance that I guess you're hypothesising there, that we would have information within the EIS to consider as part of that assessment.
So thank you for clarifying that. So that would mean that if a certain percentage of this critically endangered community in this area has been cleared from other projects, that becomes part of the consideration? Is that
both? I guess the accumulation of previous impacts, but probably more importantly, other planned projects at the time.
And if I may, Ms Freeman, the department on 1 July actually released a cumulative impact assessment technical guide under the major projects reform work that we have been working on, which steps through in detail a methodology for assessing cumulative impacts for major projects, in really step-by-step identifying what the other relevant projects are, whether it's cumulative impacts of where you're just considering one factor, or it's cumulative impacts of multiple factors. For example, cumulative biodiversity impacts along with cumulative air quality impacts, for instance. And so the technical guide does set out step by step that process.
Thank you. I'll just check with you, Mr. Justin Field. Do you have some more questions on this issue before I go back to Ms. Sharp?
A slight variation, but yes, I did. And Mr. Gainsford, it might be for you or redirect. I asked some questions through the House recently about coal mine offsets and received an answer back that I was going to seek some clarification on. It indicated in the answer that of the 41 coal projects approved in the past decade, 1 did not require offsets, 14 have not yet triggered the requirement for offsets, and so of the remaining ones, 17 have substantially finalised in perpetuity security arrangements. I was wondering if you could provide on notice the 17, and could you give us an indication of what substantially finalised means?
Yeah, thank you, Mr. Field. Yes, I'm happy to provide some further details on notice. Substantially finalised in this circumstance means that, for all intents and purposes, the offsets have been secured and they've been completed. However, because of the nature of a number of these individual cases, there is some complexity to the complete finalisation, and I'll give you a couple of examples. One is where, for example, a mining project has a number of modifications that are associated with that mining project. So they may well be for the actual consent, the original consent for that mine, plus a series of modifications that all of those offsets have been completed, but there might be one outstanding modification that is currently going through the system, and therefore, and it has a small level of biodiversity impacts that haven't been completed. The other circumstance that I guess motivated us in using that terminology was the finalisation of legal arrangements. So particularly under the previous schemes, prior to the biodiversity offset scheme, there was some flexibility in establishing those conservation bonds and agreements. And so different applicants have used different methodologies, and in some cases there are quite complex legal arrangements to secure those offsets in perpetuity, such as positive covenants and other types of legal arrangements. So again, that reflects circumstances where some of those mines have not entirely, I guess I would describe it as dotting the I's and crossing the T's. But for all intents and purposes, there are land-based offsets, there are conservation bonds that are in place. So you know, that's why the term substantially finalised has been used.
Would it be possible, Mr. Gaines, for when you provide that additional information on which of the 17 are substantially finalised, that an explanation is provided for each of those?
We can, Mr. Field. What I would say is, because there are literally scores and if not hundreds of modifications across all of these projects, it is quite a complex environment. But yes, happy to take it on notice and to try and provide some more clarity.
We're talking about 17. I appreciate there might be a lot of complexity in each of those, but you know, an explanation as quick as what you just said then for each would be useful, and a bit of an indication, if you could, for what is the process to conclude these, because it's all well and good for you to say that, and I'll absolutely take your at your word on that and the use of the term substantially finalised. But in terms of meeting an obligation, some of these approvals are from a long time ago. You know, they haven't been met. I'm just trying to understand how these get concluded. For the 9 that remain, where it says 9 have land set aside which is being approved in accordance with individual BMPs, further work is underway to secure the land in perpetuity. Could you provide on notice again which of the 9, which projects are included in that 9, and whether or not they are on track or behind in the delivery of the work that's required under the BMPs? And can I ask you a question, and it might come across as well to Mr. Elton, I think. I've heard that some of these offset obligations have not been secured because there are disagreements about whether or not the credits that are required to be secured through these sites are available on the site. So they're not adequate in terms of the biodiversity outcomes that were expected on those sites. Can you speak to that?
Perhaps if I could just answer the first part of the question, Mr. Field. So yes, happy to take that on notice. Again, with regard to these projects that we've identified here, there are biodiversity management plans that are in place for all of those projects. I am also, though, I guess, I would like to see further progress made. I don't think that we've been as timely as we should be, and you know, I've asked my team to work with biodiversity conservation to make sure that we don't have these long delays. A lot of the delays are partly as a result of some of those complex legal arrangements that I was mentioning before in finalising the offsets for these projects. Some of them are around transition, and I think that's what your second part of the question is getting to, which I'll refer to Mr. Elton. But at the same time, that there are those reasons for why extensions and why some of the offsets haven't been finalised and have taken so long. I'm also not satisfied that, and I think more work needs to be done here, and certainly I'm committed to making sure that we can try and finalise as many of these as quickly as possible. But I might refer the rest of the question to Mr. Elton.
Yes, thank you. Yeah, look, Mr. Field, in relation to the matters you're referring to, I think generally you're referring to offsets that are or have been or are still being established through offset conservation agreements rather than through biodiversity stewardship agreements. And in fact, I answered a number of questions on this matter at the previous koala inquiry as well. Our role is to essentially make sure that there is rigour in entering into those conservation agreements, and we do that. We conduct due diligence to make sure that you know, everything is correct. And there have been examples where we've had to seek additional information or revised mapping in some cases, and we're very rigorous in ensuring that we do not enter into a conservation agreement until we're satisfied that all the details are accurate in terms of the mapping and the conditions of the agreement and so on and so forth.
So how many coal mine projects would you be in this sort of situation with, where you were currently considering entering into a conservation agreement, but you're still doing the work to work out whether or not they're adequate?
There are some in relation to the Whitehaven Coal Maules Creek mine that I'm aware of. We've settled a number of the conservation agreements for that project, and there are still some to be finished. So that's one that I am aware of. I'm not aware of any other significant areas of concern for other mining projects, but I could take that on notice and confirm that.
And just one more, Chair, if I could.
Yep.
James, could this suggest to me, the language in this answer, of the 41 projects approved in the past decade, and you've outlined the 4 points there, that then means, if I'm correct, that not one of the coal projects approved in the last decade in New South Wales has had their biodiversity offset obligation secured.
So, no, I don't agree with that, Mr. Field. There are land-based offsets for all projects that are actually in place, and conservation bonds that have been required under the conditions of approval. So we monitor compliance with those requirements in the conditions of approval, and so I'm confident that that's not the case, and that in most cases the mining projects are following their conditions of approval and complying.
Okay, thank you. Ms Sharp. Hopefully these aren't too long. I actually want to go to the transport, and I'm not sure, Mr Dumazel, whether you're going to be able to answer this. In part of your submission, and you've pointed to it a couple of times, on page 6 of Transport for New South Wales's submission, there's some useful information in there, but I do want to actually unpack the issue. So the second last paragraph on page 6, they say, since 2011, Transport for New South Wales has purchased more than $77 million worth of biodiversity and biobanking credits, accepting that's obviously under the current and the old scheme. They've expended more than $6 million to establish agreements over land owned by Transport for New South Wales. Great. They've given $5.8 million to Mr Elton's organisation, and Sydney Metro has purchased a further $12 million in biobanking credits. and then they give us some information de-identified in terms of project by project about what that's cost. Are you able to actually tell the committee how much, it's not dissimilar to Mr Field's question, how many of those have actually been fully accounted for and retired?
I'll have to take that on notice.
Could you do, yeah, I know, I realise it's not your, but if you could do that and unpack that, I mean, there's a lot of numbers there, but not a lot of information in terms of what's going on, and you'd be aware that there were media reports about previous offsets that, you know, decades before they've actually been retired, and some still are not. Thank you for that. And my final question for today is, and I'm not sure, I think it might be Mr Gayfus and it's probably Mr Dumazel, Warragamba Dam. Warragamba Dam assessment, and obviously it's going through the EIS process now. You would be aware there's been a lot of discussion about biodiversity offsetting, and New South Wales Water's chosen to take in their EIS an approach that says that, you know, temporary inundation, which of course has major differences with if it was considered permanent inundation, and how is that, can you take me through, I mean, I don't really want you to go into the details of, you know, arguing the toss over the inundation or not, but I'm just interested in the pathway for advice and resolving that matter, as an example, you know, through the planning process. Mr Gaines, are you able to take me through that?
Ms Sharp, with regard to the actual impacts and offsets, is that what you're talking about?
Yes.
Okay, so with regard to the impacts and offsets, so obviously the environmental impacts statement is on exhibition at the moment. That has some very detailed biodiversity assessment, biodiversity development assessment reports.
Depending on who you ask, yes.
Depending on who you ask, yeah, sure. And so obviously now being on exhibition, this is an opportunity for us to seek further advice from our colleagues as part of the review of that documentation. We will obviously expect to receive a number of submissions that will come through as part of that process. Those submissions and the advice that we receive, we will obviously then ask Water New South Wales to respond to.
Yep, through the iterative process, yep.
That's right. And then we would expect a response to submissions that will need to address those issues, and then it goes into our assessment report. At the assessment report stage, we'll typically seek further advice as we're finalising that assessment. On occasion, we will actually get our own expert technical advice to assist us with those assessments. So it is a quite a substantial and iterative process.
Yes. And so, I mean, given that there is disagreement, and I'm not asking you to comment, you know, specific. I'm not asking you to tell me what you'll go through that process. How is, you know, there's a difference of view about temporary versus permanent, for example. How is that? Who makes the final determination on that?
So, I mean, what I can talk to, so ultimately the Minister...
Sorry, I'm probably being too specific about a specific project, but I'm just trying to unpack that sort of those decision points and where the advice comes in and who's the final arbiter of, because it's a big decision.
It is, and ultimately the Minister for Planning is the consent authority in this circumstance. So ultimately the decision is with the Minister. In terms of the temporary impact versus permanent impact issue, so we have acknowledged that this is, and we've been working with our colleagues and also Water New South Wales to, I guess, make sure that the assessment has documented a conservative approach and making sure that the impacts themselves are fully ventilated through the assessment process. We acknowledge, though, that the temporary nature of some of the impacts is different to the usual assessment.
Around the bushes that the region honey eaters are in, it's not temporary.
Yes, so obviously we need to take technical advice on those matters at the end of the day. So Water New South Wales has presented some evidence and some advice from their technical experts, and we'll continue to seek expert advice from others.
Thank you. I might just jump in with a few more just in the last 5 minutes. So I just hearing about over the last few days or the 3 days of hearings so far about the fact that it just seems to be easier for proponents to be able to offset by putting money into by paying money basically to offset. So this is increasing in your view, Mr. Elton. Is that the case, that you're more money is being paid to offset as opposed to finding offsets? Is that a general trend?
Look, I don't necessarily see that, and Ms. Demiselle might add to my remarks. The trend that we're seeing is that it's typically developers with relatively small offset obligations that may not yet be readily available in the market that are paying into our fund. So we're receiving a lot of small payments. And, you know, one of the advantages of
I think we heard that, for example, up and down the coast, so coastal areas, yeah? Instead of major projects.
Yeah, so I think we have had 3 or 4 larger payments associated with major projects, but the vast majority, I think, at this stage of major project proponents are still tending to look to source credits directly in the market rather than through the BCT. But I might, Ms. Demiselle might wish to add to that.
I don't have I can't recall the correct percentages, but I think it's something like 90% of approximately 90% of the offsets are done outside of the of that kind of payment into the fund direct.
93%.
Thanks.
Have you provided that within the government's submission? Do you know those statistics? And if not, could
I'm happy to put that
provided on notice. Yeah, thank you.
So 93% is because you know how they've got the option of creating their own site, ask the neighbour, have a look at the registers, or pay straight into the fund. So.
That's fine.
Yes,
yeah, that's fine. We can just get that on notice. And I just wanted just to bring to your attention, Mr. Elton, some of the recommendations from some of the councils that have appeared before us. And I will just clarify as well that they have said one council has said that they found the support team, and it was a biodiversity offset scheme support team. So that's probably within the department, is it? The support team, to be at all times extremely professional, helpful and pleasure to deal with, but that it's abundantly clear that they're understaffed and they have an enormous backlog of work. So we keep getting urged to make recommendations about further resources being allocated to both the BOS support team and the BCT. But one of the other recommendations is for resources to be to communicate biodiversity offset scheme related ledge to the public. So this council has said they would like from the BCT to prepare a user-friendly downloadable guide for proponents written in plain English. Do you have it? I thought you would have something like that.
We certainly have a lot of resources in relation to our role, which is more to do with landholders and being able to enter into biodiversity stewardship agreements. We don't have so much of a direct role with proponents.
We did get that feedback that it's very complicated. That was a big bit of feedback.
And that's why we're just in the process of getting a hotline in place for proponents, councils, accredited assessors. We've got, at the moment, people can contact us around the actual assessment method, but not on the scheme overall.
Okay.
And I think because there is so much confusion, you know, we want people to contact us.
That's great. So a hotline's one thing. This will be my final question. We've got 1 minute left. So, but the complexity of the scheme. So, is anything being done within the department to look at why it is so complex and to offer solutions, offer reform ideas to simplify the whole scheme?
I think there's certainly more we can do to support landholders in this space, and we need to simplify. While assessing biodiversity is a complex matter, there are things that we can do to actually make it simple for people to engage in the scheme, and I acknowledge that we've got a lot more work to do in that area. And I think having Mr. Mike Murdoch, who's our external monitor, kind of oversee our whole program. And look, honestly, we have been pouring through all the submissions coming through. We've got the audit office coming in. We're already working with the audit office. We're really trying to think of all the different things that we can do to improve the scheme, because the foundations of the scheme, having a reliable, repeatable method, transparent, that the public can see what the impact of these projects are, clearly see that is really phenomenal. And we want to be able to now make sure that the scheme is simple and easy for everybody to engage in it.
Thank you, Ms Dumazel. That's a good place to finish on. So thank you so much for appearing before today. Of course, you did take quite a bit on notice. The Secretariat will get in touch with you about that and with any supplementary questions that members may have. And of course, you'll have 21 days, maybe a bit longer at Christmas period, actually. We will deal with that if we need to get those back. So thank you very much for appearing. That is the end of our hearing, and everybody have a lovely break. We won't see you probably until the new year.